Ma Suit.
Yes. Huh? Yesterday is 22 and you call it old.
24, my lords.
Ah.
The respondent, execution has been filed by the respondent before the executing court or Sakleshpura, my lords.
Hmm.
Challenging the jurisdiction, they have filed an application, specially they have filed an application. Application came to be rejected. On that, they have filed writ
I
petition,
told you.
my lords.
Yes.
My suit for declaration injunction. Defense evidence is going on, it is for cross-examination. Filed
Suit
applica-
ಎಷ್ಟನೇ ಇಸಿದು ಒಂದು ನಿಮಿಷ ಎಷ್ಟನೇ ಇಸಿ ಸೂಟು ತಗೊಳ್ಳಿ ಎಸ್
that application for impleading,
ಅವ್ರು ಮಾಡ್ತಿದಾರಲ್ವಾ ಹ್ಮ್
filed application for impleading the who was in possession is purchaser. That application has been rejected. Matter is of defense evidence. Notice already ಆಗಿದೆ. Further orders ಆಗಬೇಕು.
ಎಷ್ಟನೇ ಇಸಿದು
Suit of 2017.
17
ಎರಡು matter connected ಇದೆ.
ಎಸ್ ಸರ್
Yeah, date-
Pending
date
24 2024 LR application rejected in FTP. Against that order that I preferred that and notice has been. My lord.
Yes, mister, how many times you keep moving?
Review petition, admission, notice.
ಆಯ್ತು ಬರುತ್ತೆ.
My lord, suit for partition.
No, we have taken your petition, disposed, given you the relief and still you are not happy. Please wait for some time. Let it come, it will come.
My lord, vacating of interim order.
There are people waiting for their petitions to be taken up. Name 2023 petition ತಗೊಂಡು allow ಮಾಡಿದೀವಿ and still you are not satisfied.
It's not like that.
Wait for it. Your status has been restored. What more you need? Corrections, ಸಣ್ಣ ಪುಟ್ಟ correction in the order. Why do you want? Wait for your turn. Wait for some time. Come after 2 or 3 months. Yes.
Vacating of interim order.
ಎಷ್ಟನೇ ಇಸ್ವಿದು
2024 fresh map.
2024
my
ಅಲ್ಲ
lord.
ಸೂಟ್ ಎಷ್ಟನೇ ಇಸ್ವಿದು
2021 my lord.
told. Yes.
My lord.
Mister, come to the other side.
Suit is 2012 year.
2012 told.
FDP proceedings, auction bid ಮಾಡಿದ್ರು. It is not partable. Then they filed application, the amount is higher side ಅಂತ ಹೇಳಿದೆ. They filed writ petition and they obtained interim stay. FDP proceedings are also stalled. It is 21 year.
Told. Yes.
It's a suit for partition. Injunction, ex parte injunction order was obtained in 2017. Since then, I have come on record, I am the defendant in that case. It has not been taken up, my lords. I filed my objection.
From 2017 it is still lying like that only.
I am awaiting
Told.
ex parte injunction. If it could be had.
My lords, the suit is questioning an agreement from 1998.
Huh?
My lords, settlement is due in the trial court, my lords. We want to vacate the stay, my lords. It's an old matter, my lords.
Parties have settled.
Please, my lords.
There are suites of the year.
For 11th, my lords. if I may request.
15, my lord, for respondent, my lord, with preliminary hearing here. This much will be.
That told. Yes.
The suit is of
Told.
2014. The suit is of 2014. We had filed an application under 710. We had been directed to serve
2013 suit.
14.
Told it. 2014.
Application for vacating stay is filed in the year 2023, my lord.
Suit is filed in which year?
17.
Told it.
Suit of 2013. Plaintiff age na amend ಮಾಡ
Told.
application.
2013 suit.
13 suit.
Told.
Plaintiff age.
ಆಯ್ತು ಕೊಡಪ್ಪ. Yes.
24 suit.
Huh?
24 suit for partition.
Ah,
Respondents are trying to alienate the property of lordship. Kindly have it on record.
you come against the ex parte order, refusing to grant ex parte order. Told.
2027. Suit filed against the government for declaration. In view of the land grabbing act, the government has to file application for transfer. The Sanabad division bench order, my lord, covered by decision. The earlier, my lord, the Sanabad court has to direct the government to take instruction.
ಏನ್ ಹಾಕಿದ್ರಿ? Told. Fresh matter.
Fresh ಬಂದಿತ್ತು, government to take instruction on site. In view of the transferring order,
Told.
influences ಆಗುತ್ತೆ.
Yes.
My lord.
Kindly have done.
My lord, suit in the year of 2014, my lord. Partition suit, my lord.
Huh?
Suit in the year of
ಸ್ವಲ್ಪ
2014.
ಕೆಳಗಿಲ್ಲ ಫುಲ್ ಮುಚ್ಕೋ ಇಲ್ಲ ಫುಲ್ ತೆಗಿ.
My lord, suit was, my lord, partition, my lord. In the year of 2014, my lord. Transposition IA was dismissed, my lord. Hence
So
they are-
14 suit.
14 suit.
Told. Yes.
Fresh shoot.
Fresh suit ಕೊಡಿ. Fresh writ
But
petition.
ಅವ್ರು ಕೇವೇಟ್ ಹಾಕಿದ್ರು last time time ತಗೊಂಡೋದ್ರು ಅದು.
ಆಯ್ತು fresh writ petition ತಾನೆ.
Fresh
ಕೊಡಿ.
another, my lord,
Suit is of the year 2010. Suit is of the year 2010. And the suit is for partition, your lordship. Therein we had placed an amendment application only to incorporate that the will is not binding,
At
your
what
lordship.
stage?
Your lordship,
At what stage of the suit?
now it is at the stage of.
At what stage of the suit did you file an application?
At the stage of arguments, your lordship. The only word we had sought.
Is there an order of stay here?
No, your lordship, is fresh suit, your lordship.
Was a fresh
Much
matter arising out of a suit for defamation. Final reliefs are in the nature of permanent injunction in the suit. The matter challenges a blanket injunction that has been passed against me at the ad interim stage.
Yes.
Maybe had on the 15th, your lordship.
You haven't told.
Your lordship, a
15th,
request in the memo which I have moved previous, the matter is set down in the trial court on Monday, your lordship, if it
It
is.
will come up only on Monday. We can't
Please,
take
your
it up.
lordship. Much. obliged.
Yes.
2021 petition, my lords, amendment application rejected,
Suit is filed in which year?
2018, my lords,
2018.
Told.
Suit of the year 23, my lord, 2023. The suit decreed in terms of the memo filed by the other side, consent decree.
Yes.
It is a suit for specific performance, wherein the court has directed to deposit that amount within 1 month, or else the contract will be annulled. Against that, I filed an application for extension that has been rejected. For that.
ಬರುತ್ತೆ ಏನು?
ಇಲ್ಲ, ಅದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಮತ್ತೆ ಅನ್ಯೂಲ್ ಮಾಡಿದ್ರೆ they deposited the amount.
In the usual course.
By the time.
ಇದೆಲ್ಲ ಈ ಕೇಸಲ್ಲಿ ಅರ್ಜೆಂಟ್ ಏನಿದೆ? Yes.
2006 suit, my lord.
2006. 2006.
For partition.
2006. Told.
Adjournments, page wise list number 1, page number 7, serial number 32 to 39.
35, Lordship kindly out, and on Monday, senior counsel is not keeping well, he's gone to hospital, that's what, Lord.
The learned counsel for the petitioner seeks time. List on date.
Monday,
Not Monday, Mr.
witness, Lordship, 13th otherwise,
14th November.
Next.
the 14th, but 13th.
ಇದು ಕೊಡ್ವಿ. ನವೆಂಬರ್ ಎಂಡ್ ಕೊಡಿ.
ಬೇಡ, sir, ದಯವಿಟ್ಟು.
ನಮ್ ಬೋರ್ಡ್ ನೋಡ್ಕೊಂಡು ನಾವು
ಆಗುತ್ತೆ sir.
ಕೊಡ್ತೀವಪ್ಪ.
much obliged.
ನೋಡ್ಕೊಂಡು.
Page number 8, serial number 40 to 48. Page number 9, serial number 49 to 54. Page number 10, serial number 55 to 59.
My
Page
lordship,
number 11.
28, my lordship, serial number.
28 will call it, please wait.
Page number 11, serial number 60 to 66. Page number 12, serial number 67 to 70. List number 2. Page number 5, serial number 12 to 14.
Sorry to. 9, my lord, Monday, 9, my lord. They filed vacating application. Monday, was some personal
Let the
inconvenience.
other side also come. Yes, next.
Page number 6, serial number 15 to 17.
Correct.
List number 1, for non-compliance first time, serial number 1.
1 week time is granted to do the needful.
14 maybe.
For orders.
Whatever you want.
Serial number 2, Kiran V. Ron.
Kiran Ron, office objections, memo of retirement, non-compliance. Who has filed this memo of retirement?
Respondent number 10, defendant number 9 has filed, my lord.
Huh?
Respondent number 10 has filed the memo of retirement. I am for the petitioner, my lords. Lord, in this,
Point number 1, my lords.
lords, in this case,
Who
my
is Mr. Dwarkanath, HS or ನೀವು appear ಆಗ್ತಿದ್ದೀರಾ?
No, my lords.
Okay.
I'm
Again,
for
office
respondent number
objections.
Non-prosecution 24/11.
Well, a memo of retirement is filed by the advocate for respondent number 10. The memo of retirement is accepted. Notice ಕೊಟ್ಟಿದ್ದಾರಾ? ಹೇಳ್ಬೇಕಲ್ರಿ. ಟೈಮ್ ವೇಸ್ಟ್ ಆಗುತ್ತೆ. ನೀವು ನೋಡ್ಬೇಕಲ್ಲ, ಚೆಕ್ ಮಾಡ್ಬೇಕಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ. Yes, who appears for respond number 10? ಬೇರೆ ಯಾರ ವಕಾಲತ್ ಹಾಕಿದಾರ? Is accepted. Full stop. Office is directed to delete the name of Mr. HS Dwarkanath as the advocate for respondent number 10. Yes.
my lords, if I may make a submission, my lord. This writ petition is, it's a very narrow scope, my lord. With regard to order 1, rule 10, my lord. I have been impleaded as a party in a suit for bare injunction after the suit was instituted, my lords.
After,
The suit was instituted, I am a third party. I have been,
how were you concerned according to the plaintiff?
my lord, may kindly come to page 44 of the application, my lord.
Yes.
Please. Paragraph number 3 and 4, my lord.
Uh,
I state that in the second week of February, the impleading applicants without any right, title or interest in the social property mentioned in the plaint, along with antisocial elements, right to interfere with the social property. The same was reinstated and it was brought to the notice that a suit is pending before the honorable court as against other defendants who try to interfere with the suit property.
so you
I
give-
state that
You're not concerned with this?
I am not concerned with this, my lord.
Will I record it and say that you will not enter near the suit property?
Please, my lord. I also want to say two more things, my lord, with regard to my plaint schedule property and the plaintiff's averment, my lord. That may also be recorded, my lord.
So
That-
therefore, you're a necessary party.
No,
If
in
you
the
have
plaint-
something, you have some property somewhere nearby,
It is nearby.
and if you are claiming that this property is yours, then you are in.
I'm not claiming this property to be mine. I'll just read the plaint averments also, my lord, with immediately after the next para also, is with regard to creation of cause of action also, because in the suit for injunction, my lords, both possession as well as interference has to be proved. Now, with regard to the interference at para 4 may be seen, my lord, because on that date, I am a citizen of the United States, my lord. I was not even there on the country when they alleged the interference caused under the application, my lord. Kindly see para 4, my lord. I state that though the impleading applicants had claimed that they have purchased the suit property, having knowledge that they had no right, title, and interest, as such, the accompanying application is filed to implead them as proper necessary party as defined in number 12 and 13. Now they say I have interfered in the second week of February, my lord. Lord, I have brought the passport entry of the petitioner, my lord.
It could be through somebody else.
But that is not averred in the petition itself, my lord. Now, secondly, my lord, if I may kindly take your lordship to
Have
the
you purchased this property?
I have purchased a property in the 2007. Suit
Therefore-
is instituted in 2013, my lord. Not
Then
through
you're a
the
necessary
plaintiffs.
party, Mr. Parkul. If you claim that you have purchased this property, then
Not through the plaintiff.
whatever it is, you have purchased this property through somebody else.
Please.
So therefore, you are a necessary party.
My lord, if I may also take only the plaint averments alone, my lord. Kindly, my lord.
That you work out in the suit, mister.
The reason being, my lord, there is no averment at all. And my kata number is completely different from what is been mentioned in the plaint averment with regard to the schedule that is mentioned, my lords.
No, you make a statement whether you purchase this property or not.
I have
If you say
purchased.
that you have purchased this property, since the suit is for perpetual injunction, is apprehension that you are attempting to interfere deserves consideration.
Please.
Work out.
My lord, just all contention will be left open, maybe.
You're already impleaded or yet to be impleaded?
I'm impleaded as defendant number 13, but an
defendant
order of
number-
stay was operating.
The defendant number 13. Yaru Narasimha.
How this?
The defendant number 13 in OS number 6886 of 2013 on the file of so-and-so has filed this petition challenging an order dated so-and-so by which the court, by which the trial court allowed an, entertained and allowed an application filed by the plaintiff under Order 1, Rule 10(2) of CPC. Next para. The facts put in a nutshell are that the suit in OS number 6886 of 2013 was filed for perpetual injunction in respect of an agricultural land in survey number 57 of Mailsandra, Kengeri Hobli, Bangalore South Taluk. The plaintiff claimed that he and the defendant number 1 were brothers, are brothers, sorry. Full stop. The defendant number 1, being the eldest son, inherited the properties with the consent of all the other family members. It is contended that the suit property is also an ancestral property, and that the plaintiff had filed OS number 1335 of 2011 for partition against the defendant number 1 and other co-partners, which is pending consideration. Full stop. The plaintiff claimed that plaintiff claimed that the defendant number one, in order to defraud his legitimate share for the suit property, colluded with the other defendants and sold a portion to the defendant number 9, 10, and 11 in terms of an sale deed dated 13/7/2012. Full stop. The plaintiff therefore sought for perpetual injunction against the defendant number one and the purchases from the defendant number one. Full stop. At what stage this application was filed?
I'll tell my
The
lord.
suit was contested by the defendants. Full stop. When the suit was listed for, at what stage?
It was still a hearing on IA, my lord, with regard to implement of defendants. Evidence had not yet commenced.
So when the suit was listed at the interlocutory stage, listed for considering interlocutory applications, comma, the plaintiff filed IA number 9,
7, my
sorry,
lords.
IA number 7.
7, my lords.
And order 1 rule 10(2) to implead the defendant number 13. Full stop. It was contended in the affidavit accompanying the application that the defendant number 13 had purchased the suit property and that he was trying to interfere with the possession of the plaintiff in the suit property. Full stop. The application was opposed by the defendant number 13, who contended that what was your claim?
There are two contentions: that I was not there in the country when the alleged interference has taken place.
He was not in the country, and therefore the allegation that he had interfered with the possession of the plaintiff was without any basis.
And secondly, the property which the defendant number 13 purchased is distinctively different
And that
from
the
the plain
property
schedule property.
purchased by him was distinctively different from the suit
From
property.
the suit property.
Full stop. Next.
And the katas are also different from what is alleged in the
The
plate.
trial court, after considering the contentions urged, comma, was of the opinion that the defendant number 13 had claimed to have purchased the suit property and therefore was a necessary party. Next para. If the being agreed by the said order, comma, the defendant number 13 has filed this petition. Next para. Learned counsel for the defendant number 13 contended that the defendant number 13 is an ordinary resident of the United States
Citizen
America,
of the United
citizen of the United States of America, and that he was not in India when it was alleged that the defendant number 13 had interfered with the possession of the plaintiff. He also claimed that the property purchased by the defendant number 13 is different from the suit property, and therefore he was neither a proper nor a necessary party to the suit. Per contra, the learned counsel for the plaintiff contended that the defendant number 13 has not disputed the fact that he has purchased portion of the land in portion of the suit property or entire property. Purchase the suit property, and therefore the threat to the possession of the plaintiff is genuine and warrants consideration. Full stop. Next, but I have considered submission of the learned counsel for the defendant number 13 as well as the learned counsel for the plaintiff. Next para. The defendant number 13 has not disputed the fact that he has purchased the land in survey number
56/2B, my lord, my property, and it is all sites when I have purchased it.
56/2B.
2B. Whereas the scheduled property is 57.
2B. Where is the sale deed?
My lord, my sale deeds are at annexure E1 to E6, my lord. Annexure E1, I have purchased through 5 sale deeds. Annexure E1 is dated 7 September at page 52, 2007.
Here, my
The schedule, my lords, is forthcoming at page 61. And the avowment that it is in 56/2B, my lords, is at page 54, the second preamble. Whereas the vendors are the absolute owner of peace and pass of human property bearing 7 of 56/2B. And my kata also I have, it's distinct from the plain schedules, my lord, plain avowments.
So what is there to show that this survey number 56/2B was owned and possessed by this defendant number 1?
There is, other than a mere plaint amendment, nothing, my lord.
Purchase land or sites?
I have purchased sites
Sites formed in survey number
56 2B
56 bar 2B of Mailasandra.
village, please. The plaint amendments, my lord, which I may, if I may request your lordships, my lord.
Please wait, Mailasandra, full
Please.
stop. From whom did your vendors buy it? From whom did your vendors buy it?
My lord, in that amendment is forthcoming. My vendors claim to be the absolute owner through an IHC, my lord. It is not here. But they have entered into an agreement of sale with Bemel Layout Society, and from Bemel Layout Society, I have purchased these plots, and they are also a confirming party. I have purchased it from defendant number 12.
But you don't even know from whom your vendors purchased. ಏನಾಯ್ತು? ಏನಾಯ್ತು? Few sites formed in survey number 56 bar 2B of Mailasandra village. Full stop. The documents, the sale deed under which, sale deeds under which the defendant number 13 has purchased do not show the flow of title of their vendor. Of his vendors, sorry, of his vendors. Full stop. It is the claim of the plaintiff that the defendant number 13 has purchased portions of the suit shell property, namely the land in survey number 57 of Mailasandra. Full stop. If that be so, comma, the plaintiff is bound to establish the said fact and also the fact that the defendant number 13 has interfered with the possession of the plaintiff in the suit property. Full stop. Since the plaintiff has alleged that the defendant number 13 had interfered with his possession, comma, the plaintiff was entitled to implead the defendant number 13 in the suit for perpetual injunction. It's no error committed by the trial court in allowing the application for it. Consequently, the impugned order does not warrant interference by this court. Hence, the same is dismissed. Hence, the writ petition is dismissed.
My lords, all contention we kept open.
All contentions are kept open.
Three,
Obliged, my lords.
serial number 3.
Here for the petitioner, my lord.
Process
File memo for dispensation of the R2, my lord.
filed, a memo is filed for dispensation of notice to proposed respondent 2A.
Please, my lord, because they are brought on record before the trial court, my lord, and filed the wakalat, filed the memo along with the order sheet of the trial court, my lord. They are avoiding the receive the same before this court, my lord. Moreover, my lord, I will not seek any relief against the said respondents, my lord.
It is contended that no relief is sought for against the respondent number 2A. In view of the above, notice to respondent number 2A, proposed respondent number 2A is dispensed.
My lord, you couldn't order, my lord, it's a
Bharat, yes. Next.
Serial number 4.
interim order may be extended.
Interim order granted early is extended to the next date.
Serial number 4, Satish K.
You lordship, I have this matter next week.
Learned counsel for the petition seeks time. List on.
27th November.
Interim order may be
Yes,
extended.
interim order is extended to the next. Suit is filed in which year? Satish? Suit is with
23 minutes.
2018, Mr. Suit andre you.
Sorry, 2018 minutes.
Next, what is the stage of the suit?
Minutes. Last time it was, I have challenged the order of impleading the allowed minutes for which I've been.
List down date, yes, next.
Serial number
Take
5.
Mr. Bhatt.
Vijay Krishna Bhatt.
R10.
My lord, I will take fresh steps.
Necessary party na.
Howದು?
Huh?
The whole relief is against R10.
In which time is granted to take, to pay process,
I may be permitted to serve the council, my lord. in the-
deposit the requisites to issue notice. In addition, the learned counsel for the petition is permitted to serve the learned counsel who represented the respondent number 10 before the trial.
Interim order may be extended.
Interim order is extended till the next date.
Serial number 6, G. Venkat Supparao.
The,
Petitioner, my lord, in the suit, sir.
ಅದು ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಬಂದಿಲ್ಲ?
The direction to complete trial within
The
the.
direction is by the other bench.
Respondent number 1 in this matter.
ಆ ಕೋರ್ಟ್ ಮುಂದೆ ಹೋಗ್ಲಿ.
Yesterday I filed wakalat on behalf of respondent number 1.
Correct, Mr. But this was disposed of by.
This was disposed of by another bench. Now I am told, my lord, there's a letter, my lord, seeking extension of time. It's only for that reason, my lord, it is before this
The
honorable.
letter dated so and so is perused. The time for disposal of OS number 2845 of 2018 is extended by another 6 months from the date of 6 months.
It's been
Yeah,
used-
stage is it?
It's in evidence stage, my lord, but let it be in the usual course, my lord. We have
Within a
Sir,
period of
there
6
is a
months,
time.
irli. 6 months aage aಗುತ್ತೆ.
1 year.
It is in the fag end of the
Months.
evidence. Further evidence of the defendants kanta ide.
ಆಯ್ತು 6 months from the date of receipt of a copy of this order.
Serial number 7.
Same order. ಯಾವ stage ಅಲ್ಲಿ ಇದೆ?
Lord's final arguments, it's listed on
3 months. 3 months.
but still end of this year is sufficient.
3 months. It's next.
Serial number 8.
ఆ లాయర్ పిలవండి, నేను సమస్య చేసేవాళ్ళు మీ
నరసి రెడ్డి.
చూశాను కదా, మీ లాయర్స్ ఎట్లున్నారంటే మీ అపోజిషన్ లాయర్స్
నరసి రెడ్డి.
వాళ్ళు
నరసి రెడ్డి.
Serial number 8, Narsi Reddy.
ಯಾವ stage ಅಲ್ಲಿ ಇದೆ proceedings before the trial? ಯಾವ stage?
ಮೆಲಡ್ ಇದು ಮೆಲಡ್ ಇದು ಎವಿಡೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ. ಸರ್ವೇಯರ್
6 months.
Serial number 9, Venkatesh R. Bhagat.
Memo for disposal ಏನಿದೆ?
The suit for basic performance,
Now, why this memo for disposal? Suit is filed in which year?
2020, my lord.
20.
20,
Why
short
this-
question is involved, my lord.
ಎಲ್ಲ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಬಟ್ ನೀವು ಆರ್ಡರ್ ಸೆಲ್ ಡಿಸ್ಪೋಸಲ್ ಕೇಳಿದ್ರೆ ಹೆಂಗೆ? What is the, who has filed this memo for disposal?
Respondent. If you stand with him, not he has to fake. That the second scheduled property is converted. It was in permissive possession of the property prior to the agreement. Therefore, it is covered by judgment. But he has to pay the duty and penalty.
But does the plaintiff say that it's a converted land?
That is converted, it is admitted.
No, whether the plaintiff says that?
Please,
ಎಲ್ಲಿ ಹೇಳಿದ್ದು?
My lord, under the agreement, possession is not given.
Now,
That's
let
all
us see what do you say in the agreement?
Possession is given, not given. That is the issue under the.
What is the subject matter of the writ petition?
Let subject matter is blood, the suit for specific formality with the trial court was filed. Agreement was filed. my lord. Two scheduled property, one is blood agriculture property, right number 2 is a converted land. my lord. But prior to the agreement, both the properties, my lord, he was in possession, the plaintiff is in possession of the property.
ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ agreement ಅಲ್ಲಿ?
Agreement, kindly come to page 49. my lord.
ಹಾ.
Page 49, last 3 line.
ಹ್ಮ್.
ಎರಡನೇ ಅನುಸೂಚಿತ ಸ್ವತ್ತು, page number 49, last 3 line.
ಎರಡನೇ ಅನುಸೂಚಿ
ಸ್ವತ್ತು ಹಿಂದೆ ರೇಷ್ಮೆ ಉದ್ಯಾನಕ್ಕೆ ಅನುಸಂಕ್ರಮಣ ಪಡೆದಿದ್ದು, ಇಟ್ ಇಸ್ ಎ ಕನ್ವರ್ಷನ್. ಸದರಿ ಸ್ವತ್ತಿನಲ್ಲಿ ನನ್ನ ಅನುಮತಿಯ ಮೇರೆಗೆ MTB ಟಿಂಬರ್ ಹೆಸರಿನಲ್ಲಿ ಮರದ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಿದ್ದು, ಮರದ ವಾಣಿಜ್ಯ ಉದ್ಯಮಕ್ಕೆ ಅವಶ್ಯಕವಾಗುವಂತೆ ದಾಖಲಾತಿಗಳನ್ನು ಬದಲಾವಣೆ ಮಾಡಿಸಿ ಕ್ರಮಬದ್ಧವಾಗಿ ಕ್ರಯಪತ್ರ ನೋಂದಾವಣೆ ಮಾಡಿಕೊಡಲು ಸಹ ಒಪ್ಪಿರುತ್ತೇನೆ. ಈ ಕ್ರಯದ ಕರಾರು ಪತ್ರದ ವಾಯಿದೆ ರಹಿತ ಕರಾರು ಪತ್ರವಾಗಿರುತ್ತದೆ. ಮೇಲ್ಕಾಣಿಸಿರುವಂತೆ ನೋಂದಾವಣೆಗೆ ಅಗತ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಹೊಂದಿಸಿಕೊಂಡು ಬಂದ ಕೂಡಲೇ ಎರಡೂ ಸ್ವತ್ತನ್ನು ಒಟ್ಟಿಗೆ ಸೇರಿಸಿ ಕ್ರಮವಾದ ಕ್ರಯಪತ್ರವನ್ನು ಬರೆದು ನೋಂದಾಯಿಸಿಕೊಟ್ಟು ಅದೇ ದಿನ ಸ್ವಾಧೀನವನ್ನು ಬಿಟ್ಟುಕೊಳ್ಳಲು
ಅದೇ ದಿನ ಸ್ವಾಧೀನವನ್ನು ಬಿಟ್ಟುಕೊಡುತ್ತೇನೆ. This was
item number 2 property was in permissive possession. He was already in possession. Item number 2 is concerned. Item number 1 is conveyed, it was agreed to not hand over the possession.
So where does it say that item number 2 possession was handed over?
That is not in the same
ಅನುಮತಿಯ ಮೇರೆಗೆ.
ಅನುಮತಿಯ ಮೇರೆಗೆ ಅಂದರೆ ರೇಷ್ಮೆ ಉದ್ಯಮಕ್ಕಾಗಿ ಅನುಸಂಕ್ರಮಣ ಪಡೆದಿದ್ದು, ಸದರ ಸ್ವತ್ತಿನಲ್ಲಿ ನನ್ನ ಅನುಮತಿಯ ಮೇರೆಗೆ ನೀನು MT ಟಿಂಬರ್ಸ್ ಹೆಸರಿನಲ್ಲಿ ಮರದ ವ್ಯಾಪಾರ ಮಾಡುತ್ತಿದ್ದು.
ಅಲ್ಲಿ ಅನುಮತಿ ಮೇರೆಗೆ ಅಂದ್ರೆ ಅದಿಂಗಾಗುತ್ತೆ, ಪಾರ್ಟ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಹೆಂಗಾಗುತ್ತೆ?
That blood he was earlier already in possession of the item number 30, with my consent, permissive possession. Item number 1 is concerned, not subsequently, after the conclusion of the agreement only, it was agreed to execute the sale deed. Possession is with respect, number 2 is concerned, item 1 is concerned. Item number 2 is concerned.
Delivered under the agreement.
That possession is not, is in permission, kindly see.
Possession was prior to the agreement.
Please, Lord.
Possession was prior to the agreement. It is not under the agreement.
Not under the agreement. Prior to the agreement, he was in possession.
So therefore, how can he become in part performance?
That is a permission, part performance with respect to item number 1 is concerned.
Vermeer's position is concerned with respect, item number 2 is concerned.
Correct.
Will not kindly see the
Item
judgment.
number 1 position ಇಲ್ಲಿ ಕೊಟ್ಟಿದೆ.
Item number 1 position ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ. Item number
Item
2 already ಸ್ವಾಧೀನದಲ್ಲಿದ್ದಾರೆ.
ಆಲ್ರೆಡಿ ಸ್ವಾಧೀನದಲ್ಲಿ ಯಾವ ಕಲರ್ ಅಲ್ಲಿ ಇರೋದು?
But under my consent, he is running the business.
So therefore it is not possession,
No, no,
part
no.
performance ಅಲ್ಲ.
No. Let kindly see.
Possession is not under part performance.
The recent judgment, covered by judgment of this honorable court. And also, Lord, Justice Abdul Nazir judgment also it is covered. Even it is referred in the impugned order. Kindly see the impugned order.
It is not Justice Abdul.
Abdul Nazir.
Correct again.
Justice Abdul Nazir, I said.
Correct again.
Kindly come to the impugned order.
Yes, please.
At page 17, para 3. Para 3 onwards. Very above recitals of the agreement shows that the plaintiff is already in permanent possession of the shed situated in item number 2 of the scheduled property and running the business in the name and style of MM Timber. Therefore, this court has directed the district registrar to calculate the deficit stamp duty.
Request consideration for court. Memo for disposal filed by the respondent is rejected since the petition requires lengthy hearing. List down on date.
It's covered by 2 judgments. Subsequently,
Nothing is covered, Mr.
They granted.
Permissive possession ಬಗ್ಗೆ ಎಲ್ಲ ಇದೆಯಾ?
ಹೌದು permissive covered by judgment.
They granted.
ಅಲ್ಲ, ಒಂದು next date ಅಲ್ಲಿ
Interim order granted early is extended till the next date.
on date kindly, because 2020 matter.
ಬರುತ್ತೆ. Yes, next.
Next, at least next week or otherwise.
Maintainability of writ petition in view of section 83. What is this? Work fact.
Seek permission to convert this WP for CRP.
The learned counsel for the petitioner seeks permission
Filing the memo for the same.
to convert this petition into a civil revision petition. Stop. The whole writ petition will have to undergo a change, Mr.
Please, Lord.
So better you file a fresh writ petition, CRP. We'll return this a certified copy of the impugned order.
Please, Lord.
ಬರ್ಕೊಳ್ಳಿ, ಅದು ಹೊಡೆದಾಕಿ. The petitioner has challenged an order passed by the Waqf Tribunal, Mysuru in OS number 2/2023. The registry has raised an objection regarding maintainability of the writ petition in view of the remedy of a revision under section 83 of the Waqf Act. Full stop. The learned counsel for the petitioner seeks permission to withdraw this writ petition and also seeks liberty to file a revision petition. In view of the matter, this writ petition is dismissed as not maintainable. Liberty is reserved to the petitioner to file a revision petition if it is permitted in law. Office is directed to return the certified copy of the impugned order to the learned counsel for the petitioner. It is needless to mention that the time consumed in pursuing this petition shall be deducted while calculating the limitation applicable to a revision petition. Yes.
Obliged.
Serial number 11, Manjunath SV.
Number petitioner, 2 months.
Serial number 12, Vishwanath Kanvi.
Non-compliance of.
Lord, I have made a submission with regard to the deletion of the.
Defendant number 6 not made a party to the amended plaint.
Yes, my lord. I am the impleading applicant in the suit, my lord. The application may be rejected, my lord, before the trial court, my lord. The plaintiff has to make a party to the, but why oversight it has.
The office objections are overruled. Office objection at seal number 1 is overruled by accepting the submissions of the learned counsel for the petitioner. List the petition for preliminary hearing.
My lord, one more submission. Lord, they have filed
It for preliminary, when do you want it?
any date may be.
Date, good, yes, next.
Please.
13th November. Serial number 13, Prakash M. Patil.
Just after service of notice to the respondent.
Permission, my lord, because the trial court is directed the, my lord, the drawing officer to hold the entire, my lord, salary as well as the pension of.
ಸರ್ವ್ ಮಾಡ್ಕೊ ಬರ್ಬೇಕು.
ಅಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಲಾಯರ್ ಸಿಗ್ತಾ ಇಲ್ಲ, ಅವರು ಬೇರೆ ಊರಿಗೆ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಏನ್ ಮಾಡು?
Kindly have it on, my lord, 20th. In the meantime, I will serve the copy.
List after service of notice to the respondent. It is open for the petitioner to serve the learned counsel who represented the respondent for the trial court. Yes.
Date may be fixed, my lord.
ಸರ್ವ್
because-
ಮಾಡ್ಕೊಂಬಂದು ಮೂವ್ ಮಾಡಿ. Cash.
Please, please.
14, Keshav Murthy B.
Appear for the petitioner.
My lordship, party in person, yaru.
My lordship, I am appearing for R2.
Lordship,
I
I
appear
appeal for R1 in
Who
this
is
matter.
Permission to
I
appear as
filed a
party
requirement.
in person.
Me lordship.
Huh?
R2 guess.
Dharanisha,
Also,
you are party in person.
also, I'll be representing.
My lord, I appear for R1 in this matter. I have filed my wakalat. My name may be shown in the cause list.
What is your name, madam?
Nisha Tiwari.
Nisha Gulati.
Nisha
Tiwari.
Huh?
Tiwari, Tiwari. TIW.
Miss Nisha Tiwari has entered appearance for the respondent number 1. You Dharanisha antidira for R1 and R2.
ಇಲ್ಲ ಸ್ವಾಮಿ R1 ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. I'll be representing R2.
Nisha Tiwari has entered appearance for respondent number 1. Office is directed to show the name of the learned counsel for the respondent number 1 in the cost list. List on yavat beku?
15th is so.
Connected.
There is another matter.
Connected.
List on yavat ide?
Connected 15th ಇದೆ ಸ್ವಾಮಿ.
15th. Aden connected number kodi.
But ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಇದು pick up ಮಾಡೋದು.
6249.
Yes, next.
Much obliged.
Archana KM,
Serial number 15.
1 week time is granted to do the needful.
But I'm the respondent, I'm representing the respondent for the trial court matter. My name may be added in.
You are the only respondent or
Only respondent,
what is your name?
Dhanush M.
Mr. Dhanush M.
Yes.
Learned counsel has entered appearance for the respondent.
Please,
Office is directed to show his name in the cause list. List on.
Lord, any day, 2 weeks to file
Date kodi,
objections.
yes, next. Chandan K.
20th. Serial number 17.
List after service of notice to the.
Respondent number 1, my lord. I filed wakalat yesterday on behalf of respondent number 1.
Uh,
Lord, I filed a suit for a partition before the trial court.
What's your name?
BCR.
Huh?
BCR, madam, B. Chandrasekhar.
B. Chandrasekhar B.
B.
B. Chandrasekhar has entered appearance for the respondent number 1. Office is directed to show his name in the cause list. List after service of notice to the other respondent.
Next week, my lord, because stay is operating against me. madam.
Interim order granted array is extended till the next date of hearing.
Very short account.
Mention after the.
ಇಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
I'll not take it up.
impleading application is allowed.
Respondent serve ಆದ್ಮೇಲೆ move ಮಾಡಿಪ್ಪ ಇಲ್ಲಾಂದ್ರೆ ಯಾರು plaintiff ಯಾರು?
Only against me. Respondent number 1 is the plaintiff, my lord. Stay is operating against me. My amendment,
The respondents 1 to 12 were defendants in the trial court and are not interested in the outcome of this writ petition. Notice to the said respondents is dispensed.
kindly next week, my
Down
lord.
on
Next week, any date, my lord.
Mr. Sidmallappa.
15th November, serial number 17, Sidmalappa PM.
What's up?
Await notice to
List
respond.
after service of notice to the respondents. Serial number 16 interim order ಇದೆ ನೋಡಿ. ಇದ್ರೆ extend ಮಾಡಿ.
Serial number 18.
Serial number 17 ಅಲ್ಲೂ interim order is extended till the next date of hearing.
Serial number 18, Nagaraj RC.
RC Nagaraj. Same order.
Interim order.
Interim order is extended till the next date.
Serial number 19, HK.
Same order. Same order.
Serial number 20, Kantrajappa MG.
Same order.
Interim order.
Interim order is extended.
Serial number 21.
21, my lord, I appear for petitioner.
Uh,
The defendants have not filed any objection. They have adopted the
what
written
is the
statement as
office
an
of
objection.
IA number to be clarified where IA once stated it annexure F.
ಅವ್ರು ಫೈಲ್ ಮಾಡ್ಬೇಕಾದ್ರೆ IA1 ಅಂತ ಫೈಲ್ ಮಾಡಿ ಹಾಕಿದ್ದಾರೆ. IA2 ಅದು actually. ಅದನ್ನ
Objections at serial number 1 is overruled by accepting the submission of the learned counsel for the petitioner. List for admission on.
Tuesday, my lord.
ಬೇರೆ
Up
ಎಲ್ಲ
to
office
Illinois
objections comply ಮಾಡಿದೀರಾ?
ಬೇರೆ ಎಲ್ಲ ಕಂಪ್ಲೈ ಆಗಿದೆ ಸರ್.
List for admission if all other office objections are complied on.
Another office objection is there, my lord. That is also made a
Check ಮಾಡಿ comply ಮಾಡಿದಿರಿ.
ಅಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಸಬ್ಮಿಷನ್ ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ.
ಒಂದೇನೋ ಮಾಡಿದಿರಿ?
ಎರಡು ಇದೆ ಸರ್.
ಇಲ್ಲ ಒಂದೇ ಇರೋದು. There is only one submission.
ಒಂದು IA2 ಬಗ್ಗೆ ಇನ್ನೊಂದು ಅಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮೆಮೋ.
ಒಂದೇ objection ಇರೋದು.
ಆಯ್ತು ಒಂದೇ. Tuesday, my lord.
Yes.
15th November.
Mr. Vijay
Serial
Kumar,
number 22, Vijay Kumar K. MA Appaya.
IA 2 of
Matter which
24.
your lordships had heard on IA for amendment, we filed our notes showing the list, order sheet dates and.
Where is Mr. Shankar Reddy? Suit is filed in which year?
Lords, the Sue, may I just, 2008, my lords.
Pass over. Yes.
Serial number 23, Abhinay YT.
Abhinay.
Additional counsel Abhinay Vaiti is not.
Advocate for restraining.
Abhinay Vaiti Manel Modva ಇದೆ ಅಂತ.
Learned
Next
counsel
week
for the
any day.
petition seeks time, this town, after 10
Okay.
days, could. 10 days.
Please, oblige.
23rd November. Serial number 24, Guraja.
I applied for the petitioner.
Ah.
But,
Yaar other side ilva? Suit is filed in which year?
2015, my lord.
2015.
15.
What is the impugned order?
My lord, for the appointment of commissioner, my lord, the application has been allowed. This is injunction suit. My lord, the petition is by defendant number 1. Plaintiff has filed application for appointment of commissioner. My lord, there are 2 suits, my lord. One is filed by, my lord, petitioner's wife. My lord, this OS number 11 of 2016.
So the limits of these two survey numbers has to be identified. See, he claims to be the owner of survey number 286.
286.
You claim to have purchased some sites in survey number 300 and 301.
Yes, my lord.
301,
Yes, my lord.
which are adjacent to each other.
Yes, my lord. My lord, in our suit, my lord, 2 times they have filed application for appointment of commissioner. 2 times it has been rejected, my lord, and he has approached
Your
the.
suit and you have filed one suit.
Yes, my lord.
Ah.
My lord, wife of the petitioner has filed one suit. OS number 11 of 2016.
Ah.
That has been clubbed together now. Now at the stage for arguments. My lord, it's an injunction suit. Both the suits are injunction suits, my lord.
No, but then the boundaries of both these survey numbers has to be identified. That is the purpose. It is not collection of evidence. How will a judge sitting in a court decide what is the boundary of a survey number?
That is
How
the.
can a judge decide? So that is correct.
My lord, the injunction suit appointment of commissioner.
That is, Mr. He is not collecting any evidence. He is only identifying the limits of these two survey numbers. He is not collecting any evidence. Because you cross-examine the commissioner to establish that the way in which he has executed the warrant is not correct. Adan Madi.
Yes.
Workful. The defendant, defendant
Number 1.
in OS number so and so on the file of so and so has filed this petition challenging an order dated so and so by which an application filed by the plaintiff under order 26 rule 9 of CPC was allowed. Next para. The suit in OS number 188 of 2015 was filed for perpetual injunction in respect of the land bearing survey number 286,
Yes, my lord.
survey number 286 of which village?
My lord, Malali village, Kasba Hobli,
Survey number-
Sakleshpura Taluk.
Idan ಬೇರೆ ಇದೆಲ್ಲ schedules ಹೊತ್ತು
No, my lord, page number 47, my lord.
filed in respect of a property bearing khata number 6220/01. Formed within survey number, lying within survey number 286 of Malali village, Kasba Hobli, Sakleshpur Taluk. Measuring 2 acres, 17 guntas. Full stop. The defendant, defendant number 1 is the owner of the sites formed in survey number 300 and 300/1, lying adjacent to the land bearing survey number 286. Full stop. The plaintiff claimed that the defendants were trying to interfere with his possession in the suit shell property. Full stop. The defendants contested the suit and claimed that they were in possession of the sites bearing numbers 300 and 300 sites formed in survey number 300 and 301 of Malali village. Full stop. The defendant, the wife of the defendant number 1 filed OS number 11 bar 2006 16 for the relief of perpetual injunction in respect of the sites so purchased. which suit was also contested. Full stop. Next para. The plaintiff in OS number 188 of 2015 filed an application under Order 26 Rule 9 of CPC to identify the limits of survey number 286. Illi the application
Lord, page number 58. my lord.
to identify the limits of survey number 286. Full stop. The said application was opposed by the defendant in the suit on the ground that in a suit for perpetual injunction, a commissioner cannot be appointed to collect evidence. It is also contended that the application was filed at a belated stage. And this suit was set down for arguments.
Yes, my lord.
For arguments. Full stop. Next para. The plaintiff is claiming title to a property lying within survey number 286. The defendants were claiming title to sites formed in survey number 300 and 301, which lay adjacent to survey number 286. Therefore, the questions that may arise for consideration in the suit is whether the plaintiff is in possession of the land bearing survey number, possession of the property lying within survey number 286, and whether the defendants have encroached into any portion of the land bearing survey number 286. Full stop. 286, or whether the sites claimed by them lie within survey number 286. Full stop. The court cannot be in a position to identify the limits of survey number 286 and also to determine whether the sites claimed by the defendant lie within survey number 286 or 300,301 of Malali village. The only way to ascertain this is through a commissioner for local inspection. Full stop. The trial court has verified the evidence on record and has found that the appointment of a commissioner is necessary for an effectual disposal of the suit. Full stop. Under the circumstances, this court does not find any necessity to interfere with the impugned order. Hence, the writ petition lacks merit and is dismissed.
Serial number 25.
And a proxy counsel, this counsel on the record that is linked, Mr. Lingraj's, there is a bereavement in the family, requested for a short accommodation.
For the response 1 to 8. Intermodally this time on the ground that there is a bereavement in the family of the learned counsel. That way of the matter, list on so and so interim order granted.
original date ಅದಕ್ಕೆ ಹಾಕ್ತಾರೆ.
That way of the matter, list on 30th November.
And then interim order.
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟು ಯಾವ
30/11 ತಾವು ಕೊಟ್ಟಿದ್ರಿ ಮುಂಚೆ.
31 ಸಾಟರ್ಡೆ ಅಂತ.
I think working date ಕಾಣ್ತಾ ಹೋಯ್ತು ಅದೆಂತ. That was the date given in the order sheet ನನಗೆ ಆಯ್ತು.
ಯಾವತ್ತು ಒಂದು ಡೇಟ್ 29th 29/11.
Interim order.
Interim order extend till the next.
Serial number 26, Mahantesh S. Hosmat.
Waiting for the respondent. Kindly pass on.
Here for petition, my lord.
ಏನು?
There is a matter, my lord, the defendant's
It is
writ
filed in which
petition.
year?
Defendant's writ petition, my lord.
Ah,
The plaintiffs had filed a my lord, suit for a bare injunction.
ah.
Not it's a case of the
What is the
plaintiff
suit?
that
Agricultural land.
it's an agricultural land. But it's case of the plaintiff that not the 2 acre 20 guntas of the land is not granted in favor of the plaintiff. Not the record of rights stands in her name. She
Both the
filed-
courts have held in his favor.
Yes,
What is the
I'm not
mistake?
disputing, Lord. I'm not disputing the grant as well as the possession of Lord. What has happened, Lord, in a western side of the boundary, Lord, the second defendant's 2 acres land, Lord, where he is unauthorized occupant, he filed a form number 53, that is pending, Lord. What the plaintiff has done, Lord, the western portion, Lord, including, Lord, the property of 2 acres, which is in possession of the second defendant, shown a boundary as, Lord, the third defendant's boundary, Lord, to grab the 2 acres, Lord. Now, Lord, may I take your lordship, now the photographs, Lord, annexure E may kindly be seen, Lord. And the schedule of the plaint. Lord, the plaint, as per plaint, Lord, east side, Lord, is a gudda.
No, after the grant of the land, was it not demarcated?
No, it is not, Lord. I have produced the copy of a
Court
grant,
ಏನ್
Lord.
ದುರಸ್ತಾಗಿಲ್ವಾ?
ಇದು ದುರಸ್ತು ಆಗಿಲ್ಲ, ಬೌಂಡ್ರಿ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ.
ಹಾ.
ಅವರು ಟೆಂಟೇಟಿವ್ಲಿ ಅವರೇ ಕೊಟ್ಕೊಂಡು ಬೌಂಡ್ರಿ ಹಾಕಿರೋದು. So, Lord,
Your lordship.
Where is the plan, where is the Darkhast, the sketch?
I don't know, Your Worship. Senior is engaged in another code. Kindly pass over.
Pass over.
But I would say, my lord, let there be a status quo maintained. I have filed an application for, my lord, Article 26 Rule 9.
The two courts have held in their favor.
I'm not disputing, my lord. I'll admit, my lord, I will not interfere with, my lord, the position of the plaintiff. It's only, my lord, the.
Either you produce a podi sketch or.
Podi ಆಗಿಲ್ಲ land.
Durasti sketch podi.
ಮಾಡೇ ಇಲ್ಲ ದುರಸ್ತಿ
Durasti ಆಗಿಲ್ಲ.
ದುರಸ್ತಿನೇ ಆಗಿಲ್ಲ.
Grand sketch podi.
ಬರೀ ಸಾಗುವಳಿ ಚೀಟ್ ಮಾತ್ರ ಕೊಟ್ಟಿರೋದು ಅವರಿಗೆ.
Sketch ಇರ್ಬೇಕಲ್ಲ.
ಸ್ಕೆಚ್ ಕೊಟ್ಟಿಲ್ಲ, ಸ್ಕೆಚ್ ಹಾಕಿಲ್ಲ.
They can't be a sagwali slip without a sketch.
But the plaintiff pays, my lord, only, my lord, annexure J.
Block number ಏನು?
27/P1.
Block ಇದೆಯಲ್ಲ ಮತ್ತೆ.
ಅಷ್ಟೇ.
Block
ಬೌಂಡರೀಸ್ ಡಿಟರ್ಮಿನ್ ಮಾಡಿ.
At least on the grand sketch ಅನ್ನ ಇರ್ಬೇಕಲ್ವಾ? You must obtain the grand sketch. Grand sketch ತಂದು ಕೊಡಿ, then we'll consider and say that as per the grand sketch injunction ಅಂತ. We'll restrict the order of injunction only to the portion mentioned in the grand sketch.
I'll see tomorrow whether.
Therefore, learned counsel for the petitioner seeks time to secure a sketch of the grant attached to the sagwali slip issued in favor of the plaintiff.
Meanwhile, my lord, that status quo to be maintained. They are troubling, my lord.
We can't do it. We can't do it.
I undertake that, my lord, so far as, my lord, the plaintiff's possession is concerned, I'll not interfere.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ? When do you want it?
10 days bit one date.
List after 10 days, one date. Santosh B.Y.
The same stage, my lord, early hearing of it. In the same stage, let it be made.
27, Santosh B.Y.
I appear for petitioner.
Respondent, Your Lordship.
Lords, to include certain suit for partition, my lords.
What is the application?
My lords, certain, I sought for amendment, my lords, and sought for including certain properties. My lords may kindly take to page 47, annexure F. Lords, these three.
What stage this application was filed?
My lords,
At what stage the application was filed?
after the issues were framed and my lords, no evidence was still,
It was posted for the stage of cross-examination, Your Lordship,
no.
Cross-examination of?
of plaintiff, Your Lordship.
No, we are the plaintiff, my lords. We never tendered any evidence.
Yes.
It is only issues were framed.
Your Lordship, if I may, draw Your Lordship's attention to page 60 of the plaint, Your Lordship. Petition,
Page
Your Lordship.
16.
Page 60.
Hmm.
Page 60, para 12.
Page 16 is annexure B, madam.
60, 60, Your Lordship.
60.
60.
Hmm.
Para 12, Your Lordship, if I may read that paragraph, it says, in the case on hand, issues have been framed on 30/10/2019 and the case is posted for plaintiff's evidence. And it reads, hence the proviso
The
of.
plaintiff
order-
has not led in this evidence.
He's not led his evidence, but the issued stage has already been crossed.
Yes.
And the provision of law is very clear on seeking for amendment of plaint, Your Lordship.
This is another property which belongs to the family.
Yes,
Yes, Barcode.
Your Lordship, one humble submission.
Yes.
I may be permitted to file my objections to the main.
No
petition.
objections. We'll allow this petition. Let the property be brought on record.
Your Lordship, in that case, if I make one humble submission, with respect to, in the order passed on IA 6, Your Lordship, it reads, page number 58, Your Lordship,
Page number
58,
58.
58,
Ah,
paragraph number 8.
ah.
The third line from in the paragraph number 8, it reads, it's relevant to note that the plaintiff in the affidavit made a reference regarding the suit in OS number 256 of 2012. OS number 256 of 2012 was filed by the plaintiff before instituting this current suit. In that, it is also relevant to note that in the plaint para number 17, it is stated about filing of a suit in OS number 256 in respect of property in serial number 74/1, 74/3, 74/2. Your Lordship, if I may further draw your attention to the application filed by the plaintiff, that is at page number 50, Your Lordship.
No, but then did you dispute that these properties belong to the family in that suit?
It's disputed, Your Lordship. Moreover, what has happened here is they've brought the knowledge of these suits were with the plaintiff at the time of filing the suit. And they have not disclosed this detail and the same objections we had filed under Order 2, Rule 2, wherein they've not
What has
spoken
happened?
about this property.
What has happened to that?
That got dismissed for default, my lord. Some of the defendants in this suit and the plaintiff, my lord, jointly filed a suit before Kunigal Court, my lords, on a separate cause of action. When one of the my lords who were the owners of the joint family, my lords, only on that, my lords, the defendant, my lords, we filed a suit. And my lords, after the death of
Did you not bring this suit to these properties into the suit when the
lords,
suit was filed?
my lords, there was a suit pending before Kunigal Court, my lords, in 256/2012.
When was it dismissed?
It was dismissed when after this suit was filed.
When?
In 2017.
2017?
Yes, my lord. 2016.
14/6/2016.
14/6/2016.
When did you file this application?
My lords, we filed this application in 6/4/2022, my lords.
What is the reason for delay?
My lords, my lords, during this pendency of the proceeding, my lords, there were certain tenants were sought to be brought before the sought to be impleaded in the suit, my lords. And that was.
Sir, what prevented you from filing this application at the earliest point in time? You waited from 2016 till 2022.
Yes, my lords.
How much cost will you pay? Cost?
Any, my lords, I'll leave to.
Yes, tell me.
1,000 rupees, my lords.
Sir, we are in thousands, lakhs.
No, my lords.
1,000 and really.
See, all the defendants are enjoying the property other than me, my lords. And they are getting rents from the properties and.
See, this cost is imposed.
Yes.
Only to deter.
Yes, my lords.
You from filing similar applications.
Yes.
It is not as if we want to enrich
Some
the other
reasonable
side.
cost maybe, my lord, some reason, 2,000.
Your lordship, heavy costs may be imposed because the reasons are not forthcoming in their affidavit as well as to why they could not include these properties.
Plaintiffs in OS number so and so, OS number 256 of 2000.
No, my lord, sure.
OS number 1186 of 2015. Before the pending consideration before the 18th Additional City Civil Judge, Bengaluru. I have filed this writ petition challenging an order dated 4/7/2023 by which an application filed with them under Order 6 Rule 17 of CPC was rejected. Next para. The suit in OS number 1186 of 2015 was filed for partition and separate possession of the plaintiff's share in the suitable properties. Full stop. The suit was contested by the defendants. Defendants or defendant?
Some defendants.
Defendants.
Some of the defendants. Full stop. The trial court framed issues and set down the case for evidence. At that stage, the plaintiff filed an application under Order 6 Rule 17 of CPC to amend the plaint and add another property and also sought for an additional relief of declaration that the giftee dated 27/6/2013 has not binding upon them to stop. The said application was opposed by the defendants who contended that the plaintiff had filed OS number 256 of 2012 before the civil judge and JMFC Kunigal for partition separate possession of the very same properties that are sought to be brought on record by way of an amendment. Full stop. They contended that the application for amendment filed after issues were framed and after the case was listed for evidence, was not maintainable in view of the proviso to Order 6 Rule 17 of CPC. Full stop. The trial court, after considering the contention so urged, held that once the issues were framed and the case was set down for trial, the party seeking amendment must show that despite exercise of due diligence, they could not plead the fact. Full stop. The trial court noticed that the plaintiffs had earlier filed OS number 256 of 2012 in respect of the very same properties that were the subject matter of the application for amendment. Full stop. Therefore, the trial court held that the plaintiff had not exercised due diligence at the time of filing OS number, filing the present suit, and consequently rejected the application in terms of the impugned order. Being agreed by the said order, the plaintiffs are before this court in this writ petition. Next para. The learned counsel for the plaintiffs contended that though the application was, though a suit was filed in OS number 256 of 2012 in respect of the very same properties that was the subject matter of the application for amendment, the said suit was dismissed for non-prosecution in the year 2016. Full stop. He contends that the defendants in the said suit had raised a contention that the suit for partial partition was not maintainable, and therefore the subsequent suit was filed for partition in respect of all other properties. He submits that unfortunately, since the suit filed in OS number 256 of 2012 was dismissed for non-prosecution, the plaintiffs were advised to include the said properties in the present suit. Full stop. He contends that the defendants would not be prejudiced in any manner if those properties are also brought on record in this suit. Full stop. Per contra, the learned counsel for the defendant number
1 and 2.
1 and 2 submits that the plaintiffs were aware that the properties which are subject matter of the application for amendment were also properties that belong to the joint family. Full stop. Therefore, they were bound to file the present suit, not only in respect of other properties, but also in respect of the properties which are the subject matter of OS number 256 of 2012. Full stop. She contends that the suit in OS number 256 of 2012 was dismissed in the year 2016, and there is no explanation for the delay from the year 2016 till the year 2022.
24.
20?
22.
April.
20, 21.
6/4/2022.
22.
22.
The application was filed. She contends that since the application is filed at a belated stage after the issues are framed and the case was set down for evidence, this application was not maintainable, and the trial court has considered the same, and therefore prays that the impugned order be left undisturbed. Next, I will consider submissions of the learned counsel for the plaintiff and the plaintiffs and the learned counsel for the defense 1 and 2. Next para. The suit in OS number 256 of 2012 were indeed filed by the plaintiffs for partition separate possession in respect of 3 items of properties bearing survey number 74/1, 74/4, 74/3, and 74/4.
Bar 2, Your Lordship. 74/1, 74/3, and
3 and 4.
74/2.
3 and 4.
3 and
Of Hosapura village. Full stop. It is not in dispute that the defendants in the said suit had raised the contention that the suit for partial partition was not maintainable. Full stop. The plaintiffs thereafter filed OS number 1186 of 2015, claiming partition in respect of the other properties. Full stop. In the meanwhile, the suit filed in OS number 256 of 2012 was dismissed for non-prosecution in the year 2016. Full stop. Therefore, the plaintiffs have now filed the application to implead to include the properties that was the subject matter of OS number 256 of 2012. Full stop. The plaintiffs must have done this at the earliest point of time before the court framed issues and posted the case for evidence. It is not as if the plaintiffs were unaware of the existence of the land bearing survey number 74/1, 74/3, and 74/4. Therefore, the plaintiffs are not diligent in pursuing the suit. Pursuing the claim in respect of survey number 74/1, 74/3, and 74/4. Full stop. Having said that, this court cannot ignore the fact that the suit is filed for partition separate possession, and therefore all the properties of the family have to be brought into the suit for an effective and for an effective adjudication of the dispute between the parties. Full stop. The delay on the part of the defendants, on the plaintiffs in filing the application to include the properties can suitably be compensated. Full stop. Compensated by awarding costs, by awarding exemplary costs. Full stop. In that way of the matter, comma, the impugned order passed by the trial court warrants interference. Consequently, this writ petition is allowed. The impugned order passed by the trial court is set aside. The application filed by the plaintiffs in order under 6 Rule 17 of CPC bracket IA number 6 is allowed. Full stop. The plaintiffs are at liberty to amend the plaint and seek for the amended reliefs. Full stop. It is open for the defendants to file up their written statement. So the trial court is directed to consider, since the suit is filed in the year 2015, the trial court is requested to consider and dispose of the suit as expeditiously as possible and in accordance with the Karnataka Case Flow Management in Subordinate Court Rules 2005.
Lordship, costs may be imposed for the time of
Either
period.
subject to payment of cost of rupees 25,000.
Lordship.
50,000.
Yes.
Serial number 28.
Lordship, kindly reduce it.
Prakash HB.
It's
I've
a
increased it
lady,
to
my lord.
50,000. It can't go down.
Lordship.
I am for petition, my lordship. Copy was not served any.
25,000. Mr. Banu Prakash.
I am for petitioner, my lordship.
Respondent.
Copy was not served any next week, my lordship.
You're for the respondent.
I appear for the.
IA for vacating. Suit is filed in which year?
It's 18, my lordship.
Suit is of the year 2018, lords. The matter is posted.
Copy ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ನೋಡಿ.
Vacating state ಕೊಟ್ಟಿಲ್ಲ ನೆನೆ ಫೋನ್ ಮಾಡಿದ್ರೆ ಸಿಗ್ಲಿಲ್ಲ WhatsApp ಅಲ್ಲಿ
ಕಾಪಿ ಕೊಡಿ.
My colleague has sent a WhatsApp.
ವಾಟ್ಸ್ಆಪ್ ಕಳ್ಸಿದಾರಂತಲ್ಲ ಭಾನು ಪ್ರಕಾಶ್.
Yesterday.
No, verify ಮಾಡ್ತೀನಿ, my lord. ಇನ್ನು next week, my lordship.
ಅಲ್ಲ ವಾಟ್ಸ್ಆಪ್ ಕಳ್ಸಿದಂತ ನೋಡಿ ಬ್ಲೂ ಟಿಕ್ ಇದೆಯಾ ನೋಡಿ. ಅಥವಾ ಬ್ಲೂ ಟಿಕ್ ಬರಬಾರ್ದು ಅದೊಂದು ಇದೆಯಲ್ಲ ಫೀಚರ್ ಅದು
Blue tick ಬಂದಿಲ್ಲ, maybe they have not seen. Blue tick is not there. Lords, just may I have it
serve a copy.
because lords, at the last stage matter is stored for arguments. At that stage they file an application for expert opinion, lords, send the entire documents.
This is a suit for?
Lord, suit is for specific performance.
Specific purpose. They are denying this their signature. Some signature are admitted, some signature are denied. That's why we sought for.
There is a registered
Thumb
agreement.
impression ಇದೆಯಾ?
My lord.
Thumb impression.
My lord.
Thumb.
Thumb ಇಲ್ಲ, signatures ಇದೆ.
Signature.
2010 there is one agreement, unregistered agreement, on the basis of which they are seeking for specific performance. 2013 there is a registered agreement. They don't seek for specific performance of 2013 agreement. They keep aside that they don't seek any relief on 13 agreement, which is registered agreement admitted by me. On the older for the same property. On the older agreement of 2010, which is unregistered, they are seeking for specific performance. Now, lords, they want to refer it for expert opinion at a stage when the matter is posted, cross-examination is completed.
What does the court say?
But the court says whatever signatures they are asking for comparison, it is available on record with us. The registered agreement is also available. The
Anyway,
admitted
the court
signatures are
cannot
available.
indulge in comparison when there is other better way
Other
of
signature.
getting it.
Other signature. They have denied the other signatures.
Court can compare, no dispute.
Court only
can
says,
compare.
lords, at this stage it cannot be sent because 73, section 73, lords, the court can compare it.
It can
Evidence is
compare.
sufficient on record to compare and come to a conclusion. When the evidence is not available and sufficient evidence is not there,
Evidence ಅಲ್ಲಿ ಏನಾದ್ರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಯಾರಾದ್ರು signature?
that they have to cross-examine us, lords.
No,
It is at the stage of cross-examination complete ಆಗೋ stage ಗೆ they
Cross examination complete ಆಗಿಲ್ವಾ?
ನಮ್ cross-examination ಇನ್ನೂ complete ಮಾಡಿಲ್ಲ. At the stage, at the verge of completion of cross-examination, they file this.
Yes,
No,
Mr.
some
Before
signature.
ಅದು ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಅಲ್ಲ ಅವ್ರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಇದ್ ಮಾಡೋಣ. ಈಗ
Class exam partly ಆಗಿದೆ ಸ್ವಾಮಿ, partly ಆಗಿದೆ. Partly they have.
No, please wait. In the course of cross examination, if the defendant admits the signature, then where's the need of a comparison?
Some signature are denied. Partly cross
there
examination.
is one more reason, my lords, why this application is filed. Lords, there is one more CRP pending where, lords, during my cross-examination, that is the defendant's cross-examination by plaintiff, certain questions were put by them. Then I gave answers, and some of the questions, my lords, answers the learned presiding officer refused to record, saying that it's all unnecessary. Why so much lengthy? This
not necessarily. Then they got irritated. Then there was a clash between the court presiding officer. Then they filed a miscellaneous petition making some allegation against the presiding officer. That is pending. That is rejected. Against that, they filed a CRP. They want a change in the presiding officer. That CRP is pending. Nevertheless, notes, since that CRP there was no stay, they filed this application. and it
When
is-
do you want it? We'll
Next
list it
week,
on
notes,
some day.
Monday, Tuesday, any day.
Take whichever date. ಯಾವ copy serve ಮಾಡ್ತೀರಿ?
Today itself I'll serve notes. I called them day
Counsel
before
for
yesterday
the
also.
petitioner submits that he has not received a copy of IA 2 of 24.
Next,
The learned counsel for response 1 to 6 is directed to furnish a copy of the application. List on.
next Thursday or
Now
Friday.
on date. Yes,
November.
Mr. Manmohan.
Serial number 29.
Obliged.
PM.
My last entry might be extended. Previous
The bond
20.
is extended till the next date of hearing.
Obliged.
IA ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಹೌದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಟ್ರಯಲ್.
Yes.
Plaintiff's writ petition. But I have filed an application for initiation of contempt. But what has happened, Lord, is I am the tenant, Lord, under the defendant. But this threat of dispossession, Lord, and them, Lord, they were not providing, Lord, water, etc. I filed a suit, Lord, seeking for injunction.
This wow laddus is the laddus, real laddus.
Lord, I sought for an order of injunction, Lord, ex parte injunction was granted. Lord, this order was communicated to her. But after the order is communicated, Lord, she disconnects water supply and, Lord, even power supply, Lord, to the premises. Lord, I file an application, Lord, for initiation of contempt before the trial court. I also seek for, Lord, the mandatory injunction to restore status quo ante. The trial court adjourned the matter, Lord. That is why, Lord, I filed a writ petition. Now, Lord, this honorable court was pleased to grant an interim order, Lord, on 25/4/2024. Lord, stating that, Lord, the order of the trial court should be complied in letter and spirit. Not to see the page 2 of the order, last portion. In the meanwhile, respondent is directed to comply with and implement the interim order dated so and so in its letter and spirit till next date of hearing. But after this, Lord, I'd even filed a police complaint. And Lord, she has the audacity of telling before the police that she will file a criminal case against me alleging sexual harassment. And Lord, she does not stop at that. She in fact files a complaint, Lord, against me alleging, Lord, section 376 offense. She's for 13 years, Lord, the managing director has raped her, and therefore, Lord, an FIR is registered. Lord, this honorable court is pleased to grant an interim order staying, Lord, further proceedings. Now, Lord, there also it does not stop. But even till today, Lord, she goes on interfering, Lord, with my possession. She obstructs the entry, Lord, to the
What is
premises.
there to show that you have been paying the rent to her?
But there, Lord, I have paid up to date rent, Lord. There is no, Lord, dispute about that.
No dispute, Andhra?
I can even place, Lord, everything on record.
Where is the document of lease or rent or whatever?
But lease, Lord, agreement is at page 22.
22.
How?
ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಬಾಡಿಗೆ ನೀವು?
Not about 12,000 per month.
Escalation.
Not
Escalation. When were you inducted in the premises?
Not this is not, in fact, not what has happened is.
2022. ಎಲ್ಲಿದೆ ಬಾಡಿಗೆ? How much is the rent?
Clause 2, Lord.
12,000.
How? Page 23. But the issue is only this, Lord. She wants this premises because in another portion of the premise, she was earlier employed, Lord, by the plaintiff itself. She worked in my company till 2021. In fact, the building is constructed at my cost. Now, Lord, she has started another Laddu premises, Lord, in the upstairs portion in a room. She wants us to somehow vacate the property. And Lord, she is leaving no stone unturned, Lord, and Lord, utter violation of the court orders, Lord. There's absolutely no value given to the court orders. Lord, kindly permit me just show me, Lord, the application for contempt for a moment. Lord, in fact, Lord, I file an application before the police for police protection. Police initially don't grant it. The trial court, Lord, grants that order. And also direct restoration, Lord, of the power supply.
Court has directed restoration.
Yes, Lord, that is also done. But please turn to
Then
page,
take a-
Lord, 36 for a moment.
Take whatever action that has to be taken. Go to the supplying a company and ask for.
Lord, power, Lord, and unless the owner gives it, Lord, I cannot do anything. Even, Lord, water connection, I have done that. But here is, not my principal contention is, Lord, the honorable court also said, Lord, comply with the order, letter and spirit. But she goes on violating this order. Kindly turn, Lord, to the application for contempt for a moment.
Vijay Shekhar Gowda. Vijay Shekhar Gowda.
Vijay Shekhar Gowda for respondent.
Electricity ಇದೆಯಾ ಇಲ್ವಾ?
ಈಗ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆ, ಈಗ ವಾಟರ್ ಕನೆಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾಳೆ? She does not allow us to take water. We have to take from the neighboring property, carry it inside the premises. She keeps vehicle or cycle in the passage so that we don't go to the premises. But can I just show one document?
An appropriate application for some police protection, something like
But
that.
police protection already ಕೊಟ್ಟಿದ್ದಾರೆ. Police protection order is already there.
ಏನೇನ್ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ?
ಅದಕ್ಕೆ ನಾನು
ನಾವೇ ಬರ್ಬೇಕು.
ಅದಕ್ಕೆ ನಾನು I have sought for initiation of contempt.
Near police protection ಕೊಟ್ಟಿದೆ, court
ಹೌದು.
in the direction ಕೊಟ್ಟಿದೆ.
ಹೌದು.
To restore the electricity,
ಹೌದು.
water, there's an injunction.
ಹೌದು.
What more you use?
Precisely, therefore, here is a person, who does not care for court order. That is why I filed an application initiation of contempt.
You take the police protection if it is given, take advantage of it.
But police nor bandidru, they at one instance they came, then I repeatedly informed the police to give police protection. I called 112, kindly permit to just show one document. But what happened was, because this entire property is sealed, because I don't.
Side is not here. Either you get them, or we'll have to simply say, take advantage of that order and approach the police.
Lords may have it on Monday, Lord.
List on Monday. There is no representation for the respondent. Just check whether the respondent is here in the court. Mr. Manmohan,
Please, Lord.
whether the respondent is here in the court. Vijay Shekhar Gowda alla. Whether the respondent that Ilva.
I have also not seen her.
There is no representation for the respondent. List on, huh? Idara, list on date put.
Monday.
Not Monday, on date put.
But my difficulty is not. I have a factory to run. But ಏನ್ ಮಾಡ್ತಾಳೆ ಅಂದ್ರೆ, she threw this dosa batter ನೆಲ್ಲ ನಮ್ಮ ಬಾಗಿಲ ಹತ್ರ ಹಾಕ್ಬಿಡ್ತಾಳೆ so that it goes inside. We call the police, and in front of the police she says, I only did it. I intentionally did it. If the door is open, I would have thrown it inside. But because the entire thing is sealed, and seen that there is no germs in the premises. ಏನಾರು ಒಂದು ಮಾಡ್ತಾ ಇದ್ದಾಳೆ ನನಗೆ. That is why I'm in a situation where I have the court order, but I'm not able to do anything.
You have to protect your business. Virtually, you can't ask the court to come and ensure. We can't watch and keep watch and guard of
completely
your
bow down.
premises. Court cannot ensure that. You have to ensure the safety of your business.
True.
ಅದನ್ನ ಯಾರು ಎಂಗೇಜ್ ಮಾಡ್ಬೇಕು, ಸೆಕ್ಯೂರಿಟಿನ ಅವ್ರನ್ನೋ ಇವ್ರನ್ನೋ ಏನ್
Security ಮಾಡಿದೀವಿ. Security ಮಾಡಿದ.
ದೋಸೆ ತಂದು ಹಾಕ್ತಾರೆ. ಅದನ್ನ ಕೋರ್ಟ್ನವ್ರು ಏನ್ ಮಾಡಕ್ಕೆ? What is that?
That is why, I'm only saying,
Correct, Mr. When there is strife between the parties, there's going to be all this kind of heartburn, all this kind of activities. ಇಬ್ರು ಜಗಳಾಡ್ದಾಗ ಇನ್ನು ಪ್ರೀತಿಯಿಂದ ಮಾತಾಡಕ್ಕಾಗುತ್ತಾ?
Court order, at least that should be given respect.
That will be an utopian situation where everybody respects the orders of the court, which never happens, and you can't expect it to happen. Alva?
At least, I would request that a person who's violating the court.
Tell us, is there any person who will simply blindly accept the orders of the court?
But if they don't, accept it.
List on date.
14th November. Serial number 30.
If you're expecting too much from the court, you should protect your business. ಅದಕ್ಕೆ ಏನ್ ಬೇಕೋ ಅದನ್ನ ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ, ಎಲ್ಲ ಮಾಡಿದ್ದೀನಿ. I have also employed
No.
security personnel.
ರಾತ್ರಿ ಹೊತ್ತು ಬೌನ್ಸರ್ಸ್ ನ ಎಂಪ್ಲಾಯ್ ಮಾಡ್ತಾರೆ.
ಅದನ್ನು ಹೇಳಿದ್ದೀನಿ.
So therefore, you know why bouncers are used.
ಅವಳು ನನ್ನ ಮೇಲೆ ರೇಪ್ ಕೇಸ್ ಹಾಕ್ತಾಳೆ, ಮತ್ತೆ ಇನ್ನೊಂದು ಕೇಸ್ ಹಾಕ್ತಾಳೆ.
They protect. You should protect. You should know how to protect your business.
Very well. ಆಯ್ತು.
ಒಂದು CCTV
ಹಾಕಿದ್ದೀನಿ, ಅದನ್ನ ಕಿತ್ತಾಕಿದ್ದಾಳೆ.
ಮತ್ತೆ ಇನ್ನೇನ್ ಮಾಡೋದು?
ಏನ್ ಮಾಡಿದ್ರು she will send her small son and daughter.
ಕಿತ್ತಾಕ್ತಿರುವಾಗ್ಲಾದ್ರೂ ಗೊತ್ತಾಗುತ್ತಲ್ವಾ?
ಹೌದು, ಅದು ಇದೆ. ಅದನ್ನ ನಾನು ಪೊಲೀಸ್ನವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. ಪೊಲೀಸ್ನವರು they are supporting her.
Yes.
But the interim order may be continued, Lord.
Yes, interim order is extended till the next date.
Great.
Serial number 30.
Hearing for petition number.
Service
awaited dismiss. For respondent number 124.
List after service of notice to respondents.
Interim order.
Interim order is extended till the next date. Manu K.
My lords, I appear for the respondent in this matter. My lords, I'm sorry, I'm on BC. My lords, this is a matter where summary judgment has been passed.
My lords, I seek a passover.
My lords, may I make one request, my lords? My lords, in the matter concerning the rejection of plaint, my lords, your lordships have already observed that that does not survive. My lords, the second matter, the summary
No,
judgment
we have
has.
passed it over.
My lords, they're seeking a passover because the matter is there before the division
is
bench
listed, my
today, my lords.
Ah.
And also before the trial court, they've asked the matter to be kept by saying they'll get a stay order from this court.
Anyway, we'll take it up, yes.
My lords, the same
lords.
matter is there at 2:30. My lords, I have some difficulty in the afternoon.
So what do you want me to do?
My lords, your lordships may take it up now or give a date next week subject to your lordships'
This
convenience.
can't be taken up now, madam. It will take us enormous time. So
My lords,
we'll
then your
pass it
lordships
over,
may
we'll
have
take
it next week.
Next week. You want it next week? The Learned Counsel for the petitioner seeks time. List on, when do you want it?
My lords, any date convenient to your lordships. My lords, next Wednesday.
Take whichever date is convenient to both
Tuesday,
of you.
Wednesday, any date, my lord.
Wednesday.
Monday,
Very well,
Tuesday,
very
Wednesday,
well.
any date.
Huh?
Monday, Tuesday, Wednesday. Any
My lords,
date.
my request for 13th, my
There
lord.
is only one submission I want to make, my lord. There is an amendment application I filed in the second writ petition. That may at least be allowed, within
My
which
lords,
time I
that's
will.
not even maintainable, that petition. Your lordships may have it on 13th, my
It's
lords.
on Wednesday, yes.
Very well. I'm grateful, my lords.
My lord, say,
Wednesday, ಹೇಳಿ ಅವತ್ತೇನು?
ಈ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಸಣ್ಣ ತೊಂದರೆ ಇದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಟ್ಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ಪಾಸಿಂಗ್ ಆಫ್ ಜಜ್ಮೆಂಟ್, ಸಮ್ಮರಿ ಜಜ್ಮೆಂಟ್. The writ petition will become infructuous.
No, again, whatever that has to be done, you please do it.
No, it's not yet passed, so that summary judgment is not challenged here. It's yet to be passed, which they're preventing.
My lords, there are two portions of the order that are under challenge. May I make
Either I'll take it up after
the division
fresh
bench.
matters and preliminary hearing,
Yes, my lord.
or I'll adjourn it to some other day. I can't take it up right now.
Yes, my lord.
It will take another 1 hour for you at least. So therefore, I don't want to
I'll leave it
other
to
lawyers to wait in the court.
Then, my lords, can it be had on
Wednesday.
Monday, my lord.
Wednesday.
Right.
Yes, next.
Very well. I'm grateful, my lord.
My humble apologies, madam. Serial number 30 notice ಆಗ್ಬೇಕಿತ್ತು. I have filed interim application pending ಇದೆ sir.
Serial number
30 ಹಿಂದಿನ matters.
in impleadment ga.
Yes, madam. ಅದು ನೋಟಿಸ್ ಆಗ್ಬೇಕು.
ಯಾರದು? Who is
Respondent number 15 is my lord DYSP of Shikaripuram, my lord. My lord, though the trial court issued direction to the respondent, impleading respondent.
that? Yeah, one issue, HCGP is directed to accept notice for respondent number 15. What do you know? Copy put on IA number 1 of 24.
Copies out, my lord.
Next.
For list number 2, for orders matter, serial number 1, Fayaz of BG.
Yes, Lord. But so far as the respondent number 12 and 13 is concerned, Lord.
Yes.
I'm seeking permission to take out hand summons, Athava,
The
to
Learned
serve the
Counsel for
copy to that counsel appearing before the trial court, Lord.
Your respondent 12 and 13, are they necessary parties?
Because sir, they are all own family members, Lord. Otherwise, it may be dispensed with and posted for,
File a memo if you want dispensation, file a memo.
I'll file.
Learned Counsel for the petitioner has filed a memo seeking dispensation notice to respondents 12 and 13. The memo is taken on record and notice to response 12 and 13 is dispensed. This is the
Next week, Lord,
petition
because
for-
the already matter has been posted for evidence, Lord, next any convenient.
This is the petition on, yavat on date put. Muniraj Gowda.
7th November, serial number 2, Muniraj Gowda V.
Hearing for respondent, my lord, first case in
R5 to R8 are the necessary parties.
24925 of 2023 matter may be infractious, my lord, suit came to be disposed on 26 November 2023.
This petition is filed challenging. This petition is filed by the Yaru.
And one Free Nation and Builders.
This petition is filed by the
Respondent number.
M Prakash.
Connected matter.
Who is M Prakash? Prakash is not a party in the suit.
My lord, connected matter in Prakash's part. First case, my lord, 24925 of 2023.
ಅದ್ರಲ್ಲಿ ಯಾರು ಪ್ರಕಾಶ್ ಯಾರು?
ಅದ್ರಲ್ಲಿ ಪ್ರಕಾಶ್ ಇಲ್ಲ.
Who is this M Prakash, Mr. who has filed this petition?
M Prakash ಬಂದ್ಬಿಟ್ಟು
Proposed defendant.
131112.
1311 next connected matter.
ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ.
First one.
First case is infractious.
The defendant number 6 in OS number 340 of 2022 has filed this petition challenging an order dated 11/10/2023, by which it rejected an application filed by the defendant under section 151 of CPC. Next paragraph, when this writ petition was listed for orders, it is brought to the notice of the court by the learned counsel for the respondent number 2, 3, and 4 that OS number 340 of 2022 was disposed of by the trial court in terms of the judgment and decree dated 29th November 2023. He therefore submits that this writ petition does not survive for consideration. In view of the aforesaid, this writ petition is dismissed as it has become infructuous. However, the contentions urged in this writ petition is kept open to be urged in an appeal that may be filed against the judgment and decree. Yes, what about the other one?
Other one, my lord, the impleading application is rejected. Other one, rule 10(2) application is rejected.
This suit is still pending.
Pending. Suit is.
What about process? R4, 5, 9 and process.
Steps on. Dispute between the
R4. This petition is filed by the proposed defendant in the suit. Full stop. The respondent number 4, 5, 8, and 9 were the defendants before the trial court. Therefore, notice to the said respondents is dispensed as no relief is claimed against them in this. List this petition on yavat week.
Next week, any date.
On
26 or 27.
26th. Interim order granted earlier is extended till the next date of hearing. Yes.
Serial number 3, Anusha B. Reddy.
Anusha B. Reddy.
For the petitioner in this matter. Lord, plaintiff's petition, application filed under order 16, rule 1 has been rejected. The suit is of the year 2004. Evidence of PW1 gets completed on 30th of September 2024. On the very same day, we make an application to summon the surveyor, Taluk surveyor, for production of a document which is exhibit P5, which is a Taluk surveyor's report. That was marked without any objection. Subsequently, my lord, in parallel proceedings, they defendant number, the contesting respondent before your lordships is the subsequent purchaser. They take up a contention that this is a forged document. Hence, I make an application to summon the Taluk surveyor along with the documents. That application has been rejected. The impugned order is at annexure B.
What is the suit for?
Suit for injunction and declaration, my lord. Subsequent to the surveyor's report, I amend my plaint in the year 2009. Changing, there was an error in the sale deed with respect to the survey number. It was initially denoted as 3/3B in my sale deed, and I came to know that it is in 17/2A subsequent to the report of the surveyor. That report of the surveyor is what I am now trying to demonstrate before the court, that it is an original document, which is not a fake document as they are now alleging.
Where do they say that exhibit P5 is forged or fabricated?
Their own objection in the my application at annexure P, my lord. Annexure P is at page 174. At paragraph 5, my lord.
Yes.
As regards statement in para 6, affidavit that genuineness and custody of survey report has been raised by defendant, therefore prove the genuineness of the said document, Taluk surveyor requires to be summoned. It is submitted that during course of cross-examination, PWN has made submission regarding non-mentioning of the date in the survey report, and also admitted survey report does not mention the date, time, surveyor visit of the land. He also admitted that the survey report was not existing as on the date of filing of the suit. Further submitted that Taluk surveyor was not appointed during the pendency of the above suit. Therefore, in order to get over these admissions made during the cross-examination, the plaintiff has filed this with malafide intention. Further submitted that alleged exhibit P5 is not original, and the plaintiff has produced a color Xerox copy of the alleged exhibit P5 survey report. Bare look of the naked eye of exhibit P5 clearly indicates that the alleged exhibit P5 survey report is not the original and it is color Xerox. Therefore, the plaintiff, in order to get over these lacuna, has filed this application. Lord, to demonstrate that it is a document obtained through proper source, I am summoning the Taluk surveyor.
Yes, Mr.
Lord, first of all, your lordship kindly turn to the plaint. Plaint ali there is no amendment, no averment as regards the fact that a survey was done. The
That is not
surveyor.
the issue. She has produced exhibit P5.
Exhibit P5 is produced. Survey report ಬಂದು ಈ ತರ ಸರ್ವೆ ಮಾಡಿದ್ರು 17(2)A ನಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು there is no pleading at all. So in the absence of pleadings, my lord, no amount of evidence, my lord, will come to the help of the plaintiff. Therefore, my lord, my first submission would be that without
Why
pleadings.
pleadings should contain all these minute details?
ಅಲ್ಲ minute ಅಲ್ಲ. Now their contention is the
Pleadings
property. Lord, your lordship may
It is
kindly
for
see.
declaration.
Yes.
There is a form prescribed under the CPC. If it substantially conforms to the form prescribed under the CPC, that is enough. Why should she mention when
Lord,
the
it is a
surveyor
fact.
and
My lord, facts, my lord, must be pleaded.
not all
Facts must be pleaded.
Not
Without
all
pleading of facts, my lord, can they say that the survey was done and the surveyor had visited the spot and the property is falling within survey number 17/2A? No such pleadings. And my lord, your lordship may kindly see. ಈಗ for a moment, my lord,
Cross
kindly turn to the
examination ಏನಂತ ಕೇಳಿದರೆ ಈ report?
cross examination ನಲ್ಲಿ kindly see, my lord. I have the depositions copy. I do not know. If your lordship-
Let a it's available with, I may be permitted to pass it.
Not every fact need be pleaded, mister.
Correct, my lord.
Not every fact.
But ಇದು this is very important, my lord. They should say that ಈ ತರ ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಆಗಿತ್ತು ಅಂತ ಹೇಳಬೇಕು.
Yes.
Lord, page 13 of the deposition, my lord. I do not know before preparing survey report under exhibit P5 whether taluk
Where are
surveyor.
reading? Where are reading?
Page 13 of the depositions, my lord. Cross examination done on 20th September 24.
My lord, it's page number 24 of the document.
Late petition.
Yes.
At page 25. I do not know before preparing survey report under exhibit P5 whether taluk surveyor had a notice to all neighboring landowners of the land bearing survey number 3/3 and 17/2 of Gankal village. It is true at exhibit P5 report, no date has been mentioned. I do not know. Usually taluk surveyor have to mention in the report date, month, year and time when such survey will be carried out. It is true where at exhibit P5 report there is no recital when and at what time the surveyor visited the land and carry out the survey. It is not correct to suggest person by name Bettaya has not been available who carried out and make a report as per exhibit P5. I do not know the name of Tahsildar which available at exhibit P5 report. It is not correct to state for the purposes of this suit, my mother Narayan Murthy, Parijata Prakash, Surendranath, Shanti, Payani have concocted exhibit P5 report. It is not correct to state whether at
What more is required? You deny.
ಹೌದು
exhibit
ಡಿನೈ
P-
ಮಾಡಿದ್ದೀನಿ. ಈಗ one more submission, my lord, I have got 7 points to urge. My lord, the first point is there is no pleadings in the plaint as regards the survey being carried out. My lord, that is the first point. As regards the second point, my lord, the survey report which has been produced, ಅದರಲ್ಲಿ ಬೆಟ್ಟಯ್ಯ ಅಂತ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
To allow it to be marked.
ಅಲ್ಲ,
Did you allow it to be marked?
that was marked, my lord, in 2005.
2005 or whatever. Why did you allow the document to be
Lord,
marked?
it has been marked. It has been marked. My lord, now my submission is ಆ exhibit P5 survey report ನೋಡಿದ್ರೆ ಒಂದ್ ನಿಮಿಷ ತಾವು your lordship may kindly for a moment that survey report is produced. Page 70. ಅದರಲ್ಲಿ your lordship may kindly see ಈ ಬಣ್ಣದಿಂದ ಗುರುತಿಸುವ so and so. Next signature ಅಲ್ಲಿ ಬೆಟ್ಟಯ್ಯ ತಾಲೂಕ್ surveyor. Now he is the person who has gone and surveyed as per the report. Now they are not seeking for examine this ತಾಲೂಕ್ surveyor ಬೆಟ್ಟಯ್ಯ. ಬರೀ ತಾಲೂಕ್ surveyor ನ ಕೇಳ್ತಾರೆ. Because ಈ ತಾಲೂಕ್ surveyor he has not gone and visited the spot. He has not conducted the survey. So he has no personal knowledge of it.
These are official records, Mr. ಅವ್ರು ರಿಟೈರ್ ಆಗೋದ್ರೆ ಅವ್ನು ಹುಡ್ಕೊಂಡ್ ಬರ್ಬೇಕಾ?
ಅಲ್ಲ.
I don't know what kind of submission.
No, he should have personal knowledge about the survey that
Yes,
he
a
has.
personal knowledge. He is not expected to have personal knowledge. Whatever based on records, you will draw the survey.
Allah, this survey report, my lord,
Cross-examine him, mister.
Lord, this survey report has been done by this person, and this person has personal knowledge of the spot inspection that he has carried out.
Yes.
So therefore, examining a taluk surveyor or a person other than a person who has surveyed the land, Lord, that cannot be done.
Is it only for production of documents or also to give evidence?
To give evidence, sir.
Give evidence.
To give evidence, sir. So therefore, he cannot depose because
Cross-examine Marty.
he will not have personal knowledge.
Cross-examine the witness, whoever brings this document and gives evidence. These are all official documents. You can't say that the official who passed the order alone has to come and produce the document and give
Lord,
evidence.
my submission is this person has gone and surveyed as per this exhibit P5. Therefore, let him be summoned. ಅವನ್ ಮಾಡಂಗಿದ್ರೆ ನಂದೇನು ಇದಿಲ್ಲ because he has personal knowledge of it.
ಅವ್ನು ಬದುಕಿದಾನೋ ಸತ್ತಿದಾನೋ?
ಅಲ್ಲ ಅದಕ್ಕೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ.
ಅದು ಗೊತ್ತಿಲ್ಲ ನಿಮಗೆ.
ಅಲ್ಲ ಈಗ ಇನ್ಫ್ಯಾಕ್ಟ್ ನಾನು ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಈ ಬೆಟ್ಟಯ್ಯ ಅನ್ನೋರು ಇಲ್ವೇ ಇಲ್ಲ ಅಂತ.
ಕೇಳಿ ಅವ್ರು, whoever comes with the document, whoever comes to give evidence, suggest all these things to him and establish that this report is not done in accordance with law.
And kindly see, my lord, this Parijata Prakash, Surendranath, Shanti, Payani anta, they all have filed suits. ಈಗ ಇವ್ರದ್ದು ಎಲ್ಲಾ ಲ್ಯಾಂಡ್ 17/2A ನಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಅವರೆಲ್ಲ ಸೂಟ್ ಹಾಕಿರೋದು 3/3B ನಲ್ಲಿ ನಮ್ ಲ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟೆ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ. ಇವ್ರೊಬ್ರು ಮಾತ್ರ ನಂದು ಲ್ಯಾಂಡ್ 17/2A ನಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
See, he or she wants some relief in respect of the property which is bearing survey number 17/2A. What is the suit property?
Suit property, my lord, is 7 guntas of land, my lord.
In survey number?
In survey number 17/2A. That is their allegation.
So therefore they are bound to prove that.
They are bound to prove it. But sale deed ಇರೋದು ಅವ್ರದ್ದು 3/3B ಗೆ.
Take advantage of it.
Kindly turn, my lord, for a moment.
Take advantage of it. How 3/3B became 17/2? It is for them to prove.
Them to prove, my lord. Why this thing is that at this point of time, this taluk surveyor na ಕರ್ಕೊಂಡ್ಬಂದು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ, as regards, Lord, one more judgment, my lord, I have. Lord.
Suit is filed in which year?
2004.
2004.
4.
Lord, restored in 2023. I conclude my evidence on 30th of September. I was cross-examined on 30th September
Was it
2020.
dismissed for non-prosecution?
Non-prosecution. Lord, without pleadings, ಇದು ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು on a similar this thing, my lord, this honorable court, my lord, has held that without pleadings, it cannot be considered. Para 5. According to the learned counsel for the petitioner, document in question is an unregistered memorandum of partition said to have been executed so and so. Based on the original cause of action, suit has proceeded. There is no corresponding pleading to support the document which is now sought to be proved. Therefore, my lord, the writ petition was dismissed. Similar, my lord, here is also a case where there is no pleading at all.
Yes.
Without a pleading, my lord, they cannot rely upon this exhibit P5. And therefore, my lord, this application now sought to summon the taluk surveyor cannot be made. And ಇನ್ನೊಂದು ಮಾಡೋ ಹಾಗಿದ್ರೆ, now one final submission which I have got. ತಾಲೂಕ್ ಸರ್ವೇಯರ್ಸ್ ಬ್ಯಾಂಗ್ಳೂರ್ ಸೌತ್ ತಾಲೂಕ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಸುಮಾರು ಜನ ಇರ್ತಾರೆ. ದಿ ADLR may be summoned to give evidence. ADLR ಬ್ಯಾಂಗ್ಳೂರ್ ಸೌತ್ ತಾಲೂಕ್.
ತಾಲೂಕ್ ಸರ್ವೇರ್ ಯಾಕೆ ಮಾಡಬಾರ್ದು?
ಅಲ್ಲ, ತಾಲೂಕ್ ಸರ್ವೆ ಸುಮಾರು ಜನ ಇದಾರೆ ಅಲ್ಲಿ. ಯಾವ ತಾಲೂಕ್ ಸರ್ವೇಯರ್ ಅಂತ?
ತಾಲೂಕ್ ಸರ್ವೇರ್ ಇರೋದು ಒಬ್ರೆ. ಅಡಿಷನಲ್ ಸರ್ವೇಸ್ ಅಟ್ಯಾಚ್ ಆಗಿರ್ತಾರೆ ಅವ್ರಿಗಷ್ಟೇ.
ಅಲ್ಲ,
ದೇರ್ ಇಸ್ ಓನ್ಲಿ ಒನ್ ತಾಲೂಕ್ ಸರ್ವೇಯರ್.
ಇಲ್ಲ, ಸುಮಾರು ಜನ ತಾಲೂಕ್ ಸರ್ವೇಯರ್ಸ್ ಇರ್ತಾರೆ. So therefore, the concerned ADLR of the Bangalore South Division, my lord, he may be.
Whoever has done this, records ಎಲ್ಲಿರುತ್ತಿದು?
In fact, my lord, one more submission.
Where will this record be?
Record. ನಾನು before the trial court, my lord, I filed a document. ನಾನು RTI ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಟ್ಟು ಈ ಎಕ್ಸಿಬಿಟ್ P5 ಬಗ್ಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದಾಗ ಈ ತರ ಡಾಕ್ಯುಮೆಂಟೇ ಇಲ್ಲ ಅಂತ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರು.
All the more reason why it has to be summoned.
Please, my lord.
All the more reason why the concerned officer is to be summoned.
Correct. If that is the case, my lord, if there is no survey report at all, lord, let the concerned, my lord, ADLR be summoned, whether this document is existing or not.
Where is that exhibit P5?
That exhibit P5, your lordship may kindly see.
It's at annexure E, my lord, page 70. 70.
70.
70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70. 70.
Who has issued the endorsement to you?
Endorsement, my lord, along with my,
From where did you get this copy, madam?
RTI.
But this was taken from the Tashaldar's office when in 2006.
The record is in the
my lord.
Tahsildar's office.
Please, my lord.
Then
It
why
was-
summon the Taluk surveyor?
It was done by Taluk Surveyor, my lord. The survey was done by the Taluk Surveyor.
So where will
Hence-
the record be? Will it be with
No,
the
before
Taluk?
because as per annexurial, I also, after their application, my lord, that there is no such document, I also made an application as per annexurial under RTA in the month of February 2024. I have got an endorsement to denote that yes, such a survey was done. And I applied under Sakala annexurial at page 151, my lord. My application is also annexed to this document. Annexurial, page 165 is my application. I make an application to the Taluk office, Bangalore South office of Tashildar, Bangalore South at page 165, Sakala Arji. I make it on 9/2/2024 and very same document I have obtained under Sakala, under RTI.
Where is that?
That is at page 165. my lord. Annexure L is the entire set of documents what I have obtained under Sakala. 165 is the application what I have made to the Taluk office, Bangalore South office
And
of
where is the
Bangalore.
document obtained by you under Sakala?
These are the annexure L is the entire set. And the last document, what I showed your lordships is what I have, the application I made from 151 page, which is annexure L, is my requisition, request to the Vishesha Tahsildar on 13/12/2005.
Where is the sketch prepared?
Sketch is at
Page 70.
161, my lord, 161. Which is part of my,
But this
RTA.
sketch and this sketch with page number 70 do not correspond with each other.
it corresponds to the same, my lord. It is signed by Bettaya.
Correct, but there is some road running.
Here also there is exhibit P5, my lord.
Exhibit P file, there is no road running.
This is
ಅದಕ್ಕೂ
what we
ಇದಕ್ಕೆ-
have obtained, my lord, under,
ರೋಡ್ ಇಲ್ಲ ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿ ರೋಡ್ ತೋರಿಸ್ತಾರೆ.
this is what we have got from there.
Hmm.
From under RTI for the very same property. Their contention is, my lord, this property doesn't come under 17/2A. I get an endorsement that it falls under 17/2A. Even the endorsement what they have given denotes that it falls under 17/2A, which is the latest endorsement.
What is this colored portion in at page number 161?
That is the portion which is 17/2A occupied by the
That's the
plaintiff.
subject matter
Please,
of this.
please, please.
Purport.
ಅಲ್ಲ your lordship may kindly see ನಾವು 161 ಇದಕ್ಕೂ ಮತ್ತೆ 70ಗೆ ಆ ಸ್ಕೆಚ್ಗೂ ಈ ಸ್ಕೆಚ್ಗೆ ಬಹಳ ವ್ಯತ್ಯಾಸ ಇದೆ.
The plaintiff in OS number 8729 of 2004 on the file of so and so.
And one more submission, my lord. Kindly turn to page 166. ಅದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 17/2J ಅಂತ ಹೇಳ್ತಾರೆ. ಇವ್ರು ಕೇಳ್ತಾ ಇರೋದು 17/2A.
ಅಲ್ಲ, ಅದು typographical error 165 ಅಲ್ಲಿ correct ಆಗಿದೆ.
Purport, yeah.
That's a typographical error when we have typed.
No, please don't intervene now, yes. OS number so and so on the file of so and so. Challenging an order dated. Where is that order?
Annexure B, my lord, at page number 30. Certified copy was not available, hence
Order
by
dated.
posted copy.
What is the order date?
29/10.
29/10/2024, by which the court rejected IA number 27,
23 and 24, my lord. IA number 23
IA
and
number 23, filed under order 18, rule 17 of CPC, and IA number 14.
24.
Sorry, order IA number 24, and order 16, rule 1 of CPC. Full stop, next para. The suit in OS number. Suit in OS number
Annexure F, page 72.
2729 of 2004 was filed for
Prayer at 79 page.
declaration of title of the plaintiff to a plot number 52 found in survey number 17/2A of Ganakal village, Kengeri Hobli, Bangalore South Taluk, and for perpetual injunction to restrain the defendants from interfering with the possession of the plaintiff in the suit property. Full stop. The suit was contested by the defendants. Contending that they were contending inter alia, that they were undertaking, they were laying a compound around the land bearing survey number 17/2A, which does not concern the plaintiff in any manner whatsoever. I am referring to paragraph number 11, page 84. Full stop. The trial court framed issues and set down the case for evidence of the parties. Full stop. The plaintiff was examined as PW1 and she marked a survey sketch prepared by the Taluk surveyor as exhibit P5. Full stop. During the course of her cross-examination, it was suggested that the sketch marked as exhibit P5 was a photocopy, and since it did not contain the date as to when it was drawn up, it was suggested that the said document was fabricated and concocted. Full stop. The plaintiff, after the evidence of PW1 was concluded, an application was filed by the plaintiff to summon the Taluk surveyor who had issued exhibit P5 to produce the documents and also lead evidence and also to tender evidence. Full stop. The said application was contested by the defendants on the ground that small Roman I, that there was no pleading in the plaint about a sketch being drawn up by the Taluk surveyor in respect of the suit property. That an application was filed before the Tahsildar seeking information regarding, seeking an authenticated copy of exhibit P5, and that the office of the Tahsildar had issued an endorsement dated 27/12/2023 that no survey sketch was issued in respect of survey number 17/2A of Ganakal village. What else? Is the other ground that you had?
And
No
that
pleading.
pleading illa. Then next, the person who has carried out that survey, he has got personal knowledge. The other Taluk surveyor who
Number
has
3, that the application, you have not mentioned that in the objections. That therefore the survey report at exhibit P5 is created, concocted and fabricated by the plaintiff. Full stop. The trial court, after considering these contentions, rejected both the applications in terms of the impugned order on the ground that exhibit P5 was already marked as a document and that the same was prepared by a public servant in the course of discharge of his official duty. It was held that exhibit P5 was a relevant document and it needed no further corroboration about its existence, genuinity and probative value. full stop. Being agreed with the said order, comma, this writ petition is filed. Next paragraph. The learned senior counsel representing the plaintiff contended that the defendants did not raise any objection at the time of marking exhibit P5. Full stop. She contends that if the documented exhibit P5 was concocted or fabricated or was a photocopy of the original survey sketch, comma, the same must have been brought to the notice of the trial court before the document was marked. She submits that after the document was marked, comma, PW1 was suggested that the said document was concocted and fabricated on the ground that what was produced was only a photocopy which did not contain the date on which it was prepared, etc. Full stop. She therefore contends that in order to establish the genuinity of exhibit P5, comma, it was necessary that the officer from the concerned department is summoned so as to give evidence about the authenticity of exhibit P5. She submits that exhibit P5 was a survey document which was prepared at her instance after duly notifying the neighboring landowners, where it was specifically shown that the defendants had encroached. Defense had encroached.
So I am, my property lies within 17/2A.
To show that the property claimed by the plaintiff lies within survey number 17/2A.
Please.
Full stop. He submits that the evidence of the concerned official is relevant to establish the fact that the property claimed by the plaintiff lies within that survey number. She further submits that no prejudice would be caused to the defendants if the concerned official from the concerned department is summoned to produce documents and also to tender evidence in support of exhibit P5. Per contra, the learned counsel for the defendant number 11 submits that there is no pleadings in the plaint about the conduct of a survey and the identification of the property within survey number 17/2A. He therefore contends that without pleadings, comma, the plaintiff has attempted to produce a document to prove that the property claimed by her lies within survey number 17/2A. In support of his contention, he has relied upon a judgment of a coordinate bench of this court in writ petition number 38590/2016. Full stop. He further contends that the document in question contends that exhibit P5 was prepared by a taluk surveyor, and therefore the person who conducted the survey should alone be summoned. And not an officer from the said department. He submits that the officer who drew up the survey sketch is privy to the fact as to how the document was drawn up, and therefore the plaintiff cannot choose to summon an official from the said department. Full stop. He also submitted that the office of the Tahsildar had issued an endorsement that the document at exhibit P5 does not exist, and therefore no purpose would be served in summoning a surveyor to adduce evidence. Full stop. I have considered submissions of the learned counsel for the senior counsel for the plaintiff and the learned counsel for the defendant number 11. Next para. The suit is filed for declaration of title of the plaintiff to the suit shell property. Full stop. The plaintiff has claimed in the plaint that the land in survey number 3 and survey number 17/2 of Ganakal were owned by her vendors, and that the entire land in survey number 17/2 is 2 acres, 18 guntas. She has claimed that the land in survey number 17/2 was bifurcated as survey number 17/2A and 17/2B. measuring 1 acre 5 guntas and 13 guntas respectively. She claimed that she claimed that her vendors sold 1 acre 10 guntas in survey number 17/2A na 2B na?
2A.
2A to her vendors. Allah. 17/2B, 1 acre 10 guntas, out of 2 acres 18 guntas in survey number 17/2, and retained 1 acre 8 guntas, which was later bifurcated as survey number 17/2A. Full stop. She claims that her vendors sold the suit property to her and contends that the suit property therefore lies within survey number 17/2A. Full stop. Therefore, the entire case revolves around the question, around the fact that the property claimed by the plaintiff lies within survey number 2A. Full stop. Exhibit P5 was a document, was a survey sketch identifying the limits of survey number 17/2A. Full stop. A copy of Exhibit P5, which is placed on record, shows that the property claimed by the plaintiff is identified in the survey sketch prepared, and it is shown that it lies within survey number 17/2A. Full stop. Therefore, it was necessary for the plaintiff to establish the correctness of the sketch, establish the genuinity, authenticity, and the correctness of this sketch. Full stop. In view of the contention of the defendant number 11, that the document at Exhibit P5 was concocted and fabricated, it was just and necessary for the plaintiff to establish the genuinity of the said document. One of the modes of establishing such genuinity is to summon the official from the concerned department and also to call upon the said official to tender evidence. Full stop. The contention of the defendant number 11 that there was no pleadings to support Exhibit P5 is inconsequential, as the plaintiff was not expected to plead each and every fact. Full stop. The plaintiff has had to generally plead the how she derived title to the suit property and how her possession was interfered. Full stop. The survey sketch, which is marked as Exhibit P5, only established P5 was on the basis of the title deeds of the plaintiff. Full stop. It is relevant to note that even after marking Exhibit P5, it is incumbent upon the plaintiff to establish the correctness of the said sketch. Full stop. This could only be done through summoning the concerned official and securing the authenticated documents from the concerned department. Full stop. The contention of the learned counsel for the defendant number 11 that the Tahsildar had issued an endorsement that no such sketch exists, makes it all the more necessary to summon the documents from the concerned department. Full stop. In that view of the matter, the impugned order passed by the trial court warrants interference. Hence, this petition is allowed, and the impugned order passed by the trial court is set aside. The applications filed by the plaintiffs under Order 18 Rule 17 of CPC is allowed. Order 18 Rule 17 of CPC and Order 16 Rule 1 of CPC are allowed. Full stop. The concerned Taluk Surveyor is summoned to produce the documents in relation to Exhibit P5 and also to tender evidence Full stop. Yes.
Obliged.
Number 4, Manjunath is the.
Yes.
ಇಲ್ಲಿ ಕೇವಟ್ ಸರ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇದೆ ಅವ್ರು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಇದ್ದಾರಂತೆ ಅಡ್ವೊಕೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೇವಟ್ ಸರ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವ್ರು ಕೇವಟ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಇದ್ದಾರಂತೆ
ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ.
ಕೊಟ್ಟಿಲ್ಲ 13 ಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದೆ
Complaints of office objections.
12 ಗೆ ಹಾಕಿ ಮಾಡಿ 13 ಗೆ ಇದೆ
Complaint and make a mention.
ಅವ್ರು ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್ ಉಡುಪಿಯಲ್ಲಿ ಇದ್ದಾರಂತೆ ನಾವು ಸರ್ವ್ ಮಾಡಿ
ಇಲ್ಲಿದ್ರೆ ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಕಳ್ಸಿ, ಇಮೇಲ್ ಅಲ್ಲಿ ಕಳ್ಸಿ, ಹೆಂಗಾದ್ರು ಕಳ್ಸಿ. ನೆಕ್ಸ್ಟ್
Number 5, Naveed Ahmad.
ಈ ನಂಬರ್ ಇಲ್ವಾ? ಫೋನ್ ನಂಬರ್ ಇಲ್ವಾ?
ಫೋನ್ ಮಾಡಿ ಕೇಳಿದ್ವಿ ಇವತ್ತು
ಫೋನ್ ನಂಬರ್ ಕೇಳೋದ್ ಬದಲು ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಕಳ್ಸೋದಲ್ಲ. Send it through other means.
12th date.
Yes, Naveed Ahmad.
Lord, I seek 2 weeks' time. Senior is not in town, man. For respondents.
Not in this.
It's for hearing on IM.
Lots filed an application lots for impleading and lots as well as lots for direction lots. Was after an order of this court lots, saying the lots judgment and decree. Lots the respondent
Time ಬೇಕಂತ ಕೊಡ್ಬೋದಾ?
a date may be fixed lots.
I have filed wakalat for the proposed respondents 2 days ago. I will file my objections.
Learn counsel for response 1 to 8 in seal number 5, 6 time. List on when do you want it?
Plus any date notes.
Any date after 15th, my lord.
Plus
Take a date.
plus 23rd, plus
23rd.
22nd, 21st my lord, 21st my lord. 21st my lord.
Yes, 21st.
Yes.
List on 21st.
Wait for.
Serial number 6, Nagendra A.
Nagendra.
Petition, my lords. File the application to bring the alerts of respondent.
Notice ಹೋಗಿದ್ಯಾ?
My lord, I am the counsel for the plaintiff in the trial court. I undertake to file the appeal for the respondent. LRs and also respondent number 2, 4 and 5.
Mr. H. Manjunath accepts notice to the LRs of the respondent number 1.
1A to E and respondent number 3A.
1 and 3 and the LRs of deceased respondent number 3.
Yes. And also undertake to
No
file the.
objection, yes, no objection to allow these applications. Hence IAs 5, 6, 7, 8, 9, 10 of 24 are allowed. The learned counsel for the petitioner is directed to amend the statement. The H office is directed to show the name of H. Manjunath as the counsel for respondent, for the LRs of respondent number 1 and LRs of respondent number 3. What about R2,
2, 4 and 5 also I undertake. I am the
2, 4,
counsel
5
for-
ನೀವೇನಾ? Mr. H.
ನಾನೇ.
Manjunath also accepts notice for respondents 2, 3, 2, 4 and 5.
Yes, ma'am.
Office is directed to show his name in the cause list. What about non-taking of hand summons in respect of respondent by advocate for petitioner?
I become infectious, ma'am.
R1 and R3 are
ಅವರ ಸೇರ್ತಿರ್ಕೊಂಡಿರೋ ಹೇಮಾವತಿ and ಮಂಗಳಗೌರಿ.
IA 1 of 24 to 4 of 24 is rejected.
ಅದು ಅವ್ರ ಮುಂಚೆ ಇಬ್ರು ಸೇರಿಸಿ ಒಂದೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ.
Rejected as separate applications are filed to bring the legal heirs of deceased respondent number 1 and 3.
Here the impugned order is rejection of order 1 rule 10(2) application.
Suit is filed in which year?
2017.
17, my lords.
Ready na? You ready?
Next one date may be granted.
And counsel for the petition seeks this now.
Interim order may be extended.
Interim order is extended till the next date of 25th.
Serial number 7, Mukunda P.
One submission, my lord. I have filed the IAS.
Copy served on the day of yesterday,
What is filed in which year?
2022 euro.
23.
23.
Against an order of injunction.
Injunction. Now, the urgency is this, there is a law and order situation which has arisen. I have filed 2 IAs, my lord. The IA number 2 is for direction to compensate, my lord. I am not on that. My lord, what they have done is interim order was granted in this case on 22/8/2024, staying the appellate court's order. My lord, in fact, the trial court had rejected my application. Appellate court granted injunction in my favor. I am the plaintiff.
We also filed the suit. Your Honor.
After, my lord, after these courts stayed that order, my lord, immediately thereafter, my lord, they come to the suit schedule property, remove the fence in a most high-handed manner and in kind of wantonness, my lord, and they destroyed the entire standing ragi crop. That shows that I am in immediate physical possession of the property.
How does it show?
My lord, they come, my lord, I have
Because
produced
they-
documents.
No,
I have
just
produced.
because they damage the standing ragi crop. It shows
Standing
that
crop,
the-
and also they've removed the fencing.
How does it show that you are in possession? Ragi
But
ಹಾಕಿದ್ದಕ್ಕೆ ನೀವು-
otherwise, there was no necessity for them to have done that, my lord, to remove the fencing.
This,
My lord, an FIR is registered.
this,
My lord, so therefore, suitable directions may be passed. Let there be a status quo, my lord. Otherwise, they'll take law into their own hands. I've also produced the FIR photographs.
Agricultural land.
My lord, it's an agriculture property, my lord. 3 acres of this thing land. Ragi crop is destroyed, fencing is removed, FIR is registered, my lord, and still there, this thing is being
this
continued.
year we have filed the partition suit in 2022, 173/2022 in same court.
Let it be, but did you destroy the standing crop?
ಇಲ್ಲ ಸ್ವಾಮಿ, we are lodged the complaint, we also lodged the complaint.
ಏನಂತ?
ಈಗ ಇದ್ರಲ್ಲಿ ಪೆನ್ಷನ್ ಹಾಕ್ಬೇಕು, ಪೆನ್ಷನ್ ಇದ್ ಮಾಡ್ತಾ ಇದಂತೆ ನಾವು ಕಂಪ್ಲೇಂಟ್, ವಿ ಆರ್ ಪೆಂಡಿಂಗ್. ಆದ್ರೆ ಮಾಡಿದ ಏನಂತ ಕಂಪ್ಲೇಂಟ್ ಏನಂತ ಅನುಮಾನ ಇದೆ ಇವ್ರ ಮೇಲೆ ಅಂತ ಅಷ್ಟೇ ಕಂಪ್ಲೇಂಟ್.
ಸರಿ, but who has destroyed the standing crop?
We not destroyed the Ragi crop.
Madam, I've produced
ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್, ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ತಾ ಇದೆ.
ಆಗಿದ್ಯಾ? ರಾಗಿ ಇನ್ನ ಯಾವಾಗ ಆಗಿದ್ದು?
ಈಗ ಇದು interim order was
When
passed
was
on
it destroyed?
17/9, my lord. 17/9/2024.
We are lodged the complaint. At a time we are in Kerala. ನಾವು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಏನ್ ಹೇಳ್ತಾರೆ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಬುಲ್ಡೋಸರ್ ಬರೋದಕ್ಕೆ ಕೇರಳದಿಂದ ನೀವು ಎಲ್ಲಾನ ಹೋಗಿರಿ, ಬುಲ್ಡೋಸರ್ ಬರ್ಬೋದಲ್ಲ?
ಅಲ್ಲಲ್ಲ ಬುಲ್ಡೋಸರ್ ಅಲ್ಲ, ಸೊ ನಾವು ಅಲ್ಲಿ ಇದ್ದಂತ ನಾವು ಇಲ್ಲ, ನಾವು ಮಾಡಿದಂತಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರಲ್ಲ ನೋಡಿ, ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಏನಿದೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
But in fact, that has been reported widely in this thing, news channels also.
ಅದಕ್ಕೆ
That screenshots of news channels have also produced.
ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ,
Have any
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕ್ತೀನಿ,
photographs?
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ.
IA number 2 ಅಲ್ಲಿ ಇದೆ. IA number 1
We also joint possession of property. ನಾವು ಪೊಸಿಷನ್ ಇದ್ಕೊಂಡು ನಾವೇ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಕ್ಕಾಗತ್ತೆ.
Along with IA number 2, I have produced photographs as well as the FIR.
ಕಂಬಗಳನ್ನ ಯಾಕೆ ಬೀಳ್ಸಿದ್ರ? Who has done this?
We not done, ಅದಕ್ಕೆ ನಾವು ಕಂಪ್ಲೇಂಟ್ ನಾವು ಕೊಟ್ಟಿದ್ವಿ ಪ್ಯೂರ್.
We'll do one thing, because they got an order of injunction, will, before the appellate court, will permit him to lay this stone pillars. Stone pillars ನ ಹಾಕೋದಕ್ಕೆ ಅವ್ರಿಗೆ ಹೇಳೋಣ.
ಆಯ್ತು, ಅದ್ ಮಾಡ್ತೀನಿ,
ರೀಇನ್ಸ್ಟಾಲ್ ಮಾಡೋದು.
ನಾನ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಆಲ್ರೆಡಿ ಅದು ಇದೆ, ಅದಕ್ಕೆ ನಾನು ಫೋಟೋನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ, ನನ್ನ ಹತ್ರ ಇದೆ. ನಾನು ಸಮ್ ಟೈಮ್
Appoint one commissioner.
ಆಗ್ಬೋದು ಸ್ವಾಮಿ,
We'll find out
ಆಗ್ಬೋದು.
if the stone pillars are there.
ಅಲ್ಲಿ ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ ಹೇಳಿ ಆಗ್ಬೋದು.
ಆಗ್ಲೇ ಎತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲೇ ಇದೆ ಅದು, ಹಂಗ್ ಕಾಂಪೌಂಡ್ ಹಂಗೆ ಇದೆ ಅದು, ಇವ್ರು ಹೇಳ್ತಾರೆ ಬಿದ್ದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಕ್ಕೆ ನಾನು
ಎಲ್ಲಿರೋದು? Where is this property?
ಫೈಲ್ ಡೀಟೇಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಡಿಸಿಷನ್ ನನ್ನ ಹತ್ರ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ನಂಗೆ ಟೈಮ್ ಬೇಕು.
Property ಇರೋದಿಲ್ಲಿ.
Property ಇರೋದು ಯಡಿಯೂರು ಹೋಬ್ಳಿ, my lord, ಮಧುರೈ ಕಾವಲ್ ವಿಲೇಜ್, ಯಡಿಯೂರು ಹೋಬ್ಳಿ, ತುಮಕೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ಇಲ್ಲಿ
ಯಡಿಯೂರು ಹೋಬ್ಳಿ, ತುಮಕೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್, my lord, ಮಧುರೈ ಕಾವಲ್ ವಿಲೇಜ್,
ಕುಣಿಗಲ್ ತಾಲೂಕು.
ಕುಣಿಗಲ್ ತಾಲೂಕು. I have also produced the FIR, my lord. The police are investigating the matter, and my instructions are that the charge sheet is almost ready. Entire standing crop, my lord, 3 acres of this thing is destroyed.
How can you pull down this stone pillars, mister? ಯಾರಾದ್ರಾಗ್ಲಿ, it's a national waste.
ಲಾರ್ಡ್ಶಿಪ್, ನಾವು ಮಾಡಿಲ್ಲ, ಎಲ್ಲರೂ ಹಂಗೆ ಇದೆ ಸ್ವಾಮಿ,
ಆಯ್ತಪ್ಪ,
ನಾನು
ನೀವು
ಫೋಟೋಸ್ ಇದೆ.
ಮಿಸ್ಟರ್, ಕಲ್ ಕಂಬನ್ ಯಾಕ್ರಿ ಹೊಡೆದಾಕ್ತೀರಾ?
ಸ್ವಾಮಿ ಹೊಡೆದಿಲ್ಲ ಸ್ವಾಮಿ, ಕಲ್ಕಂಬ ಇದೆ, ನಾನು ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತೀನಿ, ಫೋಟೋಗ್ರಾಫರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ, ನಂಗೆ ಟೈಮ್ ಕೊಡಿ.
ಇವಾಗ ಅಕಾರ್ಡಿಂಗ್ ಟು their property is fenced.
ಫೆನ್ಸ್ ಇದೆ,
We'll get it examined.
ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
ಯಾರು, any lawyer willing to go to Kunigal? Yes, any lawyer? Young lawyer. ಯಾರ ಕೈ ಎತ್ತರಪ್ಪ. Nobody was interested to go to Kunigal. They will take and bring you back. Huh? You are not young. You already gone once. So therefore I don't want to send you. Lottery ಒಂದೇ ಸತಿ. Yes, madam, can you go? You can go. Can you go, madam? You can't. Is any lawyer willing to go? What about you, youngster? ನೀವೇ, the one sitting in the end, last corner. ಹೋಗ್ತೀರಿ? ಎಷ್ಟು ಹೇಳಿ ಫೀಸ್?
Your lordship may fix, my lord. Lordship may fix, my lord.
50,000.
50,000.
Yeah,
Agriculture. They are agriculturists, my lord. It's an agriculture property.
ಏನ್
50,000.
ಮತ್ತೆ ಇನ್ನೆಷ್ಟು ಕೊಡು?
10,000 or 15,000.
10,000 will
They are agriculturists, my lord. They do not have that.
Mister, he has to give up his day's work. One day full work ಹೋಗ್ತದೆ. He has to give up his entire day's work.
Take instructions, my lord. Take
We'll direct, if it is found that these pillars are removed.
FIR is registered, charge sheet is.
Permit you to install the.
I'll install, my lord, I'll install because it's my this.
Permit, first you have to find out what is the position.
My lord, it is removed and FIR is registered.
20,000,
50,000, I have to take instructions, my lord, because
15,000,
15,000 is.
15,000. Both of you will have to pay 15,000
ಇಲ್ಲ.
each.
ನಾವು ರಿಮೂವ್ ಮಾಡಕ್ ಪೆನ್ಸ್ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, ತಿರ್ಗಾ ಮತ್ತೆ ಹೇಳ್ತಾರೆ ಪೆನ್ಸ್ ಇದೆ ಇದೆ ಆಲ್ರೆಡಿ ಇದೆ ಅಂತ
ನಿಮ್
ಹೇಳ್ತಾರೆ.
ಪ್ರಕಾರ ಇದೆಯೋ ಇಲ್ವೋ?
ಇದೆ
ಇದೆ.
ಇದೆ.
ರಿಮೂವ್
ಈ
ಮಾಡಿ
ತರ ಕಿತ್ತಾಕಿಲ್ಲ ತಾನೆ?
ನಾವಿಲ್ಲ, ಅದು ಇದೆ.
ರಿಮೂವ್ ಮಾಡಿ ಇವ್ರೇನಾದ್ರೂ ಮತ್ತೆ ನನಗೆ ರೀಇನ್ಸ್ಟಾಲ್ ಮಾಡಿದ್ರೆ ದಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಐ ಹ್ಯಾವ್ ಟು ಟೇಕ್.
ಬಟ್ ಈಗ ನೋಡಿ
ಹೇಳ್ಬೇಕಲ್ವ ನೀವು?
ಹಾಗಾಗಿ ನಾನು ಐಲ್ ಟೇಕ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಿಕಾಸ್
ಫಸ್ಟ್ ಹೇಳಿದ್ದು ರಿಮೂವ್ ಮಾಡಿದೆ ಅಂತ ಹೇಳಿ, ಈಗ ನೋಡ್ರೆ ಇನ್ಸ್ಟಾಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತೇನೆ ಸರ್, ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಐ ಹ್ಯಾವ್ ಟು ಟೇಕ್
ತಿಳ್ಕೊಂಡು ಹೇಳಿ.
That is reason I created this on report. I needed some time to file the detailed objection.
Get instructions
by Monday.
Phone ಮಾಡಿ ತಿಳ್ಕೊಳ್ಳಿ. I have already given him some hope that will appoint him as a commissioner.
Lordship, pass over the matter.
Pass over. ಫೋನ್ ಮಾಡಿದ ತಕ್ಷಣ ಬಂದು ಹೇಳಿ ಈಗಲೇ.
ಒಂದು ಟೈಮ್ ಕೊಟ್ಟಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೀಟೇಲ್ ಅಬ್ಜೆಕ್ಷನ್
ಈಗ ಬಂದು ಹೇಳಿ. If it is found that the pillars are not there and if it is lying in the manner found in the photographs, you will have to pay the entire commissioner fee. You will have to bear the fee. Find out. ತಿಳ್ಕೊಂಡು ಇಮಿಡಿಯೇಟ್ ಬಂದು ಹೇಳಿ.
Appear for the petition in this case, my lord. Respondent number 1 filed a suit for partition against some defendants, my lord. Defendant number 6 in the said suit is the father of the petitioner herein. And suit is at the stage of trial, my lord.
Suit is filed for what?
Suit is filed for partition by the respondent number 1 against the father of the petitioner. And father of the petitioner, his whereabouts are not known. Thereafter, a missing complaint came to be filed. Thereafter, his son, the petitioner, who is a practicing advocate also, my lord, he made an application to come on record by impleading himself. The application filed by him was rejected. The reasoning is at page, my lord.
How is this person interested?
He is nowhere interested. This person is the son of the defendant number 6, the petitioner who is before this court, my lord. He is the son of defendant number 6. Now kindly take annexure A, page 19, my lord. Reasoning of the trial court.
Who appears for the other side?
None of them. Notice is served on them.
Page number?
Page number 19, my lord. Annexure A, page 19, from top 8th line, my lord. It starts from the period. The period for which ಇದರಲ್ಲಿ ಇದು FIR register ಮಾಡಿರೋ date 6/9/2023 everything is mentioned. Now the court says the period for which the whereabout of defendant number 6 is not heard by the persons who naturally have to hear about defendant number 6, which is no doubt through the FIR registered that crime 92 so and so section 108 contemplated the registration is sufficient for declaring. I am not seeking that he is dead. I am just saying that his whereabouts are not known and our interests are there. So I want to come as a defendant in the suit and protect my interest, my lord. Kindly see before the filing of this suit, annexure B, my lord, page 23.
Timma Hanumaya is served.
Timmanmaya is served. Yes, please, my lord. Kindly take annexure B, my lord.
Please take out service on the advocate.
Urgency ಇದೆ ಯಾಕಂದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಹೋಗಿದೆ ಸ್ವಾಮಿ. No one is represented.
Iran counsel represented the respondent number 1 before the trial court. List on.
Until then the proceedings may be stayed. ಯಾಕಂದ್ರೆ cross examination ಇದೆ. His interest, no one is there to represent the interest of the defendant number 6.
You want to serve it, you
Agboth. I already served on them.
Yes, next.
Serial number 9.
Date, my lord.
Serve ಮಾಡ್ಕೊಂಡ್ mention ಮಾಡಿ.
Agboth. Good.
Lord, I represent my lord.
Yes. Yes, Ravindranath.
Lord, kindly, Lord, this is a petition which, Lord, the petition has been filed on the, Lord, orders on IA, passed by the, Lord, senior civil judge, Lord, Kolar KGF. Lord, kindly see the annexure D, Lord, which is the application filed by the, Lord, other side. Page number 35, my Lord. Lord, kindly see the, Lord, the prayer which has been sought, Lord. For the reasons stated in the sworn accompanying of it, plaintiff prays that honorable court may kindly accord permission to laying the underground drainage pipe in a plaint B schedule property, imposing any condition, this honorable court, so on, so, Lord. Please come to, Lord, plaint, Lord, prayer in, Lord, B. Page 27, Lord. Annexure B. Page 27, link page 20. Lord, prayer B, my lord. Lord, the perpetual injunction extend the defendant, my lord, same prayer, my lord. The suit filed in the year, my lord, the same prayer. Lord, subsequently in the 2024 application sought. Instead of, my lord, leading, when matter is, my lord, concluded and a cross-examination is over of the plaintiff, Lord, that time, Lord, this application filed, taking the, my lord, main prayer in the application. That has been allowed, my lord, even the objection has been filed, that has been allowed. So that order will question now, my lord, by me before your lordships. Well, same prayer in the application. So when matter is, when made relief is sought, my lord, evidence has to be laid, established, my lord, the case has to be established by the plaintiff, my lord, leading the evidence and producing the documents. My lord, kindly see, my lord, suit filed in the year, my lord, 2021.
Is it a unconditional order or?
Unconditional order.
With the conditions.
Unconditional order. Kindly see annexure here, my lord,
My lord, with
unconditional order.
conditions.
Order page number 23, my lord.
Please read the last portion of the order.
My lord, IA number 7 filed by the plaintiff. Page 23, my lord. IA number 7 filed by the plaintiff under section 150 CPC hereby allowed with cause. The plaintiff is hereby directed to lay the underground drainage pipe in B schedule property without damaging the other drainage. It is a final order.
Please read the next paragraph.
No, further the present order will enforce till further order passed by this court change any circumstances in future.
So therefore, if the court is convinced that the main suit cannot be allowed, then the court will pass appropriate orders to direct the plaintiff to remove the sewage pipes.
No, that's why, Lord, by taking this order, because kindly see the photograph which is produced. Lord, this is a suit, Lord, property of the, Lord, defendant. The plaint property, Lord. The plaintiff is no way connected in the, Lord, because it is exclusive property of the, Lord, defendants, Lord, or petitioner before. Kindly see a photograph, Lord, annexure page number 41 for a moment. Lord, this house was constructed, my lord. It is not a neo construction. Lord, right hand side, duplex house, my lord, behind the car, my lord. The blue color belongs to, my lord, the defendants, the petitioner herein. The, my lord, right corner one duplex house belongs to the defendants. Lord, they wanted to lay the drainage pipe in the, my lord, in between the property of the, my lord, the defendant and petitioner here. Lord, these are all matters to be, my lord, required and adjudicated, my lord, leading the evidence. Cross-examination is completed. Look, that time, in July, they filed this.
B schedule property is a common passage.
No, it is not a common. That is the same, my lord. It's not a common passage. The plaintiff has no way, my lord, connected to this. It's only, my lord, access to the property of the, my lord, defendants. Lord, she can access from the front. That is what, my lord, photographs. I have produced the photographs. That is the entrance to the, my lord, plaintiff from the first side. No, because no way, my lord, the plaintiff is
drainage or sewerage?
Drainage. They wanted to lay, my lord.
In fact, my lord, UDD scheme came.
Is it drainage or sewerage pipes?
Drainage pipe.
Drainage is to drain water.
No, my lord, it's a sewerage pipe actually.
Both, my lord, both drainage and sewerage, they wanted to lay on that.
My lord, he stops talking, then I can complete. It's both, my lord, drainage and sewerage pipe, which, my lord, were to be put beneath the incessant egress. There is no impediment, my lord, that is caused because, Lord, there is a day-to-day, the trial court, my lord, has held that.
Then how are you evacuating all this sewerage and drainage?
No, my lord, earlier what has happened, it was, my lord, through my property itself. Now, my lord, because the UDD came and, my lord, the municipality directed us, my lord, to take the drainage, my lord, straight to the pipeline, the main pipeline. Hence, my lord, we sought for we filed an application seeking relief, my lord, to connect the drainage, my lord, to the incessant egress, which was allowed by the honorable court.
But then you continue to do it whatever way you.
No, my lord, what has happened is there is no interconnectivity. All the sewage, my lord, will flow back. That is my problem. In fact, my lord, daily there is a trouble. Usually, my lord, people are staying in that particular premises. They have to, my lord, either use the public toilet or go, my lord, knocking the doors of the neighbors.
Continue to do it.
Like,
when was the suit filed?
2021.
2021. From 3 years, how you have been managing?
No, 3 years, sir, this came, my lord, the municipality, my lord.
How have you been managing from the last 3 years?
2021, my lord, when the suit was filed, my lord, there was no main drain pipe. Only later, my lord, when the suit.
Consider, but put IA 1 of 24 is filed for vacating the interim order of injunction. Interim order stay granted by this court. it appears that the plaintiff was permitted to lay the sewerage and drainage pipes in the B shell property. Stop. This incidentally was the main relief sought for, one of the main relief sought for by the plaintiff in the suit. Therefore, the order of stay granted by this court cannot be vacated at this stage. Hence, IA 1 of 24 is rejected.
One submission.
Petition for preliminary hearing in B group. Yes.
One submission, my lord.
Next.
Serial number 10. Rajshekharappa, DR.
In fact, my lord, after taking the interim order, my lord, they have blocked it.
Yes. Yes, next.
Petitioner. Resentment to appear for the respondent. This is the production of Xerox copy as a secondary evidence. My learned fund has filed an application. There is an interim order of stay. And now my learned fund has filed an application.
What is the suit is filed in 2005?
2005, my lord. The matter is at the stage of arguments of the defendant. I have already argued the matter before the trial court. Now it is the defendant's argument is yet to be done. At that stage, these applications are filed.
What is this document?
It's a power.
General power of
It's
attorney.
the general power of attorney. Lords, the property belongs to the plaintiffs. I am for the defendant number 2. Defendant number 1 is the developer of the property. He develops the property.
Where is the plaint?
And
Plaint
the-
Annex of B, my lord. Annex of C, my lord.
Plaint is annexure D.
Annex of D.
Suit is for?
Suit is for declaration and
through
injunction,
the-
my lord. Originally, thereafter the matter was, the paragraph number 14A was added and a prayer was added for possession because I was dispossessed during the pendency of the case, my lord. Now it is a suit for declaration and possession.
Lords,
But I am the owner of the property.
Yes.
And this defendant number 1, that is respond number 1 before your lordships, took the, entered into a joint development agreement with the plaintiffs. That is a producer.
Different number?
Defendant number 1 and respond number 1 before your lordships. Lord, he formed these sites, my lord. Lord, according to the development agreement which I produced before lordships, he has to choose some purchasers and had to sell the owners of the property how to execute the sale deed, my lord. Lord, so far as the facts are concerned, the defendant number 1 admits all the facts, my lord. And ownership, possession, and also the formation of the layout. But what he has sold is 2 sites in favor of the respond number 2 before lords, to defend number 2 before the trial court, contending that all the plaintiffs have jointly executed a general power of attorney dated 10/3/2003. On the basis of that, he has executed the sale deed in this favor. We have contended in the plaint that we have not executed any such power of attorney. Even I have contended there has been a collusion between the plaintiff defendant number 1 and 2, and they have fabricated a power of attorney, and without any authority, they have sold the defendant number 1 has sold these 2 sites in his favor.
That power of attorney is referred in the statement, written statement.
Yes, my lord.
That is the only contention urged by him, that on the basis of that written statement, the power of attorney only he has sold. And that is the only contention raised by him. But he doesn't produce the original.
May I submit?
And even the defendant number 2 has made this application in his evidence, admits that the original power of attorney is with the defendant number 1. That is the respond number 1 before your lordships. But he makes an application contending that the original power of attorney is with the plaintiff. That application has been allowed.
May I submit?
Yes.
Lords, the defendant number 1 is the developer who has developed about 5 acres of land. Lords, subsequent to the development, lords, a power of attorney is executed by the plaintiffs as per the claim of the defendant number 2 on 10/3/2003. Lords, authorizing the developer to sell about 6 sites, my lords, are included in this power of attorney. To sell these 6 sites, it's an unregistered general power of attorney. On the basis of this general power of attorney of 10/3/2003, lords, sale deeds are executed in my favor as well as in favor of several 3-4 persons, my lords, in respect of all
This
those
power
6
of
sites.
attorney had to be registered.
It is, my lords, of the year 2003.
Okay, the amendment was when?
Amendment
Holy.
must be of 2000.
Registration Act.
I. Now, my lords, on the basis of this power of attorney, sale deed has been executed in my favor and also in respect of several other persons.
Correct, but first of all, you get over this problem. If it is not registered, then that will be summoned and marked as secondary evidence.
Well, someone madilla, my lords, what happens is, lords, a Xerox copy is given to me because there are several sites which are included in the power of attorney. Only a Xerox,
4 sites,
six sites are there. I have.
ಆಯ್ತು ತಾಳಿ ಅವ್ರು ಹೇಳ್ತಾರೆ.
sorry.
There are 6 sites included in this power of attorney, out of which, my lords, 2 sites I have purchased and other 4 sites are sold to other persons. Now, my lords, on the basis of this power of attorney, I have purchased, I have put up a construction, I am staying there. But suddenly the plaintiffs file a suit saying that there is no power of attorney executed by them and they file a suit for declaration that these 2 sites are also belonging to them and I have encroached upon them. Notes in the written statement filed by the defendant number 1, the defendant number 1 says that, notes, the power of attorney of the year 2003 on the basis of which he has sold to me, that he has handed over to the plaintiffs. He has handed over to the plaintiffs and the written statement only specific contention is taken by the defendant number 1. Notes on the basis of the contention, because defendant number 1 is the developer, plaintiffs are the landowners. I am only a purchaser of 2 sites. And, my lords, on the basis of the statement made by the defendant number 1,
Please argue on the question of the registration of the power of attorney.
I will go through
ಅದ್ರ
that.
ಬಗ್ಗೆ ಯೋಚನೆ ಮಾಡಿ submit ಮಾಡಿ. The counsel for the respondent seeks time to address arguments on the question whether the power of attorney sought to be marked as secondary evidence required registration or not. List on.
Lord, sorry to interfere, my lord.
Continued.
Lord, sorry to interfere.
Please wait, Ravindranath.
Sorry, sir. Sorry,
ಯಾವ್ದೋ
sir.
case argue ಮಾಡುವಾಗ why
Sorry,
do
my
you-
lord. Sorry.
There's a
Sorry.
limit for. there's
Sorry,
a-
my lord. No, I was 100%
ಯಾರೋ
matter.
youngsters ಆದ್ರೆ ಮಾಡಿದ್ರೆ we can tolerate,
Sorry,
but how
sorry.
can you do this?
Sorry, I was 100%
I'm in the
matter.
midst of another matter. Please wait.
Sorry.
Stay may be continued.
Interim order is extended is, interim order granted early is extended to the next date of hearing. ಯಾವತ್ತು ಬೇಕು?
29th. 29.
29.
29. Yes, Mr. Ravindranath. ಏನ್ ಬೇಕು?
Sorry, my lord. I'm very sorry.
No,
my
I
lord.
can't, I mean, every time you do this is not the first time you're doing it. Every time
Sorry.
you do this.
Sorry, my lord.
Yes.
Interim order to be extended in that matter.
Serial number 9, interim order is extended.
Sorry. Please.
Serial number 11, Prithvi Vade.
Petition is ready. I'm serving.
Age is instructed to take a pass over, my lord. He is engaged in some other court.
I've served the copies to other side.
ಇನ್ನೇನು
also.
ಇದೆಯಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋಂಥದ್ದು?
ಅಲ್ಲ ನಮ್ದಿದೆ.
ಇನ್ನೂ ಇದೆಯಾ?
ಒಂದು 20-25 minutes ಆಗ್ಬೋದು.
ಇನ್ನೂ ಏನ್ರಿ 1 ಗಂಟೆಗೆ ಮಾಡಿದಿರಲ್ರಿ?
ಅಲ್ಲ with regard to that notification, some decisions has to be with.
No, you argue, almost argue for more than an hour. That will only pass orders ಅಷ್ಟೇನೆ.
ಅಲ್ಲ ಅದನ್ನ ಆ
ನಿಮ್ದು ಇದೆಯಾ?
Even we have to produce some documents.
Huh?
Even we have to produce some documents. my lord.
You represent the impleading applicants.
No.
Huh?
Yes.
You have to come through the additional AG.
Yes, my lord. He is engaged in some other court. That is, he is instructed to take a pass over.
Pass.
Your lordship may seek for it. Your lordship kindly have it on Tuesday, your lordship,
My lord.
2:30 or.
My lord, today
Next
it's my
sense.
lord. It's already
ಹೇಳ್ತೆ pass.
delayed.
Yes,
ಅಲ್ಲ,
next.
2:30, today there is some inconvenience for the senior counsel also in the afternoon.
Mr. I can understand why you want an adjournment. Elections ಹಂಗೆ ನಿಧಾನಕ್ಕೆ ಹೋಗ್ತಾ ಇರ್ಲಿ ಅಂತ.
ಇಲ್ಲ
That I can't.
ಅಲ್ಲ ನಾನು ಇವತ್ತವರೆಗೂ ನಾನು ಎಲ್ಲೂ ಟೈಮ್ ಕೇಳಿಲ್ಲ. ಇದು ಎಲ್ಲ
Okay.
ಪ್ರತಿದಿನ
The
ನಾವು
matter is
ಮಾಡಿದ್ದೀವಿ.
heard. I have spent at least about 2 hours hearing both of you.
ಅಲ್ಲ ನಾವು
Third matter.
ಅವತ್ತು
ಮಾಡಿ, but
ಅವಲ್ಲ
close
ಅವತ್ತು
it.
ಸಹಿತ ನಾವು ಟ್ಯೂಸ್ಡೇಗೆ ಯಾಕೆಂದ್ರೆ ಫ್ರೈಡೇ ಇರೋದ್ರಿಂದ ಇವತ್ತು ಫ್ರೈಡೇ ಇರೋದ್ರಿಂದ ಸಮ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್.
ಏನೋ ಮುಗಿಸಿ
Till
before I
108, my lord.
forget all these facts, please argue the matter.
ಅಲ್ಲ ಟ್ಯೂಸ್ಡೇ we will conclude your lordships. Kindly have it on Tuesday.
It's already too delayed, my lord.
We will not
Elections
seek any
are-
adjournment on Tuesday, your lordship. We
First
will
week of
conclude
December,
our.
my lord.
Just on Tuesday is the last chance. The Lord counsel for the petitioner seeks time. Petitioner in serial number 11.1 seeks time. As a last chance, list on Tuesday.
Interim order in second
Second
matter.
matter extend to the next date.
Lordship. Copies have been served to all the.
Do whatever you want on Tuesday.
ಅಲ್ಲ ಅದು ಮತ್ತೆ ಅವ್ರು ಮತ್ತೆ ನಾನು ಸರ್ವ್ ಮಾಡಾಗಿದೆ.
Argument ಮಾಡಿ ಅಷ್ಟೇ. And don't come and say other, give other reason to not to argue.
ಇಲ್ಲ ಇಲ್ಲ.
Conclude ಮಾಡಿ. Valuable time of the court is spent. Don't allow it to go waste.
List number 1 for fresh matter, serial number 12.
Sanchan.
Kindly may make one submission. List number 2 only, serial number 8. I was told to serve the copies on the advocate on record. It has already been served. And also the petitioner is, respond number 1 is also served. That I furnished the copies on 19th of August, madam. List number 2 only, serial number 8. I was told to serve the copies on the advocate on record in the trial court. It is already been done, ma'am.
Mr. Wait.
It may be taken
Please
up on
wait.
Monday, my lord.
ನಾನು ಯಾವುದೋ ಕೇಸ್ ಅಂತ please wait. Don't make
My
submission.
apologies, ma'am. I was not aware that it
No,
was
I'm sorry,
served
this is not the way.
because I was
You
told,
can't have patience, I also cannot have patience.
because the matter was heard.
Wait, mister,
Please, ma'am.
wait for it, ಇನ್ನೊಂದು ಅರ್ಧ ಗಂಟೆ ಕಾಯಕ್ಕಾಗಲ್ವಾ?
I'm sorry.
List number 1 for fresh matters.
When you don't have patience, please don't expect the court to have
My
patience.
sincere apologies. Because
Wait
it's
for
two
your turn,
hospitals,
wait,
so I
I
had-
was thinking that you are arguing in some matter. You're
So I was
arguing in a
taken-
matter which is already.
List one ತಗೊಂಡ್ರೆ ಅದಕ್ಕೆ submission ಮಾಡಿ.
Please wait, there is an order.
My
Even
sincere
for-
apologies.
There should be method in madness also.
My sincere apologies.
List number 1 for fresh matter, serial number 12. Sanchan Jai Nandan.
My lord, I appear for petitioner. The plaintiff is a petitioner before this honorable
number-
court, my lord.
First list.
By mistake, it was called as first list and the second.
Fresh matter first list.
Mistake ಆಯ್ತು. ನನ್ನ second list, number 1. ನನ್ನ second list 12.
ನವೀದ್ ಅಹಮದ್ ಅಂತಿದೆ.
First list ಹೇಳಿದ್ರು ತಪ್ಪಾಗಿದೆ.
Sorry, sir.
First list ನವೀದ್ ಅಹಮದ್ ಅಲ್ವೇನ್ರಿ?
Sorry.
Yeah, ಹಾಗಾಗಿ he got confused, I think.
Serial number 32.
No, he is in different matter.
32. Naveed
You
Ahmed.
should learn to wait, mister. Learn to wait.
ಬಿಡಿ ಹೋಗ್ಲಿ,
ಬಿಡಿ,
ಬಿಡಿ ಹೋಗ್ಲಿ.
Our idly path, but learn to wait.
Lords, this is defendant's petition, lords. Lords, suit is for partition. Lords, suit is filed in 2017. Lords, when evidence was led, lords, when the matter was set down for arguments, lords, an application came to be filed. Lords, referring them, lords, lords, exhibit D2 for a handwriting expert, lords.
Suit is filed for what?
Suit for partition, lords.
Partition.
Partition suit.
What is this document?
Lords, document is, lords, says, lords, it is at page number, lords.
Yeah, what is this document?
Lords, ಒಪ್ಪಿಗೆ ಪತ್ರ, Annexure D, page 23. It was marked, lords, as D2, exhibit D2. And lords, at length, lords, cross-examination was done, lords, finally, lords, the matter was set down for argument. So at this stage, lords, an application came to be filed, lords, for referring this document to the handwriting expert, lords.
Was a cross examination ಏನಂತ ಕೇಳಿದ್ದಾರೆ ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಬಗ್ಗೆ?
Lords, in the document, lords, the mother of the defendant, lords, has, lords, orally gifted this property to defendant, lords. Lords, with consent of the plaintiffs.
So what does the plaintiff say about this document in the course of cross
She
examination?
simply denied. She said that she simply denied. She is not aware of this document.
Thumb impression ಇದ್ರ ಮೇಲೆ ಏನು? What is?
And lords, it is signature, lords, they dispute the signature in the ಒಪ್ಪಿಗೆ ಪತ್ರ, lords, in the exhibit.
Did they dispute the signature in the course of cross examination or in the objections filed to the application?
No, they have not filed any, during the course of cross examination, they
ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
lords, cross examination, lords, I have not produced, lords.
ಮತ್ತೆ without knowing it, how can you file the writ petition? Learned counsel for the petitioner is directed to produce the cross examination of
Lords, exhibit, lords, DW2.
different number
Only sole defendant, lords.
of DW1.
Yes, Lord, DW1.
Yes, list after the same is done.
Serial number 33. Chandraya.
Lords, may take out notice, lords, this matter, lords. So on that day.
Learned counsel for the petitioner is permitted to serve the learned counsel who represents the respondent number.
Respondent, lords, respondent one, lords. Only respondent, lords. I'm sorry, lord, 1, 2, 3.
1 to 3.
Before the trial court. Public, lords.
Serial number 33. Chandraya.
For petitioner, filing memo for withdrawal.
A memo is filed to withdraw the writ petition. The memo is taken on record and the petition is dismissed as withdrawn. Govind Bharat.
Serial number 34. Govind Bharat, MV.
This is a petition, my lords, challenging common order dated 4/1/2024, my lords. Wherein my IS under order 18 rule 17 and 151 of CPC has.
Suit is for what?
My lords, Suit is for partition and separate possession.
Ah.
Lords, after arguing the case on merits, my lords, the defendant number 1 has filed an order, an application under Order 18 and Rule 17, my lords. That was allowed. When it was time for the defendant 1 to address his arguments, an application, this application was filed, my lords, which is similar to mine. That was allowed, my lords. That was allowed, and the defendant 1 was permitted to lead further evidence. And subsequently, my lords, on the next date of hearing, when the evidence was supposed to be led, the defendant remained absent and a lenient view was taken, my lords. Subsequently, the defendant 1 got marked 3 extra other documents, my lords. And when it was the time for me to cross-examine the defendant number 1, my lords, due to some personal inconvenience, my lords, I could not cross-examine him.
Take out notice.
Lords, the matter was listed for final arguments, my lords. It was already listed on 15th October and now it has been adjourned to 25/11.
Where is the impugned order?
Lords, page 72 to 75, my lords.
Cross-examination was closed on 14/6/23.
Yes, please, my lords.
When did you file these applications?
My lords, I filed this application on 16/12/2023.
Take out notice, issue emergent notice. In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represents the respondents before the trial court.
Lords, interim.
List down so and so until the next date of hearing. The further proceedings in the suit before the trial court is stayed. Yes.
Grateful, my lords.
23rd November.
Grateful.
Serial number 35 urgent, serial number 36, Satish DJ.
Other 2 writs are filed arising out of a common order.
Yes,
It
ma'am.
may be
The
taken
number
up
one
along.
petition
is.
Is this petition?
FR number is there, my lord.
Along with WP number so and so, so and so. List on yavat ಬೇಕು?
Monday, tomorrow, Monday. Tuesday, please.
ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ.
Monday it will be given. No, Tuesday, I'm not in station.
Tuesday, yes.
Highly.
Mr. Balakrishna Shastri.
For serial number 37, G. Balakrishna Shastri.
For the petition. Suit is one for partition and separate possession, my lords. Defendant's petition. my lords,
Suit is filed for partition.
Partition and separate. Defendant's writ petition, my lords. Defendants filed IA under Order 14 Rule 5 for framing few issues, my lords. That IA came to be dismissed on the ground that there is an additional issue number 1 framed by the trial court. Therefore, it is being dismissed. But against this order, we have gone on a review and that was dismissed, my lords. The error which was apparent is that there is no relationship between additional
Issues arise for consideration. How do these issues arise for consideration? Plaintiffs 1A, B, 3A, 3B, 3C are already impleaded.
Please.
Without cause of action, how could they be impleaded?
Please, my lords, but the order passed by the trial court, the reasoning given is wrong, my lords. Our additional issue number 1 frame ಮಾಡಿದೀವಿ. Since additional issue number 1 has been framed, this IA does not survive for consideration is what he says. In page number 12, my lords.
Where is the additional issue?
Additional issue is at page number 43. Whether the defendant proves the contention as alleged in para 8 of the written statement.
Page number?
43. Additional issue. Framed on 6/1/2020.
Yeah, para 8 ಅಲ್ಲಿ ಏನಂತ ಹೇಳಿದಿರಾ?
Para 8 ಅಲ್ಲಿ, my lords, page number 40 ಅಲ್ಲಿ, para 8.
Address of the amended plaint, Mrs. Triveni is unidentifiable and not correct. The issue is whether the address of Ms. Triveni is correct or not. That is the issue. Because this issue is framed,
Where is
these additional issues won't survive for consideration is what the trial court.
Where is the original written statement as filed by you?
Original written statement, my lord, is at annexure. Page number 29, my lord, annexure D.
But please tell us how these issues arise.
May not be, my lord, but there is an error committed by the
That
trial.
is okay, but how does these issues arise? You have filed only to protract the proceedings. This again is from Mangalore. Purple.
It may be noted, my lords, that
No noted. Application
because
does not.
there is an error apparent on the
Correct.
case of record.
It may not be on that ground, we'll dismiss it on another ground.
Please. It may be noted, my lords, that's all.
The defendant in OS number so and so on the file of so and so, in OS number 119 of 2012 on the file of the third additional senior civil judge Mangalore has filed this petition challenging the correctness of an order dated 25/2/2020 now. Dated is 25/2/2020, by which his application under Order 14 Rule 5 of CPC was rejected. The petitioner has also challenged an order. Oh, this time I'm going to impose cost on you. Sorry. And you have the audacity to come to the High Court against this order. Review Aki, 2012 suit ali, you file an application, you file a review, then you come before this court. When will you be convinced that you don't have a case? How many times should you be told that you don't have a case? Cost? No, I'll dismiss with cost. The doors of the High Court are open, doesn't mean to say you can keep on coming. Doors of the court are always open. Once sati bandmel mugitu. Innasati pade barake. This is not tourist place. ಆಯ್ತಾ? ಎಷ್ಟು ಹೇಳಿ ನೀವೇ ಹೇಳಿ ಡಿಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಹೇಳಿ ಬಿಫೋರ್ ಐ ಕನ್ಕ್ಲೂಡ್.
I may be
challenge in order.
If I may be permitted to withdraw the writ petition.
The Land Counsel for the petitioner seeks permission to withdraw the petition. The petition is dismissed as withdrawn. Yes.
Bill number 38, Harish Bandari T.
I appear for the petitioner here in Lordship. Lordship, the suit is one for declaration, Lordship. The suit is filed by the respondent one herein for declaration as against the other respondents where the petitioner is not a party. The suit filed by the respondent number 1 is claiming her right by virtue of a will. In that suit, which was filed by respondent number 1, the petitioner herein filed an IA, which is IA number 5, to get himself impleaded. That IA was allowed, and the plaintiff was directed to get the same amended and amend his name in the plaint, Lordship. Subsequently, the plaintiff filed IA number 7 to review the said order. The said order set aside the impleading application where the petitioner was permitted to get himself impleaded, as against which this petition is filed, Lordship. The question here is, Lordship, the petitioner had earlier filed a suit as against the respondent number 1, which is OS number 228 of 14, wherein the items where the will is concerned, 2 of the items of the will are a subject matter of that suit, Lordship. Wherein this respondent number 1 is also a party. If your lordship could peruse page number 38, the type copy of the 32, lordship.
You're deposed in some other suit that you're not related to this Chinnapaya.
Lordship, that is a subject matter where he claims that he is the owner of the property as there is a relinquishment deed by the said Chinnaya. That is the observation made by the court that his own statement tells.
Please take us through the application file
Yes, lordship.
for impleadment.
At page number 45, lordship.
Please come to para 3. Para 3, page 46.
Yes, lordship. I submit that the above said survey number properties are originally belonging to one Chinnapaya. The same were granted in his name. He was in possession and enjoyment of the suit properties and cultivating the same, personally growing regular crops on the same. His name was incorporated in the revenue records by virtue of the grant from the year 77 to 78 up to 96-97. He had no issues. For that reason, I had been taking care of the efforts of Chinnapaya. As he is my brother-in-law, for that reason, he orally relinquished his right on the aforesaid property. Thus, I become the absolute owner thereof. Subsequently, all the documents pertaining to those survey numbers are standing in the petitioner's name, Lord.
That's okay. You say that Chinnapaya was your brother-in-law.
Yes, Lordship.
And he died intestate.
Yes, Lordship.
He relinquished the property orally.
Orally.
Therefore, you want to come on record.
Yes, Lordship.
Correct.
I am in possession of the property,
That's
Lordship.
okay. Now you please come to this application. Order 47, Rule 1. (74).
That is the observation made by the court where it has been rejected that his own statement tells that his far relation is the ground, Lordship.
In the other suit that was filed.
228, Lordship.
228.
Yes, Lordship.
You say that you are distantly related to Chinnapaya. You don't even say that he is a brother-in-law.
Lordship,
Therefore,
that is
how are you interested in the property?
Lordship, interested as in that suit is still pending, Lordship.
Correct, madam. That can you withdraw the statement made in that suit?
Lordship, that suit is a question of trial in that case, but
that is a statement made by you.
Yes, Lordship.
For a court on oath.
Yes, Lordship.
Can you withdraw that statement?
No, Lordship.
Then?
Lordship, but if I am not impleaded in this case here in Lordship, the will where this plaintiff is relying upon, she has claimed her right by virtue of will, but the plain schedule is only one property. But the said will includes those property which is a subject matter of 228 also, Lordship.
Yeah, that's okay.
If you Lordship, the years also, that suit was in the year 2014.
How is the plaintiff claiming this property?
Yes, Lordship.
How is the plaintiff claiming?
The plaintiff is claiming because the Chinnapaya's wife, the plaintiff here in his is her sister, Lordship.
Is the wife of Chinnapaya.
Yes, no. Chinnapaya's wife is Lakshmi Devamma. Her sister is plaintiff. She is telling that as they do not have any issue, she has executed a will in her favor.
So please point out what is your relationship with Chinnapaya? On what basis you wanted to come on record?
Brother-in-law is the contention, Lordship. But as the suit is pending there, the suit being pending there, and
that suit is for what?
The suit is for declaration, Lordship.
228.
228 or 14.
That is for what?
That is for declaration and injunction filed by the petitioner herein to declare him as the owner of the property.
That is filed by some Reddappa.
The petitioner herein, Lordship.
Reddappa.
As against the plaintiff, the respondent number 1. She is the first defendant there.
Let us see what you say about your relationship with Chinnapaya in that case.
Brother-in-law is what?
Come to page 40.
Lordship, para number 3, Lordship of page 40. As he is the brother-in-law of the plaintiff.
Then what do you say in the evidence?
For this reason,
That is the
What do you
problem.
say in the evidence?
He's party related, Lordship.
Mate? So what is your right?
Lordship, I'm in possession of the property and all the
You
documents.
protect your possession if you want. If you want, you can protect your possession.
Lordship, all the documents from the year.
No, what the court done is correct.
But Lordship, if I'm not permitted to get myself impleaded in that case, Lordship, as what the respondent number 1 is doing is, the suit filed by the petitioner herein is of the year 2014. There, from 14, she has been dragging the matter, Lordship. Subsequently, in the year 19, she has filed a suit claiming her right only in respect of one item, wherein the will under which she is claiming her right includes a property which is a subject matter of 228,
Lakshmi
Lordship.
Devamma is alive or dead?
She is dead, Lordship.
She is dead.
She was dead even in the time when the suit was filed, but in spite of which she has been made as a party. Their own plaint everments shows the same.
Yes.
Because if she's not dead, then will wouldn't survive at all, Lordship.
Yes, there should be end to litigation, madam. Good.
Lordship, if I'm not permitted to implead myself and the will is...
You file a suit, you protect your possession, do whatever you want. In this suit, you cannot come on record because you are not directly related to Chinnappa.
Yes, Lordship, then I may be permitted in such a case, Lordship. In this case, only if the will is proved, in case in this matter the will is proved, that may be only subjected to the plain property, Lordship, because the will consists of those properties also, Lordship.
We do not know. The suit is in respect of survey number 122.
I will produce the will. I can submit the will, Lordship.
Your suit is in respect of which survey number?
2 survey numbers, Lordship. That is 482 and 483. Those 2 are the properties which are the portion of the property in the will, Lordship.
Correct, but this suit is in respect of 166 of 2019.
122 survey number.
Is in respect of 122.
122. That 122, the will under which is claiming her right in 122, consists of those 2 survey numbers also, Lordship.
The property claimed by the plaintiff
Yes.
is 166.
Under 166, the plaintiff is claiming survey number 122. But the suit which is pending, which is filed by the petitioner, that is survey number 482 and 483, those 2 are also included in the said will where the plaintiff is claiming her right.
That could be, but this suit is in respect of survey number
Only 122, Lordship.
only.
Yes, Lordship.
So I need not have to say it again and again.
But if the will is proved, Lordship,
Madam, if the will is proved, that is only in respect of 122.
that one observation may kindly be given, Lordship.
Observation. Yes.
If the will is proved, my entitled right will be whereof, Lordship, if I'm not impleaded here.
Yes, for the defendant number.
And one more submission, Lordship, the suit OS 228 is already dismissed. And we have filed an RA, which is pending for consideration, Lordship.
The defendant number 6 in OS number 166 of 2019 on the file of the principal senior civil judge and CJM Chikblapura has filed this petition challenging the correctness of an order dated 29/11/2022 by which an application filed by the plaintiff under order 47 rule 1 of CPC was allowed. And the order dated there is the order allowing the application
Page number 63 is a typed copy of the said order.
and the order dated 11/8/2022 allowing IA number
IA5 was the first IA.
IA number 5 was reviewed and recalled. And IA number 5 was rejected. Next para. The suit in OS number 166 of 2019 was filed by the respondent number 1 herein for declaration and perpetual injunction in respect of the land bearing survey number 122 of Jakkalamoda village, Nandi Hobli, Chikblapur Taluk. The respondent number 1 claimed that the suit property belonged to Srimati Lakshmi Devamma. She having acquired it in terms of a sale deed dated 26/10/1962. She claimed that in the revenue records, instead of mentioning the name of Srimati Lakshmi Devamma, the name of Chikkapaya was mentioned.
Chinnappai.
Chikkapaya. Illidan nodi plaint para 3 odi was mentioned instead of Chinnapaya, who is the husband of Srimati Lakshmi Devamma. Full stop. It is contended that Srimati Lakshmi Devamma died on 26/10/2012 and her husband died on 8/2/2011. Issueless. Full stop. Sorry. She died on 26/10/2012 issueless and her husband died on 8/12/2011. Full stop. She claimed that Srimati Lakshmi Devamma had executed a will dated 17/10/2012 bequeathing the suit property and few others in her favor. Full stop. Therefore, full stop. She claimed that the defendants attempted to interfere with her possession in the suit property. And later she came to know that defendants 2 to 5 had jointly obtained obtained a revenue records in their names based on a partition dated 5/4/2018. So the plaintiff therefore sought for the relief of declaration of her title and for injunction in respect of the land bearing survey number 122. Full stop. Later, the defendants 1 to 5 contested the suit by filing their written statement. Full stop. Later, when the suit was set down for evidence, an application was filed by the petitioner herein under Order 1 Rule 10(2) to come on record as a defendant number 6. He contended that he was the brother-in-law of Chinnapaya and that said Chinnapaya was under his care and control. Full stop. He claimed that Chinnapaya bequeathed ಹೆಂಗ್ ಕೊಟ್ಟಿದ್ ನಿಮಗೆ
Oral relinquishment.
Chinnapaya orally relinquished the suit property orally. Full stop. He also claimed that he had filed a suit in OS number 228/2014 in respect of the land bearing survey numbers
482/2 and 483/1.
482/2 and 482/3
483/1, Lodge.
483/1 of Yellampalli village, Kasba Hubli, Bagepalli Taluk. Full stop. He therefore submitted that he was interested in the suit property and hence wanted to come on record. So the trial court, after considering the application and the objections thereto, allowed the petitioner to come on record in OS number 166/2019. Next para. Later, the petitioner adduced evidence in OS number 228/2014. Full stop. In his evidence, he deposed as follows. Double inverted comma. Chinnappa, ಈತನು ನನಗೆ ದೂರದ ಸಂಬಂಧಿಕನು ಆದರೆ ಯಾವ ರೀತಿ ಸಂಬಂಧ ಅಂತ ನನಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ. Full stop. Therefore, the plaintiff in OS number 166/2019 filed an application under Order 47 Rule 1 of CPC to review the earlier order permitting the defendant number 6 to come on record. Full stop. In the objections to this application, comma, the defendant number 6 did not deny the aforesaid evidence adduced by him in voice number 228 of 2014. Full stop. It is the trial court therefore was convinced that the defendant number 6 / petitioner herein was not the brother-in-law of Chinnapaya and therefore was not entitled to come on record in the suit filed in OS number 166 of 2019. Full stop. The trial court therefore allowed the application and reviewed its earlier order permitting the petitioner to come on record in the suit as defendant number 6. Being agreed with said order, this petition is filed. Next para. The learned counsel for the petitioner submitted that the petitioner was the brother-in-law of the deceased Chinnapaya. She submitted that based on the oral relinquishment of by Chinnapaya, the petitioner was in possession of the land bearing survey numbers 482/2 and 483/1. Full stop. He submits. She submits that since the petitioner was the brother-in-law of the deceased Chinnapaya, and since the will under which the plaintiff was claiming in OS number 166 of 2019 covered not only the land bearing survey numbers 122, but also the land bearing survey numbers 482/2 and 483/1, he was a proper and necessary party to establish that the will was not properly executed, validly executed. Full stop. She therefore contends that the impugned order passed by the trial court is without reference to the properties bequeathed and allegedly bequeathed under the will propounded by the plaintiff in OS number 166/2019. Next para. I have considered the submissions of the learned counsel for the petitioner. I have also perused the plaint in OS number 166 of 2019, OS number 228 of 2014, as well as the orders passed by the trial court, which are impugned in this petition. Next para. The suit in OS number 166 of 2019 was filed for declaration of title of the respondent number 1 in respect of the land bearing survey number 122 of Jakkalamadu village. Under the will dated
17/10/12, Lodge. 17/10/2012.
17/10/2012. Full stop. The defendant number 6 / petitioner herein sought impleadment in the suit claiming to be the brother-in-law of Chinnapaya. Full stop. The plaintiff in the suit was the sister-in-law of Chinnapaya. Full stop. Therefore, the court, by accepting the claim of the petitioner that he was the brother of Chinnapaya, felt it appropriate to implead him, as he also had a covetable interest in the property. Full stop. Later, in the suit filed by the petitioner in OS number 228 of 2014, the petitioner categorically stated in his evidence that he was not related to, that he was related to Chinnapaya distantly. Full stop. He did not claim that he was the brother-in-law of Chinnapaya. Therefore, he was not interested in the outcome of the suit filed by the respondent number 1 in OS number 166 of 2019. The trial court has considered the same and has rightly held that the order permitting the petitioner to come on record in the suit filed by the respondent number one deserve to be reviewed and recalled. There is no error committed by the. trial
Lordship,
court
but my
in doing so.
possession may not kindly not be affected due to the same lordship.
If the petitioner is in possession of the land bearing survey number 482/1 and 483/1,
482/2 lordship.
so and so, he is entitled to protect his possession in accordance with law.
Grateful lordship.
Serial number 52 on Monday. 42.
52.
42. On Monday, Lord, because afternoon session I have in Harvard VC.
Come back. The matter is listed, you moved it.
Please.
Come back. Yes, Mr. Votes.
Please again, my lord.
Apologies, sir. ನಾನು ಹೇಳೋದಷ್ಟೇ. We are doing
Second
some
list in the
serious
first list,
business.
second list in the first list, ಅದಕ್ಕೆ I made is interrupted the court.
Okay, you can
But,
wait for some time.
Serial number, list number 2, serial number 8. I was told to have the copy served on the advocate who is representing the respondent in the trial court. It's already been served and memo is filed to that effect.
ಇದೆಯಾ?
ಇದೆ sir. If memo is filed on 19th of August 2024.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ?
Monday, it will be taken up on Monday, madam.
Monday.
Grateful, my lord.
To serial number 7, my lord, my instructions are that your lordship directed me to take instructions immediately. My instructions are that my client herself has refenced it on 29th October with permission of the jurisdictional police, because investigation is over. Investigation is over and the charge sheet is ready. My lord, I'll argue on vacating of the interim order application. Your lordship may have this matter Monday or Tuesday.
Monday. Monday.
ಇಲ್ಲ.
There is no date ಕೊಡಿ. Anyway, now we are in possession.
ವೀರಪ್ಪ.
No threat for your possession. Take whichever date is committed, not Monday.
ಯಾವ ತರ ಒಂದು ಡೇಟ್ ಅದು serial number 7 list 2.
ನೀವು ಹೇಳಿ ಸರ್, ಯಾವತ್ತು Monday ಬೇಡ ಅಂತ.
ಅದು ಮಂಡೇ ಬೇಡ, ಯಾವ ತರ ಶಾರ್ಟೆಸ್ಟ್ ಡೇಟ್ ವೆಕೇಟಿಂಗ್ ಇದೆ ಹಾಕೊಂಡಿದ್ದೀನಿ, ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಹಾಕಿದ್ದೀನಿ.
14th ಕೊಡ್ಲಾ? 14th.
ಆಗಲ್ಲ ಸರ್, ಇದು ವೆಕೇಟಿಂಗ್ ಹಾಕಿದ್ದೀನಿ ನಾನು.
ಮಾತಾಡ್ಕೊಂಡ್ರಿ ಸರ್, ನನಗೆ I don't have any.
ಸರ್ ಆಗಲ್ಲ, 14th ಆಗ್ಲಿ ಬಿಡಿ, ಹಾಕಿದ್ದೀನಿ.
paragraph 20. The Supreme Court in the case of Rallis India Limited also so and so has taken the view that once the vicarious liability of a partner of the firm is specifically made out by an appropriate averment in complaint, then the High Court should not discharge the accused of their vicarious
serial number 39, Lakshmikant K.
For the petitioner in this case. Petitioner are the defendants before the trial court. Suit filed by the plaintiff for possession and other consequential relief. In that manner, they filed IA direction to implead the 5 to 12 and direction for to deposit the rent. On the last occasion,
tenants,
5 to 12 tenants ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. The last occasion directed to produce the photos. In the photos, we have not at all let out the premises for tenant.
ಫೋಟೋಸ್ ಏನಿದೆ ಇದು?
ಅದ
ಎಲ್ಲ ಬಾಗ್ಲು ಹಾಕಿರೋದಿದೆ.
ಬಾಗ್ಲು ಹಾಕಿದೆ.
ಬಾಗ್ಲು ಹಾಕಿರೋದು
ರೆಂಟ್ ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ರೆಂಟಿಗೆ ಕೊಡ್ತಾ ಇಲ್ಲ.
ಹಿಂಗೆ ನೀವು ಬಾಗ್ಲಾಗ ಫೋಟೋ ತಕೊಂಡ್ರೆ ಅದು
ನೆಕ್ಸ್ಟ್ ಫೋಟೋ ಕೇಳಲಿಸಿ ಇವ್ರನ್ನ, ಅದ್ರಲ್ಲಿ ಹುಲ್ಲೆಲ್ಲ ಬೆಳ್ಕೊಂಡಿದೆ.
ಕರೆಕ್ಟ್ ರೀ.
ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಎಕ್ಸ್ಪ್ರೆಸ್
ಹಳ್ಳಿ ಕಡೆ ಎಲ್ಲ ಇರೋದು ಹಿಂಗೇನೆ ಅಂಗಡಿಗಳು. ನಿಮ್ದು ಯಾವ ಊರು?
ಪಾವಗಡ.
ಪಾವಗಡದಲ್ಲಿ ಹೆಂಗಿರುತ್ತೆ ಹಳ್ಳಿ ಅಂಗಡಿಗಳು ಹೇಳಿ? ನೀಟಾಗಿ ಮುಂದೆ ಕ್ಲೀನ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡ್ತಾರ? ಮಾಡುದು.
Year in after at least, if your lordship permits to.
Suit is for what?
Suit for declaration and mandatory injunction also. Page 11. ವಾದಿ ಎ ಮತ್ತು ಬಿ ಹಕ್ಕುದಾರರೆಂದು ನಿರ್ಧರಿಸಬೇಕಾಗಿಯೂ ದಾವಾ ಪ್ರತಿವಾದಿ ಬಿ ಅನುಸೂಚಿ ನಿರ್ಮಿಸಿದ ಕಟ್ಟಡವನ್ನು ತೆರವುಗೊಳಿಸುವಂತೆ ಮ್ಯಾಂಡೇಟರಿ ಇಂಜಂಕ್ಷನ್ ಡಿಗ್ರಿ ಆಕ್ಷೇಪಣಿಸಬೇಕಾಗಿಯೂ ಒಂದು ವೇಳೆ ಪ್ರತಿವಾದಿ ದಾವಾ ಅನುಸೂಚಿ ಬಿ ನಿರ್ಮಿಸಿದ ಕಟ್ಟಡವನ್ನು ತೆರವುಗೊಳಿಸಿದ್ದಲ್ಲಿ ವಾದಿ ನ್ಯಾಯಾಲಯದಿಂದ ಸಹ ಸದರಿ ಕಟ್ಟಡವನ್ನು ತೆರವುಗೊಳಿಸಬೇಕು ಡಿಗ್ರಿ ಆಕ್ಷೇಪಣೆದಾಗಿಯೂ ದಾವಾದ ಪ್ರತಿವಾದಿಯಾಗಲಿ ಆತನ ಕಡೆ ಯಾರೇ ಆಗಲಿ ವಾದಿ ಹಕ್ಕುದಾರಿಕೆ ಮಾಲೀಕ ಒಳಪಟ್ಟ ಎ ಮತ್ತು ಬಿ ಯಾವುದೇ ರೀತಿಯಿಂದ ಪ್ರವೇಶ ಮಾಡದಂತೆ ಶಾಶ್ವತ ನಿರ್ಬಂಧಕ.
ಬಟ್ ಲೆಟ್ ದಿ ಪ್ರಪೋಸ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿಲ್ವಾ?
ಇನ್ನ ಸರ್ವ್ ಆಗಿಲ್ಲ.
ಸರ್ವ್ ಆಗದೆ ಹೆಂಗೆ ಅಲೋ ಆಗುತ್ತೆ?
ಹಂಗೆ ಅಲೋ ಮಾಡ್ಬಿಟ್ಟೆ.
ಎಲ್ಲಾದ್ರೂ ಉಂಟು ನೋಡ್ರಿ.
ಕೈಂಡ್ಲಿ page 27 ಮೇಲೆ ಇಂಪೌಂಡ್ ಆರ್ಡರ್. IF4 and 5 filed by the plaintiff under 1 Rule 10 CPC implead the proper defendant number 5 to 12 and 151 to deposit the advance and rent amount is hereby allowed.
No, but proposed defendants ಗೆ notice issue ಆಗಿದೆ ಇಲ್ವೋ ಹೇಳಿ?
Notice issue, they filed IA, notice issue ಆಗಿದೆ.
Plaintiff has filed this application.
Please.
Whether notice of this application is issued to the proposed defendants.
No notice was issued. So that manner the.
Are you sure?
Issue notice, please. Other the issue summons to the defendant number 5 to 12 with direction to deposit the rent. Other last pair.
ನಾನು ಹೇಳ್ತಿರೋದೇನು, ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ
ನೋಟಿಸ್
ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ವಾದಿಗಳು ಅರ್ಜಿ ಹಾಕಿದ್ಮೇಲೆ ಕೋರ್ಟು ಆ ಅರ್ಜಿ ಮೇಲೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದಾರಾ?
ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದೆ.
ನಿಖರವಾಗಿ ಗೊತ್ತಾ ನಿಮಗೆ?
ಇದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಇಶ್ಯೂ ನೋಟಿಸ್.
ಆರ್ಡರ್ ಅಲ್ಲಿ ಬಿಡ್ರಿ,
ಗೊತ್ತಿಲ್ಲ ಸರ್.
ಆಫ್ಟರ್ ದಿ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ ದ ಕೋರ್ಟ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಸಮನ್ಸ್.
ಪ್ಲೀಸ್,
ನಾನು ಕೇಳ್ತಿರೋದು
ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ಬೇಕಾದ್ರೆ
ಆಫ್ಟರ್ 1 Rule 10 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ಮೇಲೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
ನೋ ನೋಟಿಸ್ ಇಶ್ಯೂ.
ನಿಮ್ಗೆ ನಿಖರವಾಗಿ ಗೊತ್ತಾ?
ಪ್ಲೀಸ್, ಇನ್ ದ ಆರ್ಡರ್ ಶೀಟ್ ಇಟ್ಸೆಲ್ಫ್. ನೋ ನೋಟಿಸ್ ಇಶ್ಯೂ.
ನಿಮ್ಗೆ ಆರ್ಡರ್ ಶೀಟೇ ಇಲ್ಲ, ಹೆಂಗ್ ಗೊತ್ತು ನಿಮ್ಗೆ?
ಪೇಜ್ 29 ಅಲ್ಲಿ
ನೋಡಿ ಎಲ್ಲಿದೆ.
IA number 5 call on for orders. Power for defendant number 5 and objection to IF4.
Please check ಮಾಡಿ. Learned counsel for the petitioner is directed to ascertain whether notice was issued to the proposed defendants on IA number 5.
Please.
On IA number 5. ಯಾವತ್ತು ಹೇಳ್ತೀರ?
Tomorrow
ನೀವು ಒಬ್ಬರೇ ಬರ್ಬೇಕು.
Monday.
ಯಾವತ್ತು? Tuesday, Wednesday.
Wednesday 13th March.
12th ಕೇಸ್ ಇದೆ, ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್.
ನೋಡೋಣ. Yes, next.
12th ಅಲ್ಲಿ at least.
40 ಕಲ್ಯಾಣ.
12th ಮೇಲೆ. 12th at least.
12th ಆಗುತ್ತೇನ್ರಿ? ನೋಡಿ ಎಷ್ಟಿದೆ, ಜಾಸ್ತಿ ಇದೆ, ಜಾಸ್ತಿ ಇದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ at least no, I may be directed to serve the copy to the other side.
Correct. 13th ಬರ್ಲಿ, yes, 13th page. Kalyan R.
Serial number 40, Kalyan R.
There is no representation for the petitioner. It's not on the long date. It's Rajendra KR, 28th November.
Serial number 41, Rajendra KR.
Petitioner.
Maybe please, my lord. So this writ petition filed against the orders passed by the as against the annexure L liveran. That is
not
the
Rajendra.
Yes. Both are on record.
Yes.
As against the annexure L, my lord.
Suit is for? What is the suit filed for?
Suit for partition in initial stage, my lord. Then after the suit was dismissed, Your Honor. So we are illi petitioners 1, 2, 3 are not arrived any party in original suit or RFA, Your Honor, my lord.
ಇದೊಂದು ರ್ಯಾಂಕ್ ಆಫ್ ಪಾರ್ಟೀಸ್ ಅಲ್ಲಿ FDP ಕೋರ್ಟ್ ಅಲ್ಲಿ 32 ಅಂತ ಮಾಡಿದ್ದೀರಾ? ಹೇಳಿ.
So ಇಲ್ಲಿ suit for partition against the wrong persons, my lord. ನಮ್ಮ ತಂದೆ ಹೆಸರು ಡಿಫೆಂಡ್ ನಂಬರ್ 10 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಬಟ್ ಕೈಯಪ್ಪ ವಾಸ್ ಡೆಡ್ ಅಂತೂ ಕೂಡ ತೋರಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಮತ್ತು ಅದರಲ್ಲಿ ಒಬ್ರು ಕೈಯಪ್ಪ ಡೆಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾರನ್ನೋ ಬೇರೆಯವ್ರನ್ನ ಕದಿರಮ್ಮ ಅಂತಕ್ಕಂಥವ್ರನ್ನ ಎಲ್ಲಾರ್ ಆಫ್ ದಿ ಕೈಯಪ್ಪ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ಬಟ್ ಅವ್ರು ಹಾಕಿರ್ತಕ್ಕಂಥ ಜಿನಾಲಜಿಕಲ್ ಟ್ರೀಲೇನೆ ದಟ್ ಜಯಮ್ಮ ಇಸ್ ದಿ ಮೈ ಮದರ್ ಇವರ್, ಮೈ ಮದರ್ ಆಲ್ಸೋ ಡೆಡ್, ಮೈ ಲಾರ್ಡ್. ಸೊ ಆಫ್ಟರ್ ದಟ್ ನಮ್ಮನ್ನಲ್ಲಿ ಪಾರ್ಟಿನೇ ಮಾಡಿಲ್ಲ. ಮತ್ತು ಅದಾದ್ಮೇಲೆ FDP ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ನಮ್ಮ ನೋಟಿಸ್ ಬಂದಾಗ ಐ ಕೇಮ್ ಟು
ನಿಮ್ಗೆ ನೋಟಿಸ್ ಬಂತು FDP ನಲ್ಲಿ?
ನೋಟಿಸ್ ಬಂದ, ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ನೋಟಿಸ್ ಬಂದಿಲ್ಲ. ಬಟ್ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬಂದಾಗ ಅವಾಗ ವಿ ಕೇಮ್ ಟು ನೋ ದಟ್ ಇವರ್ ಆಲ್ ದೀಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ದೆನ್ ಇಮಿಡಿಯೇಟ್ಲಿ ವಿ ಕಲೆಕ್ಟ್ all the papers and prepared revision petition, my lord. After that, in the revision petition, Honorable Court, we withdrawn that review petition as per.
So this judgment was called in question in RFA.
RFA, yes.
RFA ಏನಾಯ್ತು?
RFA allowed ಆಯ್ತು ಸ್ವಾಮಿ, ಬಟ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟರು ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಡೈರೆಕ್ಷನ್ in page 133, my lord.
Yes.
So ಇಲ್ಲಿ 133 page ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು, for the reasons stated in the judgment and while allowing the regular first appeal, it is ordered and decreed that judgment and decree passed by the trial court is hereby set aside. The suit of the plaintiff is decreed as prayed for the declaring that plaintiff are entitled to off share in the suit scheduled properties,
Yes.
which are subject matter of the grant to extent shown in the said grant ಅಂತ ಹೇಳ್ತು ಸರ್. ಬಟ್ ಇಲ್ಲಿ ಅವರು ಪ್ಲೈಂಟ್ ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ ಡಿಫರೆಂಟ್ ಇತ್ತು, ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಅಲ್ಲೇ ಡಿಫರೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. ಎಕ್ಸ್ಟೆಂಟ್ ಇಸ್ ನಾಟ್ ಟ್ಯಾಲಿಡ್ ವಿತ್ ದಿ ಪ್ಲೈಂಟ್ ಅಂಡ್ ಗ್ರಾಂಟ್ ಆರ್ಡರ್. ಇವರನ್ನು ಪ್ಲೈಂಟ್ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿಗೂ ಡಿಫರೆಂಟ್ ಇತ್ತು. ಆನರಬಲ್ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟ ಮೇಲೆ ದೇ ಆರ್ ನಾಟ್ ಕ್ಯಾರಿಡ್ ಔಟ್ ದಿ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ, ಮೈ ಲಾರ್ಡ್, ವಿತೌಟ್ ಕ್ಯಾರಿಯಿಂಗ್ ದಿ ಶೆಡ್ಯೂಲ್ಡ್ ಪ್ರಾಪರ್ಟಿ. ಆಮೇಲೆ ನಮಗೆ ಬಂತು, ಎಸ್ ನಾವು ಡಿಫೆಂಡ್ ನಂಬರ್ 10 ಅವರ ಮಕ್ಕಳಿದ್ದೀವಿ, ಹೆಂಡತಿ ಮಕ್ಕಳಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೂಡ ಹಾಕ್ಕೊಂಡ್ವಿ ಸ್ವಾಮಿ. ಇಂಪ್ಲೀಡ್ ಅಪ್ಲಿಕೇಶನ್ 1-10 ಅಪ್ಲಿಕೇಶನ್ FDP ಅಲ್ಲಿ ಹಾಕ್ಕೊಂಡ್ವಿ. ಅದಾದ್ಮೇಲೆ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ ಕೂಡ ಫೈಲ್ ಮಾಡಿದ್ವಿ. ಅವರ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್ಡ್ ಬೈ ದಿ FDP ಕೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್. ದೆನ್ ವಿ ಕೇಮ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಇನ್ WP, ಮೈ ಲಾರ್ಡ್, ಆಸ್ ಪರ್ annexure G, page number 136, ಇದರ ಪ್ರಕಾರ ಬಂದಿವಿ ಸ್ವಾಮಿ. This honorable court directed to FDP court consider our objection, my lord. But FDP court is not consider our any objection, my lord. Without considering our objections, pass the impugned order as annexure L, my lord. So ಈ annexure ಎಲ್ಲಲ್ಲೂ ಕೂಡ ನಾವು ಲೀಗಲ್ ಏರ್ಸ್ ಇದೀವಿ. ಇಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 10 LRs ಅಂತಾನು ತೋರಿಸಿಲ್ಲ. ಮತ್ತು ಇಲ್ಲಿ 32 to 34 ಪಾರ್ಟೀಸ್ ಇರ್ಬೇಕಿತ್ತು ಸ್ವಾಮಿ. ಇನ್ ಪೇಜ್ ನಂಬರ್ 169 my lord.
ಮತ್ತೆ ನೀವು RFA ಹಾಕೋಬೇಕಲ್ವಾ?
RFA ಅಂದ್ರೆ ಈಗಾಗಲೇ RFA ಆಲ್ರೆಡಿ ಕನ್ಸಿಡರ್ ಆಗಿರೋದ್ರಿಂದ.
ಅಲ್ರಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಮೇಲೆ RFA ಹಾಕೋಬೇಕಲ್ವಾ?
ಇಲ್ಲಿ ನಮ್ಮ ಆರ್ಡರ್ ಇದು ನಮ್ಮ ರಿಟರ್ನ್ಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆರ್ ನಾಟ್ ಕನ್ಸಿಡರಿಂಗ್ ಅಂತ ಹೇಳಿ.
But then the court has directed a final decree to be drawn.
Yes,
Commissioner's report accept ಆಯ್ತು, ಫೈನಲ್ ಡಿಗ್ರಿ ಡ್ರಾ ಮಾಡಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ, ಫೈನಲ್ ಆರ್ಡರ್ ಮಾಡಿರ್ತಕ್ಕಂಥದ್ದು ಸರಿ ಇಲ್ಲ ಅಂತ ನಮ್ಮ.
ಸೊ ಅದಕ್ಕೆ ನೀವು ಎಲ್ಲಿ ಹಾಕ್ಬೇಕು? ರಿಟ್ ಪಿಟಿಷನ್ ಅಥವಾ 96 ಅಲ್ಲ?
96 ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ ಸ್ವಾಮಿ, ಬಟ್ ಆಫೀಸ್ ಇಸ್ WPL ಹಾಕಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಎಲ್ಲಿದೆ ಎಲ್ಲ ಹಾಕಿದ್ರಿ? RFA ಎಲ್ಲ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲೇ ಹಾಕಿದ್ವಿ.
RFA ಹಾಕೋಬೇಕಲ್ವಾ ವೆಂಕಟೇಶ್?
ಇಲ್ಲ, RFA ಇದಕ್ಕಿಂತ, ಯಾಕಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋ ಇದ್ರ ಮೇಲೆ
ಅದನ್ನೇ RFA ಹೇಳಿ ಅಂತ ಹೇಳ್ತಿರೋದು. Now the commissioner's report is accepted.
Yes.
Final decree is ordered to be drawn.
Yes, sir.
So therefore the proceedings are disposed of.
Yes, my lord.
So you have to file an RFA.
ಸೊ ಇನ್ನೂ ಫೈನಾಲಿಟಿ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಬರೀ ಆರ್ಡರ್ ಆಗಿದೆ, ಬಟ್ FDP ಡ್ರಾನ್ ಫೈನಲ್.
Commissioner's report accept ಮಾಡಿದ್ಮೇಲೆ nothing remains.
Yes, my.
ನೋಡ್ಕೊಂಡು ಬನ್ನಿ.
Please.
Work. After hearing the learned counsel for the petitioner, it is seen that the petitioner is challenging an order by the FDP court accepting the report of the commissioner and directing a final decree to be drawn as per the report of the commissioner. The learned counsel for the petitioner is directed to verify whether an appeal under section 96 of the Code of Civil Procedure is maintainable. Based on yavat week?
Next week any date.
Date kuli yavattu? Samir Pasha.
19th September, 19th November, serial number 42, Jamir Pasha.
Shankar Reddy.
Lord, a suit for partition was filed by the petitioner. Please, Lord. Lord, the petitioner before your lordship initiated a suit for partition. Lord, in the partition suit, Lord, there were altogether 6 items. Lord, all purchased by the father of the petitioner. But during his lifetime. Lord, he died intestate. And Lord, subsequently the devolution opened. Lord, my another sister, who is respondent number 3, had filed a similar suit, Lord, in OS number 173 of 2018. Lord, one application came to be filed in that OS, Lord, because one of the item property was acquired by KIDB for Metro. Lord, because of, after the demise of the father of the petitioner, that compensation award amount, Lord, was given in the name of defendant number 1 mother. Lord, that suit was settled by the brother by paying her the share. Lord, he denied me the share. I initiated a separate independent suit. Lord, I also filed a similar application, Lord, in page 67 is my application. And Lord, the order, Lord, in the sister's suit, which was, Lord, directing the defendant number 1 mother to deposit the money, was assailed before this honorable court. Lord, page 100, Lord. First, I will take your lordships to that order. Page 100. A similar order was challenged. Lord, it was, in fact, dismissed. That trial court order is right. You deposit the money. Order dated 2 June 2022. Lord, I'll take your lordships to, Lord, the operative portion in para 8, page 104. Lord, it is the case of the petitioner that he is the lawful owner of item number 2. It is the case of the respondent number 1 that item number 2 is purchased by his father by paying consideration amount. In order to establish whether the suit property is self-acquired property of the petitioner or whether the property was purchased by the father of respondent number 1 is a matter which requires trial. As observed above, The petitioner, without disclosing about the pendency of suit, has withdrawn the compensation amount to deprive the legitimate right of the respondent number one. If direction is not issued, then the petitioner may misuse the compensation amount and respondent number one may not be in a position to recover the said amount. In order to protect the interest of both the parties, the trial court was justified in passing the impugn order. Hence, I do not find any ground to interfere with the impugn order. Lords, I am situated similar to my sister. Lord, I filed a similar application. Now, please turn to Annexure A, page 24. Lord, page 25, the impugned order. Lord, without looking into any of the documents, in fact, the order of this honorable court, Lord, a non-speaking order is passed. Page
No,
25.
anyway, now the court has directed the amount to be deposited.
That suit was settled. That was another suit filed by my sister.
In OS number 25145.
Lord, that is the present suit. That is my suit. Subsequently filed, my lord, after that suit was
This is the
settled.
other suit, 1732.
Yes.
It was settled by
yes,
your brother.
It was settled.
Ah. And
Lord,
what
in
happened
fact,
to-
I was assured that my share will also be given in that suit itself.
Hmm.
But Lord, it was not.
So your application is rejected.
Please, Lord, please see the order, page 25.
Oh.
Learned counsel for the plaintiff files IA under section 151 of CPC to direct defendant number one to deposit the compensation award amount of so and so received in respect of item 2 property. Proper forum to for adjudication of entitlement of compensation in land acquisition is different. Hence, IA is rejected. That was not the subject matter at all.
Yes.
Because the
Now your
compens-
brother has received the entire money.
Yes, mother and brother-in-law, they are enjoying.
They have received it?
Yes.
Lord, what happened was, the third respondent, my lord, in the first instance, files a suit, my lord, for the relief of partition. The present petitioner, my lord, was also a party, my lord, in the previous suit for partition. Very same properties, my lord. And during the pendency of the said suit, not one of the lands, item number 2 came to be acquired. Not the ground on which, my lord, on the previous round of litigation, it was directed to be deposited was that a suit is pending. Without disclosing the suit, you have taken the money. Therefore, redeposit the amount before the court was the order passed. Subsequent to such an order, we have settled the claims of both the parties. They have allowed the suit to be withdrawn. Subsequently, my lord, at a later point of time, she, my lord, without, if it is the case, my lord, that there was a promise and terms of the settlement has not been complied with, she has to open the previous suit. She can't file a separate suit. If she says that in the previous suit, when settlement was arrived at, a fraud has been played on her, then it is in the same suit, my lord, order 23 rule 3A, she has to invoke and now she files a fresh
Want
suit.
to settle it?
My lord,
Please
it
settle
has
it.
been settled, my lord. It has
What
been
about
settled.
this petitioner?
Petitioner also.
Yen-
Petitioner was also a party in the previous
Whether
suit.
any money was paid to her?
He was paid.
ಏನಿದೆ?
That is the reason, my lord, why she did not object for at the time of compromise.
No, what is there to show that you paid her money? ಏನಾದ್ರು ಬೇಕಲ್ಲ?
That, my lord, I'll
I
ascertain.
can't, we can't allow these cases to be dealt on technicalities.
My lord,
She is entitled for a share, she should be given her share.
my lord, the previous round of litigation, why it was ordered to be deposited was, court said at this particular point of time, we can't take a decision whether it is a joint family property or a self-acquired property. However, compensation has been withdrawn during the pendency of the suit. But that is not the present situation, my lord. And when my sister settled the
Even
issue,
otherwise, now she has filed a suit for partition
please, my lord,
in respect of that amount also.
that amount she has
Yes.
not in.
Item number 2.
If that is the case, you can't be using that money. Either you deposit at least her share.
Your lordships may kindly turn to the schedule. The money that has been received,
Item number 2 is, my lord, the account of defendant number 1. It is very similar to the suit of my sister. my lord.
and insofar as the prayer is concerned, my lord, mother has received the money according to them. And it has been shown as, my lord, the account details has been
Now,
furnished.
whether this amount is still lying in the account,
It is still in the account.
then we'll direct see this account to be frozen.
My lord, I will make one effort, my lord, to see whether they have taken any documents, my lord, while settling the previous case. If, my lord, such an order is not passed, and your lordships would
It's
also
okay,
appreciate.
but now that he says that the amount is still lying in the account, let the account be frozen.
For day-to-day maintenance also, I will
Yeah,
not be able
you
to
take
use any money.
you take your share, deposit her share. subject to the outcome of the suit.
But if she has already received in the previous round of litigation,
Adana you establish it. Adikén documents ilvalla.
But in fact,
documents return statement ಹಾಕಿದ ತಕ್ಷಣನೇ ಅವರು application ಹಾಕಿದ್ದಾರೆ. And the trial court has not given time to file objections also. On the very same day, when the application came to be
Well,
filed.
please check what is it you want to do.
But I
Either
would
you
only say-
deposit her share or will direct this account
But I
to.
would make a statement before the court, not if the amount has been settled, if there is something in writing which discloses that petitioner has also received some money in the previous round of litigation, that I will submit. Otherwise, my lord,
Party, until then we'll freeze the account. Until then,
my lord, I do not know what is the balance that has been left.
whatever is there, ಏನಿದೆಯೋ ಅದು.
please.
ಬರ್ಕೊಳ್ಳಿ. The dispose ಮಾಡೋದ ಪೆಂಡಿಂಗ್ ಇಡ್ಬೇಕಾ?
Pending it. Otherwise, I will not have to take instructions and place on record.
After hearing the learned counsel for the petitioner and the learned counsel for the caveat respondents 1 and 2, this court is of the opinion that the amount lying in the account of the respondent number 1.
Please.
In which bank? Syndicate Bank.
State Bank of India ಅಂತ account extract ಹಾಕಿದ್ದಾರೆ.
Syndicate SYNB ಅಂತಿದೆಯಲ್ಲ. IFSC code is SYNB.
Not
Our
Syndicate
statement
Bank,
of account.
Syndicate Bank is now merged with
Syndicate Bank is merged with Canara Bank,
Canara Bank.
not State Bank of India. The account may not extract that has been produced before the court along with the writ papers. Your lordships can find at page 108. They have produced an account extract of a different bank, which discloses that it appears a sum of rupees 5 lakhs is available in that account, according to them.
108.
ಎಲ್ರಿ ಇದೆ?
ಇದು ಹಳೇದು
Page
ಇದು.
107,
Lord.
108.
This I have furnished to show that the rent from the property was collected.
ಆಯ್ತು, ಇವಾಗ ಯಾವ ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಮಾಡ್ಬೇಕು ಹೇಳ್ರಿ?
But
Regarding
the-
that, they have not
in
produced documents.
106, my lord, page 106. Canara Bank. 106, my lord.
What is available, my lord, is 1,84,000.
Huh?
What according to them, my lord, is available in the mother's account is 1,84,000.
No, that is not the mother's account. That was some other person's account where, my lord.
You please give in a piece of paper which account you want to be.
Lord, page 106, please. ಅಲ್ಲಿ ಮೇಲೆ first is in small letters, my lord, Canara Bank, Fraser Town, Bangalore.
Correct.
It is.
Account number?
Account number is, my lord.
Below that account number and current customer ID number is there.
Lord, in the bottom column.
This stands in the name of Zahida Begum.
She is the respondent number 1 mother.
You want this account to be frozen?
Please.
At Canara Bank, Fraser Town branch. In account number 04102010019808. It has to be frozen to secure the interest of the petitioner pending disposal of this writ petition. In that way of the matter, the amount lying in the account of the respondent number 1 at Fraser Town, Canara Bank, Fraser Town branch, Bangalore. Bracket account number 04102010019808 is ordered to be frozen until further orders.
Till next date.
Until next date. ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ? List on.
ಒಂದು ವಾರದೊಳಗಡೆ ಯಾವುದು?
On date, or whichever date you want.
ಒಂದು 20ನೇ ತಾರೀಕು ತಮಗೆ ಅನುಕೂಲ ಇದ್ರೆ.
20th, huh? 20th.
21st, my lord.
Whichever date you.
Please. I'm grateful.
Girish NR.
Serial number 43, Girish NR.
It's a suit for partition. Where the impugned order is on application which is allowed for inclusion of a property under Order 6, Rule 17. The property is a
This
self-acquired property.
application is filed by whom?
Application is filed by the plaintiff. I am defendant number,
What stage you filed this? At what stage of the suit?
it is at the stage of evidence,
Whose evidence?
for plaintiff evidence.
You should
Well,
have-
what has happened is, there was a suit, this suit is of 2004, where it was, the judgment was passed in 2015. And similar application was filed before that judgment. In 2015, same property was proposed to be included, that application was dismissed. Later, when the judgment on the appeal, when the suit was restored, they have filed similar application for inclusion of the same property.
Which is that suit, earlier suit?
Same suit, it was decreed in 2015. Thereafter, they had preferred an appeal because the suit was dismissed. And in the RA, it was restored, remanded back to the trial court for fresh this one. And again, they file a similar application for inclusion of the property. I may take your honors to page 30 of the affidavit, the application, along with the application which they have filed. They have stated that in third para. Further, I had maintained the application earliest in this case, and the same is not taken into consideration and passed the judgment against which I preferred an appeal, and the matter remanded back by the appellate court. But this is not true. It is a false statement, because IA number 8, which they had filed to include this property, was already dismissed by the trial court before this judgment, earlier judgment. And again, an application
Where is
not
the order
maintainable.
dismissing?
My lords,
Where is the order dismissing the
yes, my lord.
application on the earlier occasion?
My lords may take to page 13 of the impugned order. The previous application, IA number 8, was dismissed on 12/8/2015. It finds a place in the impugned order. Thereafter, the judge may not record any reason why a similar application is rejected there and why it is allowed, why it needs to be allowed. There is no reason.
Where is that order 12/8/2015
since
not
it-
released?
Since it is admitted the fact that it's a part of record.
You
I'm
know
not
it,
sub-
the other
Please.
side, but I don't know it.
But it is on part of record where the
Correct,
judges
Mr.
are.
I should know it.
Please, ma'am, I'll submit.
Learned counsel for the petition is directed to place on record. Order dated 12/8/2015, passed in OS number 333 of 2004.
Yes.
2004 suit.
Yes, my lord. Next week,
ಯಾವತ್ ಬೇಕು?
14th,
14th ಆಗಲ್ಲ. ಎಷ್ಟು ಯಾವತ್ತಿದೆ ನೋಡ್ರಿ.
13th.
Mr. R. Kiran.
21st.
Great.
Serial number 44. R. Kiran.
R. Kiran.
No, my lord.
You ready?
Yes, my lord.
My lord, in the last occasion, I was asked to file a list of dates in the matter.
Yes, please.
Your lordship, even I'm filing the list of dates. I'm also filing the list of dates.
Sure. No. Yes. Whose list of dates you want me to refer to?
I think.
Okay, I'll first refer to your list of
Please,
dates.
my lord. My lord, this petition has preferred silencing the order of the Honorable Trial Court, taking the written statement to the counterclaim on record that was filed beyond 120 days, my lord. My lord, I'm the defendant before the trial court. I have filed my written statement along with the counterclaim on 24/6/2023, my lord.
24?
24/6/23.
WS with counterclaim.
Yes, my lord.
Hmm.
My lord, on 1/7/2023, written statement and the counterclaim was rejected by the trial court. On the ground that, my lord, that was filed beyond 120 days. Thereafter, the respondent has we have preferred the writ petition challenging that order, my lord. Accordingly, the Honorable High Court takes on record the written statement stating that it was not beyond 120 days.
Yes.
My lord, in that this Honorable High Court has also directed the trial court to take on record the written statement and the counterclaim, my lord. Accordingly, the trial court takes the written statement and counterclaim on 14/7/2023. My lord, thereafter, on 4/8/2023, the trial court fixes the stage for the respondent to file rejoinder or written statement to the counterclaim.
Yes.
My lord, in the meanwhile, challenging the order of this Honorable Court in writ petition, the respondent prefers SLP before the Supreme Court challenging the order, my lord. The Honorable Supreme Court asked the respondent to file a review petition before this Honorable Court. Accordingly, review petition was filed before this court. In the review petition, this Honorable Court confirms the order in the writ petition dated 10/7/2023, taking the written statement on record, that saying that there was a moratorium, my lord. Because of the moratorium, the written statement was not filed within 120 days. So as soon as the moratorium period was ceased, the written statement was taken on record and it was filed, my lord.
Yes.
On 31/2024, this High Court confirms the order of the writ petition, my lord. My lord, on 24/2024, the respondent, along with the memo, files objection to the written statement to the counterclaim.
On what date?
24/2024.
24/24.
Yes, my lord.
He files objections to the counterclaim.
Yes, my lord.
Hmm.
My lord, in the meanwhile, my lord, after this Honorable Court dismissed the review petition, I had preferred an application before the trial court on 14/2/2024 to decree the counterclaim, contending that they have not filed the written statement to the counterclaim within 120 days.
Yes.
Accordingly, the trial court dismisses the application and posted the matter for issues, my lord, closing the stage for the respondent to file written statement to the counterclaim. My lord, thereafter, on 31/5/2024, respondent before the trial court seeks time to file necessary applications. On 6/6/24, they file an application for recall and reopen to take their written statement to the counterclaim on record. Accordingly, the Honorable Trial Court on 18/7/2024 allowed the applications taking the written statement to the counterclaim on record, my lord.
Yes.
Your lordship, as per Order 8, Rule 1 of CPC.
Okay.
Yes.
I'm not disputing the dates, my lord. My contention is this, my lord, that when the course of the whole case was going on, the order of this Honorable Court was passed on 31/1/2024, my lord, which is not disputed. The copy of that order, in fact, my lord, was released on, I applied for the order in February, my lord, of 24.
No, but how does it matter? You knew that the review petition was dismissed.
Yes, my lord, but the point in contention was that whole aspect that I wanted to challenge it, what is the order was to be looked into. That was released only in the month of April.
So that means to say that you waited for the review petition copy to be released and only then you thought of filing the statement.
Yes, my lord.
That's a justification.
No, that is not the justification, my lord, but the fact matrix is this.
No, but how does it see? If the court has fixed a date.
No, court had not fixed a date, my lord.
14/8/2023. 4/8/2023 was the date fixed for filing the statement.
My lord, that was the next date of, the date was fixed, yes, but in terms of, there is no specific date fixed by the court, my lord.
He says the date was fixed on 4/8.
Your lordship finds that order at Annexure E, my lord. Annexure E. Page number 55.
Annexure?
E, my lord, page number 55.
Yes.
Yes, my lord. But my contention is, my lord, for the application filed, a reason order has been given by the trial court, which is before challenged before this court. And my contention is issues have been framed, and I've also led evidence on
I'm
all
not
these
on
issues.
that. Whether you file the statement within the time fixed by the court, number one. Number two, whether you file the statement within that 120 days
No, my
from
lord,
the date of.
I've not filed my.
So
that.
what should be the justification? How do you justify that?
My justification is this, my lord. The case was in continuance. I was following up with the court. I have filed a necessary application which has been allowed by the court by a reasoned order.
Yes.
My contention is that I'm relying on Order 8, Rule 3B, my lord. Where, and sorry, Order 8, Rule 6A 3.
Yes. Please read.
Yes, my lord. Plaintiff shall be at liberty to file written statement in answer to the counterclaim of the defendant within such period as may be fixed by the court.
So where is the time period fixed?
It was in the next date, my lord. Yes, but if you consider the fact that 120 days have been, even after that I've lapsed, I filed a necessary application to that effect, which the court has allowed me.
How can the court allow is what I'm asking you? That is a contention. That
Yes.
is the reason why you are before this court.
Yes, my lord.
See, for a written statement to be filed in the ordinary course, it is 120 days.
Yes,
Now, there is slight distinction when it comes to a counterclaim,
yes,
because counterclaim Order 8 Rule 6A3
yes,
says such time as fixed by the court.
yes.
Correct?
In general course of action, that's the next date in general.
Not general course of action. It says as
No,
may be fixed by the court.
I understand, madam. The statute is very clear on that particular fact. In fact, that is what I have relied on before the trial court. The trial court has accepted my finding, my argument before the court. A reason order has been passed.
Correct. Reasoned order is not correct is what I'm telling you.
Because we have relied on judgments as well, my lord, where in the case before the trial court, judgment, if I can.
See, the proceeding is before the commercial court.
Yes, my lord.
So every bit of CPC has to be strictly applied.
Yes, yes, my lord.
Correct.
We have relied on judgment. It is not strict on law. Judgment of the court also has been relied upon.
Yes.
And that has been replicated in the order as well.
What is the stage of the case?
It's now for plaintiff's evidence, my lord. Plaintiff has led evidence. Certain application has been filed for summoning of documents, which has been adjourned by the petitioner's side.
What is the counterclaim made?
My lord, counterclaim, our goods are in their possession, my lord. They are the carriers. Our goods was not released to us, my lord, on the alleged ground that we have not cleared their invoices. So we have sought around 75,000, my lord. My lord, 74 lakhs, sorry, my lord, 74 lakhs.
Then how about imposing some exemplary costs? That is the only way out, otherwise we can't.
Reasonable cost may be imposed.
Reasonable.
My lord.
Commercial contracts.
One submission, my lord. My lord, as per Order 8, Rule 6G, the rules relating to the written statement is clearly applicable, my lord. In that situation, their
Madam,
written
the
statement
suit is still in the infant stages. The suit is still in the infant stages.
Yes, my lord.
It is still in the infant stages. I have no doubt what you say is right. Commercial courts only, we can't extend the time for filing the statement. No dispute about that. That is a position of law also.
Yes, my lord.
But still, since the suit is still in the infant stages, why can't we impose some cost and be done with it? No.
Cost may be imposed, reasonable cost, my lord. That's my only.
No, not reasonable. It's a
Looking
commercial.
at the facts and circumstances of the case, my lord, that's my, cost may be imposed. I leave it to the discretion of the court.
See, otherwise they're entitled for a decree.
My lord, the
They're
fact.
entitled for a decree. Don't forget.
No, I understand, my lord, but the point is, it's an exaggerated claim, my lord, which needs to, it's a which needs to be probed by the court.
He's right.
I leave before to this court, my lord. My only request is a reasonable cost. my lord.
Yesterday, let us see how reasonable you can be.
Maybe about 10,000 rupees would be reasonable, my lord.
You are VHVK Associates.
I'm from
No, no.
VHVK, na? Aditya D.
Yes, madam.
ಹೇಳಿ ಎಷ್ಟು ಅಂತ ನೀವೇ ಹೇಳಿ
10,000 rupees would.
10,000 ಅಲ್ಲ it's a flea bite. 10,000 is a flea bite. Come up with some decent
I
figure.
think that is reasonable, my lord. Considering we have also at loss, we have not. We've been see, if the suit has been filed in 2023. We also not got our monies. And counterclaim is maybe an arm twisting mechanism. That is my whole case.
They have preferred and they have challenged it before the Supreme Court and the review
25,000.
petition was filed against.
25,000 will impose 25,000 cost. Cool. The defendant in commercial OS 739 of 2022 file of so-and-so has filed this petition challenging the correctness of an order dated 18/7/2024 by which the court permitted, the court allowed an application filed by the plaintiff under section 151 of CPC to accept the written statement to the counterclaim. Full stop. Next para. The suit in commercial OS 739 of 2022 was filed for recovery of rupees 11,75,656. Full stop. The defendant filed a written statement along with a counterclaim on, what is the date?
My lord, on 24/6/23.
On 24,
6/23.
on 24/6/2023. 24/6/2023. Full stop. The written statement filed by the defendant was rejected by the trial court on the ground that it was beyond the time prescribed under Order 8/1. This order was assailed by the defendant before this court in WP number
14/255 of 2023.
also. This court allowed the writ petition and permitted the written statement to be taken on record. Full stop. The plaintiff challenged the said order before the Honorable Apex Court in SLP civil number
Double 2/128 of 2023.
so and so. Before the Apex Court, liberty was sought to file a review petition to review the order passed in WP number so and so. Consequent thereto, a review petition number so and so was filed before this court, which was rejected on review petition
31/1/24 month.
31.
so and so. But the review petition 551 of 2023, which was dismissed on 31/1/2024. Full stop. Thereafter, the defendant filed an application under Order 8, Rule 6E, reduced Rule 10 for decree to decree the counterclaim. The said application was rejected on 27/3/2024. Full stop. The plaintiff filed objections to the counterclaim on 20th of April 2024. Full stop. Later, he filed an application under section 151 of CPC to reopen the stage of the case and to accept the counterclaim, objections to the counterclaim. Full stop. The trial court allowed the application in terms of the order dated 18/7/2024. Being agreed with the said order, the plaintiff is the defendant is before this. The learned counsel for the defendant submitted that under order 8, rule 6A(3) of CPC, the plaintiff was required to file the statement or the rejoinder to the counterclaim within the time permitted. She contends that the trial court had granted time up to what? 4/8, huh?
Yes, my lord.
Up to 4/8/2023. Full stop. She submits that the plaintiff did not file the counterclaim, but filed a belated counterclaim on 20th of April 2024. That is beyond
Objection to counterclaim.
objections to enta barudre. Without filing the rejoinder to the counterclaim, filed a belated objections to the counterclaim on 24/2024 beyond 120 days prescribed under Order 8 Rule 1. She contends that the proceedings is before this commercial court, and in view of the judgment of the apex court in so and so, the counterclaim had to be, objections to the counterclaim had to be filed within the time permitted. Full stop. She contends that the proceedings before the commercial court have to be construed strictly, and the provisions of the Code of Civil Procedure have to be applied strictly in view of the law declared with Honorable Apex Court in the above noted judgment. Full stop. Per contra, the learned counsel for the plaintiff contended that the order passed by this court in review petition 151 or 115. 551 of 2023 was received only in the month of April 2024, and therefore, the plaintiff was disadvantaged in filing the rejoinder to the counterclaim. He submits that the proceedings before the commercial court is still at a nascent stage, and therefore no prejudice would be caused to the defendant if an opportunity is granted to file the rejoinder. Besides this, he contends that there cannot be any automatic decree of the counterclaim, as the defendant is bound to establish the entitlement to the counterclaim. Full stop. Next para. I consider submissions made by the learned counsel for the plaintiff and the learned counsel for the defendant. Next para. As rightly contended by the learned counsel for the defendant, proceedings before the commercial court have to be strictly construed, and the timelines fixed under the Code of Civil Procedure have to be strictly adhered to. Full stop. There is no escape from this, as the purpose of the commercial courts is to ensure speedy and quick disposal of the claims brought before it. Full stop. Having said that, this court cannot ignore the fact that the defendant is also bound to establish the counterclaim by producing oral and documentary evidence. There is no automatic decree as provided under Order 8 Rule 10 of the Code of Civil Procedure. Full stop. This the division bench of this court in Aisha B has held that there cannot be an automatic decree if the written statement is not filed. Full stop. In that way of the matter, though the counterclaim, the rejoinder to the counterclaim was filed belatedly, since the proceedings were still at the stage of evidence of the plaintiff, the rejoinder filed to the counterclaim is, has to be accepted by compensating the defendant for the delay in filing the rejoinder. Full stop. In that view of the matter, this writ petition is disposed of upholding the order passed by the trial court. However, the plaintiff shall pay a cost of rupees 25,000 to the defendant before the trial court on the next date of hearing. It is made clear that if the cost is not paid, the trial court shall ignore the rejoinder filed to the counterclaim and proceed in accordance.
30 days may be given, my lord. The party is in Delhi, so I'll inform him.
You
because the
raise
next
it in
date-
your bill.
My lord?
You raise it in your bill.
I can raise it. Much obliged.
Much obliged.
Serial number 45, here Vishwanath.
T.N. Vishwanath.
Lords, defendant's writ petition, my lords. The respondent herein, my lords, filed OS 12 of 2023 before the trial court against the petitioners for declaration and perpetual injunction that she is the absolute owner of the plain scheduled properties. My lords, the said suit of the plaintiff, my lords, was denied by the petitioners herein, my lords. When the matter was set down for evidence, the respondent herein, my lords, comes up with an application under order 6 rule 17 to declare that the judgment and decree in some other suit, OS 199 of 2017, in which he is not at all a party, to declare that that judgment and decree is null and void.
But how did
Milords,
how did she get the information of this OS number 199?
Milords, in fact, Milord, she claims that she is the owner of some house kata properties, Milords, which are the properties of respondents herein. I mean, petitioner herein.
But does the defendant mention about the suit in the written statement?
No, Milords.
Then how did she come to know about the suit?
Milords, please, Milords, and that suit is filed much prior to filing of, that suit is decreed much prior to filing of the suit, Milords, present suit.
Hello, but have you referred this decree anywhere in your statement or in your? Huh?
No, Milords, I have not mentioned. I have mentioned that in the objection. That's all.
Can you take out notice then? Purple issue,
Milords,
emergent
not
notice.
for further stay of further proceedings because 26th case suit to
Madi,
evidence comments.
please go on with the cross-examination, Madi. I don't know why you want to stall the proceedings before the court. Genuine agidre tagoli.
Even impugned order is not a speaking order also, Milords. There's no specific reason for allowing.
Go on with the cross-examination. There's only a consequential remedy that they're seeking for. Let us see.
Please.
In addition, the learned counsel for the petition is permitted to serve. The learned counsel who represented the respondent, number one, only one
Sole
respondent before the trial court.
Much.
Serial number 46, Arvind Reddy.
Lords, kind of petition, defendant's writ petition. Plaintiff's suit for partition before the trial court, my lord, he was subjected to cross-examination. I kindly turn to page number 75, my lord. Second line, I may permitted to read. Konganahalli ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 4/1
page 75.
Please, madam. Second line, madam. ಕೊಂಗನಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ ಸರ್ವೆ ನಂಬರ್ 4/1 ಜಮೀನನ್ನು ಈ ದಾವೆಯಲ್ಲಿ ಸೇರಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ. This property was left out from the plaint schedule. Thereafter, my lord, IA number 22 was filed seeking to amend the written statement to include survey number 4/1. So that application was rejected by the trial court on the ground that the same was filed at the belated stage. Cross-examination was completed on 29/5/2023.
Yeah, but what is it you want to insert?
Lord,
Self-defendant has constructed 35 commercial shops.
That property has been included in the suit. May kindly go to the last line of the application, page number 26 to 76. Furthermore, she has not included the landed property being survey number 4/1. Survey number 4/1.
Page number?
Page number 77. Further, she has not included the landed property bearing survey number 4/1 situated at Konganahalli village, Chintamani Taluk, as well as the house vacant site situated at Banahalli village, Kaivara.
76 is annexure J,
House, other
application for amendment.
house.
ಎಲ್ಲಿದೆ ಅದು? ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ?
76 ಅಲ್ಲಿ ಕೆಳಗಡೆ ಲಾಸ್ಟ್ ಲೈನ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ. Furthermore,
ಹಾ.
last line. Furthermore, she has not included the landed property. Next one, 77. Bearing survey number 4/1 situated at Konganahalli village, Chintamani Taluk, as well as the house and vacant sites situated at Banahalli village, Kaivara, Chintamani Taluk. The suit itself is not maintained without inclusion of all the properties in the plaint schedule, and the suit for partial partition is not maintainable as required under law. Additionally, the suit is also not maintainable regarding survey number 38/2, as the plaintiff has not sought.
How are you related to the plaintiff?
My lord, we have denied the relationship, my lord. She says that.
How are you related to the plaintiff?
I am the sister, brother's son. My father is a defendant number 1. I am the defendant number 2.
Defendant number 1 is Chaudamma.
Defendant number 1, Chaudamma, is my brother's elder sister. I am the defendant number 3 before the trial court, my lord.
Pradeep.
Priest. My father is Bujappa, defendant number 2, my lord.
Bujappa is the son of Chiknaranappa.
House.
So therefore, sister tane idellanu.
House.
Sister suit.
House. Sister suit for partition. She has not included.
Settlement ಮಾಡ್ಕೊಳ್ಬಿಟ್ಟು ಯಾಕೆ ಎಳೆದಾಡ್ತಿರೋದನ್ನ?
Alla, they are not coming. Now we are ready to settle it, my lord. They are not coming.
Correct. ಅಲ್ಲ, are you willing for mediation ಹೋಗಕ್ ರೆಡಿ ಇದ್ದೀರಾ? ಆಗಿದ್ಯಾ?
ಅವ್ರು ಕೇಳ್ತಾನೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ಬರ್ತಾ ಇಲ್ಲ ಅದು.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ, we are ready for that settlement. ನಾವು ರೆಡಿ ಇದ್ವಿ, ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ.
ಈ ಕೊಂಗನೂರು ಯಾವ್ದದು? ಕೊಂಗನಹಳ್ಳಿ ಅವ್ರು ಯಾರ ಹೆಸರು ಇರೋದದು?
Standing in the name of the Chikanaranappa, grandfather, my grandfather.
ಅದ್ ಯಾರು ಕೊಟ್ಟಿದಾರೆ ಅದು?
ಅದು ಅವ್ರ ಹೆಸರಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ. ಅವ್ರ ಪೊಸಿಷನ್ ಇದೆ. ಮೈ ಸಿಸ್ಟರ್ ಅವ್ರ ಹೆಸರಲ್ಲೇ ಇದೆ.
ನಾರಾಯಣನ ಪೊಸಿಷನ್ ಇಲ್ಲ.
ಅಲ್ಲ, ನಮ್ಮ ತಾತನ ಹೆಸರಲ್ಲಿ ಚಿಕ್ಕನಾರಾಯಣಪ್ಪ ಹೆಸರಲ್ಲಿದೆ.
ಯಾರ ಪೊಸಿಷನ್ ಇದೆ?
Vacant ಇದೆ ಸ್ವಾಮಿ. Landed property, it is vacant.
Then the court can always include this property.
Court has rejected that application to include.
Take out notice, issue emergent notice.
But the matter is turned up for 11th ಇದೆ ಅದಕ್ಕೆ.
Cross examination ಎಲ್ಲ ಮಾಡಿ.
Cross examination conclude ಆಗಿ matter is stand posted for my evidence, my lord.
ಮಾಡಿ no.
In addition to which, my lord, I may permitted to serve the
addition the law and counsel for the petition served. So the respondent number 1.
House. Respondent 2 may respondent number 2 bank may kindly be dispensed with notice.
2 ಆಮೇಲೆ ಮಿಕ್ಕಿದ ರೆಸ್ಪಾನ್ಸ್ ಬೇರೆ ಯಾರು ಇಲ್ವಾ?
ಯಾರು ಇಲ್ಲ ಸರ್.
Notice to R2 is dispensed at the request and risk of the petitioner. Yes. Next.
Serial number 47, Sharad Kumar Shetty. Hearing for petitions.
Lordship. This is a suit for partition. Wherein the petitioners had filed an IA number 8, your lordship, that is under order 6 rule 17 for adding a scheduled property, the schedule B. When the trial
What
court,
stage you filed this application?
was filed during evidence, I guess. Yeah.
See, when you come before this court, GM-CPC court, there are 3 things that you should always bear in mind. When the suit was filed, what is the nature of application, when the application was filed.
Yes,
These
sir.
3 things are very material. Please find
Kindly
out.
pass over, your lordship.
Learned counsel for the petition seeks time. List on when do you want it?
Short date may be given. Monday, your lordship. Monday.
Told.
19th November, serial number 48, Raja L.
This case appear for the petitioner. Petitioner dependent 2 is before the trial court. Suit for partition and separate position. The above matter is the suit in OIS number 2020, my lord. The defendant number 2 is filed the application chief examination and also application filed the defendant order 65 of evidence act, my lord. The trial court after hearing the matter reject the application, my lord. The application is only 2 documents, my lord. Earlier partition, 2 documents in one registered document, one Panchayat Parikat, 2 documents. The original is lost, my lord. The Xerox copy is produced before the trial court along with the application, my lord. The trial court, after hearing the matter, reject the application, my lord.
On what ground?
What this, in the written statement specifically contains and the application is this water document is produced before the court to take the contention, my lord.
ಏನ್ stage, suit stage ಏನಿದೆ?
ಈ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿದೆ ಡಿಫೆಂಡೆಂಟ್ ಫರ್ದರ್ ಎಕ್ಸಾಮ್ ಫರ್ದರ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ದ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ ಮಾರ್ಕಿಂಗ್ ಒರಿಜಿನಲ್ ಇವ್ರ ಹತ್ರ ಇದೆ.
Issue emergency notice. Petition the learned counsel for the petitioner is directed to serve the learned counsel for the respondent number. Respondents before the trial court. Kamalamma ಒಬ್ರು ಸಾಕಾ? ಏನ್ ಕಾರ್ತಿಕ್, ಲಕ್ಷ್ಮಿ, ಧರಣೀಂದ್ರಯ್ಯ. Issue emergency notice to the response 1 to 3. In addition, the learned counsel for the petitioner is directed to serve the learned counsel for the respondents before the trial court. The trial court is requested not to hear the parties, not to
ಎವಿಡೆನ್ಸ್,
not to pass judgment until further orders.
ಅಲ್ಲ ಎವಿಡೆನ್ಸ್
ನೀವು ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಮಾಡಿ.
ಅಲ್ಲಲ್ಲ ಎವಿಡೆನ್ಸ್ ಅಂದ್ರೆ ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇವೆ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್.
ಇಲ್ಲಿ ಮಾಡಿ ಎವಿಡೆನ್ಸ್
ಅದರ ಅಲ್ಲ ಎವಿಡೆನ್ಸ್
ಮಿಕ್ಕಿದ ಎವಿಡೆನ್ಸ್ ಮಾಡಿ. See, the only intention is that you complete your evidence, your role. ಆಮೇಲೆ ಇದು ಅಲೋ ಮಾಡಿದಾಗ ನೋಡೋಣ ಅದನ್ನು. Not to pronounce judgment ಅಂತ ಹೇಳಿದ್ರು.
The case itself relies on the document. The document is the.
Correct, Mr. You lead your evidence. Let us see later. ಈ ಡಾಕ್ಯುಮೆಂಟ್ ಮೇಲೆ ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Last party. Further proceed to the cross examination and posted to the.
Mr. So many things happen. You do your job. We have said that the judgment should not be pronounced. So ಇದಾದ್ಮೇಲೆ allow ಆದ್ರೆ we will allow that application. I will permit you to lead evidence and do.
When we contended the written statement itself.
ಡೇಟ್ ಮೈ ಫಿಕ್ಸ್ ಆದ
ಒಂದು ಡೇಟ್ ತಗೊಳ್ಳಿ. ಇಷ್ಟೊಂದು
29th November.
ನೀವು ಒಂದೇ ವಾರದಲ್ಲಿ ಒಂದೇ ತಿಂಗಳಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮುಗಿಸ್ಬಿಡ್ತೀರಾ? ಮುಗಿಸ್ತೀರಾ? ಅಲ್ಲ ಮುಗಿಸ್ತೀರೇನಪ್ಪ? ನಾನ್ ಕೇಳಿ ನೀವು ಉತ್ತರ ಕೊಡ್ತೀರ. Will you conclude the evidence within 1 week, 10 days, 1 month? Will you conclude? ಇನ್ನ ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ಸು ಅಲ್ಲಿ ಇಲ್ಲ ತಂದ್ಕೊಡ್ಬೇಕು, ಕಾಯಿಲೆ ಬರಬೇಕು, COVID-19 ಬರಬೇಕು. Then next.
49 Janardhan G.
An application for appointment of a commissioner was rejected. That is a petition by defendant number 3 in the trial court. And an application on Action L that was filed on 4/7/2024 to appoint a court commissioner to find out whether this property the suit shall property for which the relief sought for by the plaintiff for declaration and injunction is.
What is the suit for?
That suit is for declaration and injunction, and also in respect of the possession of the B schedule property, saying that it has been encroached by the defendants. And in that suit, my lord, since the revenue proceedings and other proceedings, it has been brought to the record. The government has decided that it's a pond, my lord, is part of pond, it should be preserved. My lord, and in respect of which a suit has been filed.
I think I represented him in some case. ಯಾವ್ದು ಕೇಸ? I think I represented ತಿಪ್ಸಂದ್ರದ ಇದು. ತಿಪ್ಸಂದ್ರ. Not before. List this petition before any other court after obtaining the orders of the Honorable Chief Justice. Yes.
Number 50, Krishna S. Vyas. Hearing for the petitioners in this matter. Alerts, the case stems from a warrant of arrest having been issued against the petitioner by the courts below, my lords, in an execution proceedings. The original proceedings, my lords, the decree is dated 7/3/2002, my lords. In 223/1997. Subsequently, it is a suit for bare injunction, my lords, which had been preferred by the first respondent against the petitioner and others.
15/6/2007, my lords, an execution petition came to be instituted by them, my lords. And on subsequently, my lords, an application for arrest of these decree holders came, judgment debtors, my lords, came to be filed. There are 3 judgment debtors as on record today, my lords. That is the petitioner, along with respondent number 2 and 3, happen to be his children, my lords. Now, my lords, this petitioner on 23/10/2024, my lords, moves an application under section 59 read with 151 of Code of Civil Procedure, my lords, seeking for stay of the arrest as against only this petitioner on medical grounds. And elaborate medical records, my lords, has been produced, wherein it is categorically seen that, my lords, he has been suffering from multiplicity of disorders, my lords, and he has also been had undergone an angioblast, as well as he is a chronic diabetic patient. He had heart ailments, my lords, and so many other ailments, my lords. Without considering any of the contentions which have been taken in the application, my lords, on 23/10/2024 itself, the impugned order came to be passed, my lords, wherein the application of the petitioner has been dismissed, my lords, summarily on the ground that there have been multiplicity of proceedings which have been encountered between the parties in the past, and that after having lost the entire proceedings, they have filed this application. It is only as against the arrest of this petitioner who is 78 years of age. That is all the contentions which has been taken. Now, my lords, the first respondent, who was earlier also not in possession of the property, however, my lords, he was successful in getting a bare injunction from this from the learned trial court, my lords. Now he is trying to enter upon possession of the property by utilizing such kind of orders. But so far as respondent number 2 and 3 are concerned, my lords, we are not seeking for any stay of the proceedings.
Do whatever you want.
Yes, my lords.
There is a judgment and decree against you.
Yes, my lords.
Now, if you violate it,
I will not violate. I will not violate it, my lords. I am not violating it. My only difficulty is that there is a warrant of arrest which has
you
been
and your
issued against
children don't violate it.
my lords,
You can't say, my children are violating, I'm sorry, I will not violate. No.
Only with respect to the petitioner, this petition has been preferred, my lords, and any order that may be
There is
passed by this
something called
restricted to the petitioner, my lords.
You should pinch where it pains.
My lords, difficulty is this.
See, if you pinch the feet, it will not pain.
My lords, difficulty is a 78-year-old person.
How does it matter, mister? If he has violated the order of injunction, he has to face the music.
Even to establish the fact that, my lords, he has been violating the order of the court, there is no document which has been produced by the petitioner.
97 suit, 2002 decree.
Yes, my lords.
Still that man is not able to enjoy the fruits of the decree.
It is not the first petitioner who has been violating it, my lords. Petitioner has got no role to play at all in that.
Yes.
He had a nominee be made part of it. If the elaborate
Even undertaking that you and your sons will not interfere with the possession.
Yes, my lords, that may be an undertaking. I will persuade my sons not to interfere. Certainly, my lords. That may be an undertaking taken before this honorable court. On that basis itself, it may be.
The petitioner issue emergent notice to the respondent. Number 1. Notice to other respondents is dispensed. Next para. The learned counsel for the petitioner submits that the petitioner and the petitioner and his sons, who are the respondents 2 and 3, would undertake not to disturb the possession of the petitioner or the respondent number 1, as per the decree passed in OS number
223/1997.
Full stop. In that way of the matter, the order dated
24
dated 27/9/2024
and 23
issuing arrest warrant against the petitioner is stayed till the next
as well as
hearing.
23/10/24, my lords.
23/24, your application is rejected. That is all.
Again, they issue another warrant, my lords. There also they have issued a warrant.
And either 23/10/24.
Hence, issue arrest warrant.
Issuing arrest warrant against the petitioner is stayed.
Much up. My lords, a hand delivery.
Yes.
Serial number 51. Fire south.
For petitioner in this case, Lord.
Hmm.
Lord, in this case, the petitioner is the plaintiff before the trial court in OS number 400 of 2023. Lord, the concern this suit for permanent injunction has been filed by this plaintiff. The petitioner before this court, the concise fact of the case, this Lord, the petitioner father, Syed Khalil Shah, was discharging the duty as a mutwalli of the Babaya Makan Thereafter, the land has been granted in favor of this petitioner father by the land tribunal on 31/8/1988. Annexure E page 50, my lord. Annexure E page 50. So thereafter, my lord, my father has executed a registered will on 14/11/2006. F, that is the annexure F, my lord. Pursuant to this, my lord, that I approach this court and obtain the orders thereafter, the revenue records annexure K, page 69, my lord. The revenue records have been changed in my name.
Yes.
With MR number 7 of 2013-14, my lord. From that day to till date, I am in possession and enjoyment of this property. Now this defendant, they have no manner of right, title, interest over this property. They were trying to interfere in my peaceful possession.
Who are these defendants?
Lord, they are the defendant. One is the officer of the Jamia Masjid.
What about 2, 3, and 4?
They are the, it appears that they are also his followers. No. So they don't have any right over this property because by virtue of the grant made in favor of my father and also the revenue records have been changed in my name. Why the will dated?
Nelmangla IA ಏನಾಗಿದೆ?
ಅದು IA ನಲ್ಲಿ ಸ್ವಾಮಿ ನೋಡ kindly see annexure A page 29 lord.
What is the stage of the suit now?
Stage of the suit ಸ್ವಾಮಿ ಇನ್ನ still for orders ಅಂತಾನೆ ಇದೆ.
Orders on what?
Orders on that IA1. Lord, kindly see page 30 lord. Page 30 lord.
ಬರ್ಕೊಳ್ಳಿ. ಏನ್ ಕೇಳಿದ್ರ? What is the
I'm
relief order?
speaking for the expired injunctions to restrain this defendant from interfering in my peaceful possession. Lord.
Issue emergent notice. It is open for the petitioner to serve the learned counsel who represents.
Sir, ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ ಲಾಸ್ಟ್ ಟೈಮ್ ತವಲ್ಲ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೆ ಸರ್ ಮಾಡಿ ಅಕ್ಲಾಮಿಂಗ್ ಹಾಕಿದ್ದೀನಿ. Yesterday I produced before this court.
Issue emergent notice ಆಗಿಲ್ವಾ?
ಇಲ್ಲ ಬರೀ only directed to serve the copy to the
Emergent
counsel.
notice. Issue emergent notice to the respondents. The learned counsel for the petitioner submits that notice of the petition was served to the advocate who represents the respondents before the trial court on
Yesterday, that 6th, Lord.
6th. Full stop, next para. It is seen from the order sheet of the trial court that till
From 9/12/2023 to till date, he has not passed the order.
from 9/12/2023
To till date.
to 8/7/2024, the court has not passed any orders on the application. The learned counsel for the petitioner submits that from 8/7/2024 till date, the court has not passed on the interlocutory application. In that view of the matter, till the trial court passes the orders on IA number 1, the respondents are restrained from interfering with the possession of the petitioner in the suitable property.
Much use.
Number 2. Number 12. Sachin Jai Nandan.
Lord, I appear for the petitioner. Petitioner is a plaintiff before the trial court, my lord. The suit is for injunction and suit is for one for injunction, my lord. The petitioner was granted land as per annexure C, grant order. There are two survey numbers which are the suit schedule property, survey number 50 and 61. My lord, the defendants, they filed the till date, the revenue records are in the are mutated and they are standing.
What has happened before the trial court?
My lord, before the trial court, my lord, the petitioner had filed IA number 10, seeking for restraining the defendants not to interfere with the possession of the plaintiff petitioner's property. My lord, the trial court, my lord, the defendants in their written statement, they claim that they are the unauthorized occupants of the land and their application for
Take out
grant.
notice, issue emergent notice.
My lord, the difficulty is, my lord, I do not want the suit to be stalled. However, they are interfering with the petitioner's.
Status quo ಇದೆಯಲ್ಲ.
A status quo, my lord, the difficulty is, my lord, the defendants, by taking advantage of the order of the status quo, they are interfering with the plaintiff's property. My lord, the order of the trial court, my lord, the appellate LAC, the lower appellate court and all, my lord, page number 28 and 29, and the trial court reasoning, The reasoning is only that the defendants have produced
Serve it
certain.
and come back.
My lord, the defendants have produced certain photographs which show that defendants are having possession over this property. My lord, there is no even a single document with respect to the
Serve
defendants.
it and come back, yes.
Any date may be granted.
In addition, the learned counsel so on so. List on date. Yes, Veerappa Reddy.
22nd November, serial number 13, Veerappa Reddy.
My grandfather in 1946 partitioned all the properties and we have acted. Subsequently, 3 suits were filed. In one suit, there was an application to restrain the defendants from alienating the property that was vacated on merits. By suppressing those 2 suits, the first respondent filed another suit before the trial court, and the trial court felt that it cannot grant ex parte injunction. It passed a detailed order by refusing the injunction and order for issue of emergent notices. Thereafter, very next day, it was advanced and injunction was granted. Unless the order dated 13-3, as per the said order, notices were issued, that is recalled. That was not done. Next day, injunction was granted.
Where do I get it?
It is at it is at page 1892, 13-3-24. Detail order ಮಾಡಿಬಿಟ್ಟು emergent notice ಕೊಡೋಕೆ ಹೇಳುತ್ತೆ. Next dayನೇ injunction ಕೊಡ್ತಾರೆ.
Page 92.
92, page number. The plaintiff has filed present suit for the relief of partition and separate portion of settled property and for a relief of defense. Along with the plaintiff filed IA1 and R13 CP seeking temporary injunction against defendants, so and so, to restrain them from maintaining settled properties till this person. On going through the entire pleadings and documents on record, I am of the opinion that it is just and necessary to hear the other side before passing any restraining order in respect of IA number 1. Hence, I proceed to following order. Issue summons to defendants along with emergency notice so and so. Next day it was advanced and injunction is granted. Case advanced. Learned counsel for the plaintiff has expressed that his apprehension that the purpose of filing of the suit will be defeated if the urgent relief is not granted on IA number 1. It is further submitted that not out of multiplicity of proceedings it is necessary grant restraining order in respect of it. It is also noticed that IA2 has been filed under order 32 rule 3 of CPC to appoint 13th defendant as a natural guardian. Since the reasons made out are all, IA2 is allowed and defendant number 3 is avoided. In order to avoid multiplicity of proceedings, the plaintiff and defendants are hereby restrained from creating third parties settlement property till the next date of hearing.
I could issue emergent notice. Interim stay of the order dated 14-3-2024 passed by the trial court in OS number 278 of 2024. The registry is directed to issue appropriate notice to the additional senior civil judge and JMFC Devanalli as to how the suit was advanced and an order of injunction was granted, though the trial court was not satisfied that there was no case for grant of ad interim injunction. Yes.
Serial number 14.
My lord, this is, I am appearing for the petition. This is yesterday's matter, my lord, listed today. I have requested the local council, my lord, to give me the details of the documents for which it is being produced and reasons for its production. I am still to receive on
Council for the petitions, which time list on out wicked.
Tuesday.
Tuesday.
Open in serial number 15. Gautam Chand, SF.
My lord, serial number 15 and list 2, my lord.
B group 52. Finally, second list second list check out here. No, B group. First list will be
List number 1. For preliminary hearing B group matters. Serial number 52.
And for the petition, my lord, defendant number 2 is in this petition, my lord.
Appear for
Defendant number
respondent
2.
number 1 in this matter.
Suit for declaration possession, my lord. I filed an application for production of documents, my lord, that came to be dismissed. That is under challenge in this petition. my lord.
What
States
is the
arg-
suit for?
Declaration possession, my lord. To prove my possession, I have, my lord,
It's for declaration and injunction, my lords. Not for
declaration injunction.
It's for declaration and injunction.
Yes,
not
ma'am.
for possession.
Yes, yes, I correct myself.
Declaration injunction.
Injunction, my lord.
When is the suit filed?
Suit filed, my lord, in the year 2009, my lord.
2009.
Yes, my lord. These documents were not in existence, my lord. Proceedings was going on. That condition I have taken in my return statement, my lord. Only to prove my possession, my lord, I have produced, I filed this application, my lord. Khata extract and tax paid receipt dated 2014. my lord. That, my lord, your lordship will get at page number 48 of the petition. The only reason given by the trial court is
Yeah,
the
application ಏನ್ ಹಾಕಿದ್ದೀರಾ?
application, my lord, to order it rule 1A, my lord, at page number 48, my lord, your lordship will get at page number 48. I have given reasons at para 3, my lord, 50, my lord. Para 3, I have given reasons, my lord. I further submit that in view of the dispute raised by the plaintiff's husband before the corporate authorities, the corporate authorities has issued the notice to the husband of the plaintiff as well as the second defendant for conducting an inquiry for issuance of khata based on the sale deed dated so and so. However, the khata came to be issued subsequent to filing of the suit, and in the written statement filed by the second defendant is clearly mentioned that the application filed by the second defendant seeking for affecting the khata is still pending before the Brihat Bengaluru Mahanagar Palika. Now, after conducting the inquiry, the BBMP has issued khata in respect of the property referred in the written statement and also assessed the property for taxes and collected the taxes. These documents, my lord,
What are these documents?
my lord, your lordship will get a page number 48, my lord.
Khata, endorsement, tax paid, electric.
Tax paid receipt, only to prove my possession, my lord.
Yes.
Nine-
That's
90
That's
Yes.
at page number 40. Yes, I'm sorry. The documents which they have mentioned, that is the list of documents, my lords, that is at page number 48. Because they agree that the kata dated is of the year 2014, which means to say, my lords, the documents were in possession with them at the year 2014. And they have filed the application to recall the order when the matter was posted for further arguments. The case was posted for arguments. The court had heard us. It was partly heard and the matter was posted for further arguments.
Application was filed at what
After
stage?
a lapse of 3 years, my lords, in the year 2017, they filed an application to recall the order.
at the
But
stage-
indeed, this has been appreciated by the trial court, my lords, in page number.
ಯಾವ stage filed ಮಾಡಿ?
argument at the stage of.
Page was for arguments, my lords. It was for arguments. This has been appreciated by the trial courts, my lords, in page number.
What are the other documents you have produced?
There, my lord,
No, but have you produced any khata and other documents earlier?
khata have not produced, my lord. Sale deed, other
ಏನ್ documents produce ಮಾಡಿದ್ರ ಮುಂಚೆ? What are the other documents that you have produced?
That's at page number 15, my lords.
Page
That is
number?
the order of the trial court, page number 15, 1-5. But it starts from both parties have adduced oral as well as documentary evidence. Case posted for arguments. Even arguments was heard in part. At this stage, defendant number 2 filed these 3 applications to reopen the case and permit the defendant number 2 to produce these documents. Now, point for consideration is whether there is any point in consideration is whether, I'm sorry, the contention of the defendant number 2. As far as the application filed under order 18, rule 17 of CPC is concerned, the Honorable Supreme Court already held that this provision enables the court to recall any witness for clarification. That being the position of law, certainly this application filed by defendant number 2 is not maintainable under this provision. As far as order 8, rule 1A CPC is concerned, defendant may produce documents at later stage subject to grant of the leave by the court. It discloses that all these documents were in possession of defendant number 2 till filing of this application. Because that is what in the year 2014 they have taken the application. But they have filed the application. I'm sorry. In the 2014, they have collected the document. They filed the application in the 2017.
Stay in this proceeding.
Probably.
Stay there.
stay.
Huh?
There is stay in this proceedings, my lord.
Why do you keep this petition pending from 2017? By now you could have got a judgment.
Please.
Yak ಮಾಡಿದ್ರಿ ಹಿಂಗೆ? No, at least you could have considered and said, ಆಯ್ತು ಮುಗಿಸ್ಕೊಂಡು close ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಡ್ತಾರೆ. 7 ವರ್ಷ you wasted.
Please.
ನೀವು ಎಷ್ಟು ಕಾಸ್ಟ್ ಕೊಡ್ತೀರಿ ಹೇಳಿ?
Reasonable cost make
ರೀಸನಬಲ್ ಎಲ್ಲ ಇಲ್ಲ. ಹೆವಿ ಕಾಸ್ಟ್ ಎಷ್ಟು ಹೇಳಿ?
5,000. Property.
ಪ್ರಾಪರ್ಟಿ ಇರೋದೆಲ್ಲಿ?
Sanjay Nagar.
ಸಂಜಯ್ ನಗರ್. ಎಲ್ರಿ ಅದು ಸಂಜಯ್ ನಗರದಲ್ಲಿ?
Ward number 100, Sanjay Nagar, Main Road, Bangalore.
So it's at page number 25. The schedule is at page number 25.
ಸಂಜಯ್ ನಗರ ಕೊಡಿ. ಎಷ್ಟು?
5,000.
Hey, please come up with ಎಷ್ಟೊಂದು 50,000. Nothing less than that.
I'll leave to your lordship. Any,
No marking, only marking of documents, no oral evidence. No oral evidence.
but he has
only-
to come. Yes, ma'am.
You can only mark the documents, no oral evidence. You want to cross-examine him?
We'll take a chance, my lords. We'll cross-examine.
50,000 ಬರ್ಕೊಳ್ರಿ.
My lord, 25,000. my lord.
ಸಾಧ್ಯನೇ ಇಲ್ಲ. The defendant number 2 na?
Yes, my lord, different number 2.
Defendant number 2 in voice number 1554 of 2009 on before the pending consideration before the 37th Additional City Civil Judge, Bangalore, has filed this writ petition challenging an order dated
Order dated, my lord.
5/9/2014 by which, an application filed by him under section 151 of CPC was rejected. Applications filed by him under section 151 of CPC, Order 18 Rule 17 of reduce section 151 of CPC, and an application under Order 8 Rule 1A of CPC were rejected. Next para. The suit in voice number 1554 of 2009 was filed for
Declaration,
Declaration
injunction.
and injunction.
declaration and injunction. Full page plaint ಹಾಕಿಲ್ಲ ನೀವು.
ಹಾಕಿನ್ 18 ಅಲ್ಲಿ plaint ಇದೆ.
ಒಂದ್ ಪೇಜ್ ಎಗರಿಸ್ಬಿಟ್ಟಿದ್ರ ನೀವು. ಫಸ್ಟ್ ಪ್ರೇಯರೇ ಕಾಣ್ತಾ ಇಲ್ಲ ಇಲ್ಲಿ.
Amended plaint ಅಂತ annexure B. man.
ಹಾ?
Annexure B 18. 18, page number 18.
ಎಷ್ಟು?
Page illa.
18, my lord.
18.
18.
ಇದು ರಿಲೀಫ್ ಎಲ್ರಿ ಇದೆ ಅದನ್ನ
Take, my lord, it is at page, all one page.
First page illa, sir.
ಅಲ್ಲೊಂದು ಪೇಜ್
First to
ಎಗರಿಸ್ಬಿಟ್ಟ
declare
ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ಯು ಆರ್ ನಾಟ್ ಎಕ್ಸೆಪ್ಟ್. ವಾಟ್ ಆರ್ ದ ರಿಲೀಫ್ ಶಾರ್ಟ್?
Your lordship may kindly, my lord, at annexure A ಅಲ್ಲಿ ಅಲ್ಲಿ relief sought ಅಂತಿದೆ. That may kindly be referred, my lord.
Annexure?
Annexure A, page number 12, relief claim, declaration of the plaintiff is the absolute owner of the suit and declare that the GPA dated so and so is fifth column.
You have the copy of the plaint with you?
I have, may I get, my lord, file?
Is there not? ಯಾರು ಕೊಡಿ?
ನೀವೇ ಕೊಡಿ.
May I get, my lord, file is?
The suit so and so is filed for so and so reliefs. Full stop. The suit was contested by the defendant number 2 na?
2, my lord.
Defendant number 2. Full stop. When the trial in the suit was concluded and when the arguments in the suit was heard by the trial court, an application was filed by the defendant number 2 to defendant number 2 under Order 8 Rule 1A reduce section 151 CPC, comma, under order 18 rule 17 of CPC to recall DW1, na?
Yes, ma'am.
To recall DW1 for further examination, and under section 151 of CPC to recall the stage of the suit. Full stop. These applications were contested by the plaintiff on the ground that the applications were filed at a belated stage, and that the defendant number 2, who was in possession of these documents in the year 2014 itself, did not justify as to why those documents were not filed at the earliest point in time. Full stop. The trial court, after considering the contentions urged, held that partly held that the arguments in when the case was posted for arguments, and after arguments were heard in part, the defendant number 2 filed the 3 applications. Full stop. It held that the documents sought to be produced by the defendant number 2 were subsequent to the filing of the suit, and nothing prevented him from producing the documents at the stage of recording his evidence. Full stop. It also held that the documents sought to be produced by the defendant number 2 were revenue documents and not documents of title. It held that the evidence adduced by the defendant number 2 is sufficient enough to determine his claim. Consequently, it rejected all the applications in terms of the impugned order. Next paragraph. The learned counsel for the defendant number 2, being agreed by the said order, this writ petition is filed. Next paragraph. The learned counsel for the defendant number 2 contended that these documents were essential to establish that the defendant number 2 was in possession of the suit property. He contends that though these documents were available with the defendant number 2, the same could not be produced. ಏನಕ್ಕೆ ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕಾಗಿಲ್ಲ?
Not in existence, my lord, at the time
Okay.
of filing. 2014 ಅಲ್ಲಿ we have got the order, my lord.
Correct, but 2014 ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದೆ ಯಾವಾಗ?
Well, I think it was in the year 2012, March. They led their evidence,
ಏನಾಯ್ತು?
the defendants. ಇಲ್ಲೆಲ್ಲೂ ಹಾಕಿಲ್ಲ, ನಾನು ಚೆಕ್ ಮಾಡಿದಾಗ 2012 ಅಂತ
Produced. However, he contends
ಚೆಕ್ ಮಾಡಿದಾಗ.
that the details of the khata were mentioned in the written statement filed by the defendant number 2. He also contends that the husband of the plaintiff had raised some dispute before the corporation authorities, and that after conducting an inquiry, the Brihat Bangalore Mahanagar Palike had issued the khata in respect of the property. He therefore contends that the defendant number 2 could not produce the documents when the evidence was adduced. Next para. The learned counsel for the plaintiff, on the other hand, contended that these documents are not documents of title but are revenue documents, and does not in any way help the plaintiff, defendant number 2, in establishing his case. He further contends that there is no reason mentioned as to why these documents were not produced at the earliest point in time. Full stop. Besides this, he contends that the defendant number 2 has not established as to how these documents are material for the purpose of considering the case on merits. Full stop. Next para. I consider submissions made by the learned counsel for the plaintiff and the learned counsel for the defendant number 2. Next para.
For the
You ಯಾರಿಗೆ?
friend 3, madam.
Defendant number 3.
Of 5.
ನಿಮ್ದೇನಿದೆ?
Same.
The learned counsel for the defendant number 3 also adopted the contentions of the learned counsel for the plaintiff.
Plaintiff.
Plaintiff. Full stop. Next para, I have considered submission so and so and so. The relief sought for in the suit was for declaration of title of the plaintiff and for consequential reliefs to set aside to declare a GPA and a sale deed executed in favor of the defendant number 2 and 3 as null and void, and for perpetual injunction, full stop. Injunction to restrain the defendants from interfering with the plaintiff's peaceful possession in the suit shall property, full stop. The defendant filed his written statement when?
Not
Yavaga? On 20th of April 2009, claiming that the khata of the suit property was in his name. Full stop. The evidence of the defendant was recorded on Utidya,
It's on 2012-2013.
2012-2013.
2012-2013.
2013. Full stop. The documents in question were subsequent to the date of the evidence, recording of the evidence of the defendant number 1. Defendant number 2. Full stop. Ideally, the plaintiff must have, defendant number 2 must have produced these documents at the earliest point in time. There is no explanation given for the delay in producing these documents at a belated stage, that too when the suit was set down for arguments. Full stop. No doubt the impugned order passed by the trial court was justified in view of the conduct of the defendant number 2. However, since this writ petition is pending before this court from the year 2017, and an interim order is granted by this court staying the further proceedings in the suit,
Please.
it is appropriate to direct the defendant number 2. It is appropriate to allow these applications filed by the defendant number 2 and place defendant number 2 subject to conditions to ensure that the defendant number 2 goes on with the proceedings in the suit without further delay. In that view of the matter, this writ petition is disposed of, allowing the applications filed by the defendant number 2 is disposed of, setting aside the order passed by the trial court dated so and so, and allowing the applications filed by the defendant number 2 under section 151 of CPC, under Order 8 Rule 1A, and under Order 18 Rule 17 of CPC. Full stop. This is, however, subject to the condition that the defendant number 2 shall pay a cost of rupees 50,000 payable to the defendant number to the plaintiff on the next date of hearing. This is also subject to the condition that the defendant number 2 shall only mark the documents and shall not lead any further oral evidence. It is, however, open for the plaintiff to cross-examine the defendant number 2.
Please.
Full stop. Since the suit is filed in the year 2009, the trial court is requested to dispose of the suit as early as possible, at any rate within a period of 3 months from the date of conclusion of the evidence of the parties.
Please. Cross-examination only with respect to these documents. Cross-examination by the plaintiff only with respect to these documents.
Obviously.
Obligements.
Number 53, Madhukar Deshpande.
Plaintiff's application for amendment of the plaint came to be rejected, my lord. The suit was filed in the year 2002, my lord. Even before
2002 suit.
Yes, my lord.
Yavaga.
The earlier, prior to the amendment to the order 6 Rule 17, my lord. And
At
then,
what
my lord,
stage?
then at the stage of cross-examination of DW3, my lord, I came to know about one particular development. That is that information what I was not having. And that is the reason, my lord, why they did not pay the sale consideration amount to me. And then, my lord, that is one of the reason, my lord, for what
Please tell us at what stage you filed this application?
at the stage of cross-examination of DW3, my lord.
DW?
Three.
What is this? What do you want to insert by way of amendment?
I am adding 2 paragraphs, my lord.
Yes,
my lord. These paragraphs are necessitated. The reason is that, my lord, there is a one particular road which is shown in the CDP, my lord. That particular road is the reason for them not to pay the sale consideration to me. For that reason, my lord, I sought for the cancellation. And one more important factor is that, my lord, it is a 24 guntas of land, my lord.
Is for what?
For cancellation of sale deed, my lord.
Cancellation of sale deed?
Yes, my lord. There is one more development, my lord. That is one of the defendant, that is defendant number 2. He has received the 2 lakh rupees what he had paid to me, and he has reconveyed a portion of land of the scheduled property. And that particular witness has admitted that because of the road, we did not the transaction did not materialize.
Read the whatever amendment you want.
Yes, ma'am. Page number 35, my lord. The plaintiff submits that after execution of the sale deed, when the plaintiffs have demanded for the balance sale consideration amount, the second defendant started telling that some close associate of the first defendant informed that there is a road problem, and if there is no road problem, they will make the payment. If there is a road problem, then the scheduled property is of no use to them. The plaintiff submits that the plaintiffs came to know about the first defendant from the second defendant, and whenever the plaintiffs asked the second defendant to make the payment, he used to tell that there is a road problem, but he had not gave any authentic document to show that there is a road problem. And whenever the plaintiff asked the second defendant, he used to inform the plaintiff that he is searching for the said document, but he had not able to secure it. The plaintiff submit that since the second defendant had alleged that there is a road problem, the plaintiff tried their best to secure the authenticated information, but they failed to do so. The plaintiff submits that whenever the plaintiff demanded for the balance sale consideration amount, the second defendant used to tell the plaintiff that why you are bothering about the money when you are in possession of the scheduled property, and when we are going to put up the construction, anyhow we have to come to you. This is the elaboration of my contention, my lord. What
you knew it at the time of filing the suit itself.
I was aware of it, my lord, but the only thing is that his contention regarding not going with the transaction, I was aware. But he was telling me that there is a one particular road problem, and for that reason, we are not making the payment. Then, my lord, in his cross-examination, my lord, I request my lords to kindly take one particular document, page number 34, my lord. In his cross-examination, in his examination,
They're not on that.
Yes, my lord.
Did you know this fact at the time when the suit was filed?
My case was that, my lord, there was no problem, there is no road problem at all.
Correct. ಅವರು ಹೇಳಿದ್ರು ಅಂತ ಇಲ್ಲಿ ಹೇಳ್ತಿದ್ರ ನೋಡಿ ಡಿಫೆಂಡ್ ನಂಬರ್ ಇನ್ಫಾರ್ಮ್ ದಟ್ ದೇರ್ ಇಸ್ ರೋಡ್ ಪ್ರಾಬ್ಲಮ್.
Yes, my lord. I was aware of it, but I was under the impression that there are no document available to that effect at all. But in his evidence, my lord, the defendant number 2 produced this particular CDP plan showing that there is a road in our property. Only then I came to know that, my lord, there is a real problem with respect to that. Earlier to that itself, my lord, there is a reconveyance which has taken place.
Not at this stage. ಇಷ್ಟು ಲೇಟ್ ಆಗಿ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
What I am seeking for is only an elaboration of my contention, my lord.
No, where have you said in the plaint? ಆಯ್ತು, elaboration ಇದ್ರೆ okay, I'll accept. Where have you said in the plaint?
My lord, in page number 19, my lord. Page number 19, para number 5, my lord. The plaintiff submits that since the defendants did not pay the sale consideration amount in full, and as it was not agreed by the parties that the delivery of the possession of the suit scheduled property is only after the payment of entire sale consideration amount to the plaintiff continued to be in physical possession of the suit property even till today. The next, my lord, the defendants tried to take the possession of the suit scheduled property by playing fraud on the plaintiff by the year 2000, claiming the right under the sale deed dated so and so, but the plaintiff was not delivered the possession to the defendants. I have made a statement that the entire sale consideration was not paid to me. And this particular statement, what I have made the statement, my lord, I am elaborating it.
No, where have you said at least one kade elladru?
My lord, they have not paid the sale consideration.
You're virtually improving your case.
I am not, my lord, my submission is that, my lord, I am just elaborating my contention, elaborating my pleadings. I am not at all introducing a new fact, my lord. The essential fact is that, my lord, for this particular suit for cancellation of the sale deed is that, my lord, they have not paid the entire sale consideration. They have played the fraud on me. And on that count, my lord, I am seeking for the cancellation of the sale deed, my lord. And for that, my lord, what are the material facts I have stated? But I came to know why they have not executed is, the reason is the road problem, which I came to know the existence of road only, my lord, in the examination of DW3. Yes, my lord. I request my lords to kindly take the page number 34, my lord. In page number 34, my lord, the exhibit, it is marked as exhibit D21, my lord, in the evidence of defendant. Then, my lord,
Where is the defendant said that there's a road problem?
Yes, my lord. Yes, my lord. I will file the. Sorry.
Could you?
I request my lords to kindly take page number 13, my lord.
13.
Yes, my lord.
13.
13.
Idralla?
Yes, my lord.
Idralla? Sir, 13 ilvalla illi.
That is the deposition, my lord. Hope my lords has the deposition.
Yes, please.
Yes, my lord. The examination on 18/6/2018, my lord. This is examination in chief, my lord, because he was recalled. I will just read it, my lord. I have produced revised comprehensive development plan 2011 of BDA, and the same is marked as exhibit D21. The said plan was prepared on so and so, and it was in force till the year 2011. Then I request my lords to kindly take his further cross-examination at page number 15, my lord.
Yes.
Yes, my lord. Page number 15. On the date of purchasing the property itself in the sub-registrar office, immediately after registration of persons belonging to the defendant number 1 inform me that road is going to be formed in so and so. It is true that assigning this reason, I did not pay the sale consideration to the plaintiffs. Even the defendant number 1 did not pay the sale consideration to them. At the instance of defendant number 1, even after knowing that the road is going to be formed in that survey number, I did not inform it to the plaintiffs. At the time of executing the sale deed in respect of 6.5 guntas of land in favor of the plaintiffs, I got back rupees 2 lakh amount that was already paid by me to them. It is true that actual market value of the said property was considerably more than price shown in the sale deed. My lord, my submission is that, my lord.
You knew everything.
I was not aware, my lord. It is only defendant number 1 and 2 came to know about that. They were aware of it, my lord.
It's true.
It is true that
on the date of purchasing the property itself in the sub-registrar's office, immediately after registration, persons belong to defendant number 1 inform me.
Inform me means defendant number 2, my lord. It is the defendant number 1 and 2 jointly purchased the property from the plaintiffs, my lord.
Yes.
And then, my lord, defendant number 1 and 2 aware of it. I was not aware of it.
You raise this as a ground in appeal. Suit
it is a 2002 suit, my lord. My only submission, my lord, I may be permitted to explain. The sale deed was executed in the year 1998, my lord, by the plaintiffs in favor of defendant number 1 and 2. Both they purchased this property. They did not pay the entire sale consideration. And then, my lord, I filed a suit for cancellation. Then, my lord, defendant number 1 also contested, defendant number 2 also contested. The defendant number 2 was examined. He was cross-examined. In his cross-examination, he admits the fact that there is a road problem. For that reason, my lord, he received back the 2 lakh rupees from whatever the 2 lakh rupees was paid under the registered sale deed, that was received back by him. And he has already reconveyed 6.5 guntas of land, which is forming part of the suit schedule property. Then, my lord, further he explained, he said that he will provide the document. In principle, my lord, they were supposed to develop the property. They agreed to provide the documents. They did not provide the document at all. But that is the property, that is the road was the reason for not developing the property and also not paying the sale consideration to me. And for that reason, rightly, I have sought for the cancellation of the sale deed, my lord. And the defendant number 2 in his cross-examination, he admits that particular fact. My lord, I have to elaborate my case, which is the reason.
No, sorry.
My lord, I will persuade my lords with respect of one
okay.
observation made by the learned judge, my
Okay.
lord.
Sorry, Mr. The plaintiff in OS number so-and-so on the file of so-and-so has filed this petition challenging an order dated so-and-so by which an application filed with them under Order 6 Rule 17 was rejected. Next para. The suit in OS number 4129 of 2002 was filed from the following reliefs. Copy marked page number 21. The suit was contested by the defendants. Defendant number 1 and 2, no?
Defendant number 1 and 2, my lord.
Both of them have contested?
Yes, my
Defendant number 1 and 2.
Page number 24 and
Full stop. The defendant number 1 has sold it to D2 or?
no, my lord. The plaintiffs have sold it to defendant number 1 and 2, my lord. They have together, they have purchased it, my lord.
Yes. Next para. When the suit was set down for cross-examination DW3, the plaintiff filed an application under Order 6 Rule 17 to incorporate the following, page number 35 and 36. Full stop. This application was contested by the defendant.
Not contested.
Not contested.
Not contested.
The trial court, after considering the averments made in the plaint as well as the stage of the suit, held that the application filed under Order 6 Rule 17 was highly belated and was filed at the stage of closure of the trial. Full stop. It held that allowing the application would throw up further issues.
Page number 48, my lord.
Yes, I am reading that. Throw up further issues and result in a fresh trial. Full stop. Being agreed with the said order, the plaintiff is before this court in this petition. Next para. The learned counsel for the plaintiffs submitted that the amendment sought for was though belated, did not change the nature of the suit nor the cause of action, and no admission in favor of the defendants was sought to be withdrawn. He contends that no prejudice was also caused to the defendants if the application was allowed. Full stop. He contends that what is sought to be brought on record by way of an amendment, is a fact which was admitted by DW1,
DW3, my lord. That is defendant number 2.
Full stop. He therefore contends that the trial court must have considered the application leniently. Next para. I have considered submissions made by the learned counsel for the plaintiffs. Full stop. Next para. The suit was filed for declaration that a sale deed executed by the plaintiff in favor of the defendants 1 and 2 was without consideration and consequently cancellation kedilva.
My lord, word cancellation has not been used, but the court rightly it has considered it under section 31 of the Specific Relief Act as a suit for cancellation.
And to restrain the defendants from interfering with the plaintiff's peaceful possession and enjoyment of the suit's real property. Full stop. The plaintiffs have claimed that they had sold the suit property to the defendants in terms of sale deeds dated
16/5/1988.
Sorry,
my lord, 1998.
1998. They alleged that the defendants had not paid the full consideration. Though it was mentioned in the sale deed that a consideration of rupees 4,50,000 was paid instead of 7 lakhs. Full stop. They contended that despite demands made by the plaintiffs to pay the balance consideration, the defendants did not pay the consideration which compelled the plaintiffs to seek for the relief of declaration. Full stop. The defendants have denied the claim of the plaintiff in their written statement. Full stop. They have contended that the sale consideration that was agreed upon was a sum of rupees 4,50,000 and not rupees 7 lakhs as alleged. Full stop. Next paragraph. Based on these contentions, the suit was set down for trial. In the chief examination, the plaintiff did not mention anything about the defendants refusing to pay the full consideration on account of a road road problem. Full stop. This was not even the case suggested to the defendant number 1 or 2 in their cross-examination. Full stop. The defendant number DW3 during the course of cross-examination referred to some road problem. Full stop. The plaintiff taking cue from the said evidence adduced by the DW3 has filed the instant application to justify the reason for the defendants not paying the full consideration. Full stop. It is therefore clear that the plaintiff was also not aware at the time of filing of the suit that the defendants had, next paragraph, a perusal of the pleadings that is sought to be brought on record by way of amendment indicates that the plaintiffs were aware at the time of filing the suit that the defendants had refused to pay the full consideration in view of a road problem. No reasons are mentioned as to why the plaintiffs did not seek for an amendment at the earliest point in time. Full stop. Though the amendment does not change the nature of the suit or the cause of action, but the amendment, if allowed, would definitely result in reopening the case for adducing evidence and thereby protract the suit. In that view of the matter, since the plaintiffs have not exercised caution at the time of filing the suit, but have woken up at the time of cross-examination of DW3 to seek for an amendment, disentitles them for seeking the relief. Consequently, this writ petition lacks merit and the same is dismissed. However, it is open for the plaintiffs to raise this as a ground in any appeal that may be filed against any judgment that may be passed by the trial court.
Number 54, Venkatesh Somareddy.
Appearing for the Learned Counsel for the petitioner. My lord, the impugned order is rejection of the application for appointment of the Commission for Spot Inspection, my lords.
Suit is for what?
Suit is for bare injunction. Stating that there is a pathway, page 14, my lords, prayer in the plaint. Permanent prohibitory injunction restraining the defendants, their men, agents, servants, and so and so from blocking the roadway and putting up the compound wall at the eastern side leading to the plain shield property. And the plain shield property is mentioned, my lords. Contention is there is no such pathway, and now they want to construct a new compound wall. That is there is no such pathway is the allegation.
What does the defendant say about the pathway?
Pardon me?
What does the defendant say about the pathway?
My lord, the contention is they are now trying to create a new pathway. The pathway as mentioned herein is not there. That is their case, my lords. And that's projected in the spot inspection held that will show that it's there is no such pathway as alleged. And there is no such blocking as they say, my lords. And they say there is 8 feet pathway. One sketch is produced. Plaintiff's contention, my lords. The defense contention is there, so it's no such 8 feet pathway. It's only a smaller pathway is there, my lord. They want to widen it. Therefore, this is false suit is filed. And only injunction is filed. No such declaration is sought, my lords. Not even mandatory.
What stage this application was filed?
My lord, the initial application page 59, my lords, was filed during the stage of evidence of the plaintiff. The page 59. The learned trial judge held, my lords, that's premature. Let it be kept in abeyance. Page 99, your lords, may kindly see order of the learned trial judge, my lords. Evidence is not over. Let the evidence be over. After the conclusion, you can file this application, can be considered. Then after the conclusion, evidence was concluded. We were also, defendant was also examined, my lords. He contended that there is no such pathway, etc., my lords. Then it is dismissed on the ground, page 114, my lord. Reasoning is that would amount to fishing evidence and helping the party, defendant, to collect evidence. That is the reasoning, my lords.
Yes.
And defendants can prove their case by leading their own evidence, and court's assistance cannot be sought to collect evidence. So object of the local investigation is for the purpose of elucidating any matter, not to assist the party to collect evidence. This is the reasoning, my lord. In fact, this would elucidate the matter. SWOT inspection, what we are seeking is about the matter which is in existence. That can only be spoken by the expert or the court commissioner on spot visit.
Yes, suit is for injunction, my lords. I am for the plaintiff. I filed the suit. Suit is in the year of 2013. They filed application in the 2018.
Yeah, but this pathway runs through whose property? Defendant's property.
No, my lord, our property is adjacent to that. He now wants to create a pathway through my property. It's adjacent property, my lords.
You are for the plaintiff or defendant?
Defendants, my lord.
Yes, for the
Defendants. Defendants filed, my lord.
I am for the
Defendants are
plaintiff.
opposing the plaintiff's prayer, my lord. On the ground that there is no such pathway at that place, they want to widen it. And my lord, they want to create a new pathway. That's our case, my lords. And by they obtained ex parte injunction initially by way of producing some sketch.
Correct, Mr. How is the suit maintainable?
Suit is filed by them, my lords.
Correct.
Please.
How is the suit maintainable?
No, my lord, now what the trial court has granted an injunction initially, my lord.
So how is the suit maintainable for injunction?
Injunction, the prayer, may pray, my lords. The injunction
is asking for an easementary right over your property.
They say, my lord, there is already, that road is already there at the time of purchasing, because they say they have purchased from my ancestors. They say it's already there. That road is already there. So they're seeking permanent injunction.
Already there and then.
They say the contention in the plaintiff, my lord, that there is a 8 feet approach road, which is denied by us. We say that.
So you say that you have planted coconut trees. So it means to say that they're claiming over your land.
Yes.
Then?
No, my lord, what they
prescriptive right, alva.
How though?
Assuming that he's got a prescriptive right, without seeking for a declaration, how is the
suit is not maintainable, my lord. My lord,
then
now
why do you want to keep this petition pending?
No, my lord, for this reason, my lord. Now, my lord, they produced one sketch, a rough eye sketch, my lords, showing that there is already a pathway. It's a rough eye sketch prepared, my lords, and based on that, injunction is sought. Now, my lord, there is already a injunction sought during the
plaint copy.
Please, my lord, I have the plaint copy. You have produced it, my lord. May I beg to take the honorable court to
page number 11.
11 onwards. My
what does he say about
11?
That's para 4, my lords, page number 12.
Please, my lord. Plaintiff submits that the para 4, my lords. Scheduled property originally belonged to Albert D'Souza, who is the father of the defendant, number 1. Husband defendant, number 2. Plaintiff submits that the said Albert D'Souza had sold the scheduled property to Mr. Muhammad Sharif, son of so and so, and registered sale deed dated dash. Registered as document number dash, volume number dash, executed before so and so for a valid consideration together with so and so, together with the right to use and enjoyment of 8 feet approach road. This is contention, my lords, to the plain scheduled property for ingress and egress. Then, my lord, he says that para itself, my lord, after 2 lines, plaintiff submits that the said sale deed eastern boundary is shown as roadway and the schedule of the said sale deed and annexed sketch, a specific averment had been made with regard to the transfer of the right by way of way. Notarized copy of the sale deed is produced, stamped, and the same may be read, etc., my lords. Then para 7, plaintiff submits that the plaintiff has been in actual possession and enjoyment of the plain scheduled property. Things being so, defendants who are holding the property adjacent to the plain scheduled property now attempted to block the roadway leading to the plain scheduled property with the ulterior motive, attempting to put up and construct the compound wall to block the said pathway.
No. He says.
Please, my lord.
The property was sold for valid consideration together with right to use and enjoyment of 8 feet.
8 feet.
Approach road.
It's not there, my lords.
Then
That's
if it's not there, then why?
No, my lords, now my lords, since there is no such relief of declaration sought, only injunction is sought, my lords. Now I have also stepped into the witness box, my lords. It will elucidate the matter. In fact, my lords,
Not
what is there in the spot, my
Not
lords?
necessary.
Otherwise, my lords, my lord, he contention is I am already in existing, enjoying the road. There is a road, my lords. Now, my lord, if that, whatever that is in the spot, your lords may kindly see. Our contention is, my lords, there is already his property is covered by compound wall. He says, I am going to construct a compound wall. There is already a compound wall, my lords. Your lordship may kindly also take judicial notice, my lord,
Not
many
of
times.
that. If the suit itself is not maintainable.
No, my lord, he
Because
says,
Because he's seeking for an easementary right over your property.
my lord, he doesn't say, he claims plain shell property is his property, my lords.
Oh, the plain shell property is his property.
Please, my lords.
But the dari is on your property.
He says, my lords, prayer is on any other person claiming through or under him, blocking the roadway, putting up the compound wall on the eastern side leading to scheduled property.
Road ತಾನೆ.
Eastern side on
But
the
you
road.
should have a prescriptive right, even if it's a road.
Please.
Unless it's a public road.
Please,
If it's a road on your property,
please. He says that property is sold to him, it is contention, my lords.
prescriptive right ಬರ್ಬೇಕಲ್ರಿ.
How, Swami, how?
Declaration ಬಡವಾ.
ಬೇಕು ಸ್ವಾಮಿ ಆದ್ರೆ now my lords, we don't want to take a risk, my lord. The situation is this, my lord. Once if an injunction order is for any reason is granted, they will break open and create a road stating that there's already an injunction. This is what's happening, my lords, because there is already an injunction granted. That's for my lord. Kindly also appreciate the contentions urged by us in the return statement. In the contentions, my lords. Now, my lord, page 18, my lords, line number into, it is false that in the said cell, the eastern boundary is shown as roadway, and in that, in the schedule so and so. Then, my lord, kindly permit me to read para 7. In fact, there is no pathway to the plain scheduled property in the northern side. There is a 4 feet pathway to the scheduled property in the eastern side, which is given to the plaintiff at the time of sale deed. 4 feet, my lords. The sketch annexed to the plaintiff is false. There is no pathway of 8 feet to the plain scheduled property in any side. Defendants have planted coconut trees which have been existing.
So
since
you also admit there's a 4 feet path.
4 feet. Now he wants to extend to 8 feet, stating that there is an 8 feet, my lords. Now this existence, my lord, whatever that is 4 feet is existence, my lord, that can be seen from the spot inspection only, my lords. Otherwise it will lead to, my lord.
Lords, the contention raised by the defendants, my lords, saying that there is no pathway, roadway. Now, if you lords is to read just now the plaint averments here, the 8 feet road which has been, we have annexed it with a sketch. 8 feet road ಇದೆ. We have given the sketch of the roadway. Subsequent to that, now the defendants, they are blocking the roadway. We are not blocking. They are they are blocking the roadway and path and trying to build a compound. No, that my lord, subsequent.
Whether it's a 8 feet or a 4 feet pathway, how can you ascertain it? Is there any document?
We have produced sketch, my lords.
That is your hand sketch, mister. Is there any official document from any official record which says that this is not 4 feet, it is 8 feet and ella sigtada?
This is the property, the shoot shredder property is purchased by the plaintiff by one of the ancestor of the defendants. It's under the register sale deed.
I hope you understand what I am asking.
Yes, great.
Is there any document which shows that the pathway is 8 feet and not 4 feet?
Except this sketch, my lords, there is no other documents.
So how does the court come to the conclusion?
Subsequent to that, even we have filed an application under order 26 rule 9, which came to be dismissed by the trial court, my lords.
Really?
On, my lords, if you lords take page number 129. They have filed in the year 2018.
Is that a fact, mister?
Now, my lord, I feel my
They have filed in the year 2018. We have filed in the
there is
2019.
something, my lord, what my learned friend has read is page 129 is typed copy of order sheet dated 10/4/2019, my lord.
10/4/19.
There is wrongly typed as plaintiff has filed, my lords. That's why I drew my lord's kind attention to the original order sheet. That's page 99.
Where is your application, mister?
No, lords.
Now, but this fact plaintiff filed, my lords, page 99 is correct, my lords. Plaintiff also filed. page 99, my lords. Lord McKinley, page 99.
Then I-
99, my lord.
What happened to that?
That's kept in abeyance, my lord, till
That-
evidence is over.
That
Now
application was
defendant,
kept in abeyance.
then the defendant says, let it be considered, my
The
lord.
application filed before the completion of the trial is premature.
And the defendant files an application, my lords. Now, so both of them want commissioner now.
Both of you want commissioner.
Yes.
Let it be appointed. Barkul. The plaintiff in voice, sorry, the defendants in voice number so and so on the file of so and so have filed this petition challenging an order dated so and so by which an application filed with them under order 26 rule 9 of CPC was rejected. Next paragraph. The suit in voice number 355 of 2013 was filed for perpetual injunction to restrain the defendants from blocking a roadway and from putting up any compound wall on the eastern side leading to the plain scheduled property. Full stop. It was the claim of the plaintiffs that the father of the defendant number 1 and husband of defendant number 2 had sold the suit property to, who is this Muhammad the
Plaintiff,
Sharif?
the husband.
Husband already.
Oh, Muhammad Sharif, so and so. Mr. Muhammad Sharif.
Also Andre?
Earlier it
To
was sold to
Muhammad Sharif
Sharif.
on 7/4/2001. Full stop. Along with the property sold, he was also given the right to use and enjoy 8 feet approach road to the property. Full stop. The plaintiff alleged that the plaintiff claimed that Muhammad Sharif got the land converted for non-agricultural purposes on 23/9/2009 and thereafter sold it to Mr. Abdul Bashir, the vendor of the plaintiff, in terms of a sale deed dated 3/11/2009. Full stop. The plaintiff contends that the defendant attempted to block the road, the roadway, 8 feet roadway. And therefore, the plaintiff was advised to file a suit for perpetual injunction for the reliefs mentioned above. The defendant number 1 and 2 contested the suit and claimed that there was no pathway to the plain scheduled property on the northern side. They contended that a 4 feet pathway connected the plain scheduled property on the eastern side. And the same was given away at the time of the sale deed, at the time of executing the sale deed in favor of the plaintiff. Full stop. The defendants denied that there was no pathway of 8 feet. Full stop. Based on these contentions, the suit was set down for trial. During the course of trial, an application was filed by the defendants for appointment of a commissioner to identify whether the pathway on the eastern side of the property of the plaintiff was 4 feet and whether there was any pathway on the northern side of the property. Stop. The said application was kept pending by the trial court. Full stop. After the evidence was concluded, the trial court considered the application in terms of the order dated 24/10/2019 and rejected it on the ground that the defendant is bound to prove the contention that the pathway was not 4 feet, was not 8 feet, but 4 feet. Full stop. It was held that in a suit for perpetual injunction, the burden to prove the issues is upon the plaintiff. and a commissioner cannot be appointed for collection of evidence to help the parties to prove their case. So being agreed by the said order, the defendants are before this court in this writ petition. The learned senior counsel for the defendants submitted that the pathway in existence is only 4 feet, and the same is sought to be widened to 8 feet by the plaintiff. He contends that the plaintiff has produced a rough hand sketch where the pathway is shown to be 8 feet, though there is no official document to establish the said fact. He contends that in order to elucidate the issue in controversy and also to get a fact check, it is imminent that the court exercised its power under Order 26 Rule 9 to appoint a commissioner. Full stop. Per contra, the learned counsel for the plaintiff contended that the suit is filed for perpetual injunction and therefore there is no need to appoint a court commissioner. Full stop. He contends that appointing a commissioner would amount to collection of evidence and therefore the trial court was right in rejecting the application. Next para. I have considered the learned counsel submissions of the learned senior counsel for the defendants and the counsel for the plaintiff. I have also perused the impugned order. Next para. The dispute circles around the question whether the passage claimed by the plaintiff is a 8 feet roadway or a 4 feet passage. Full stop. Admittedly, there are no documents to establish the claim of the plaintiff or the defendant. Full stop. The plaintiff claims that the passage existed over the property of the defendant. Full stop. Therefore, without getting a clear idea as to the ground, what exists on the ground, the court will not be in a position to decide the suit effectively. Full stop. Appointing a court commissioner in the facts of this case would not amount to collection of evidence, but would be appraising the court about the ground realities. This would help the court in appreciating the evidence on record and arriving at a right decision in the suit. In that view of the matter, the impugned order passed by the trial court warrants interference. Hence, the writ petition is allowed, the impugned order is set aside. The application filed by the plaintiffs and Order 26 defendants and Order 26 Rule 9 of CPC is allowed. Yes.
Great.
Password. Yavadu.
Serial number 22, passed over matter.
22.
Vijay Kumar. Serial number 22, passed over matter, list number 1, K. Vijay Kumar.
Huh? No. When do you want it?
My lord, like a short date, my lord. Senior counsel will engage.
Take whichever date.
My lord, it's a humble request to extend an interim order, my lord.
And with your lordship's kind leave.
My lord.
My lord, with your lordship's kind leave, my lord.
List number 2, serial number 12, my lord. There is a small error, typological error in grounds of the interim prayer. If I may be permitted, I will make the correction.
After notice, anyway, notice.
My lord, the crop name is wrongly mentioned. Notice crop name is wrongly mentioned in the grounds of interim prayer. Coffee and that, but I had to.
ಆಮೇಲೆ ಮಾಡಿ ಇನ್ ಮುಂದೆ ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ದಯವಿಟ್ಟು ನನ್ನ ಕೋರ್ಟಲ್ಲಂತೂ ಮೂವ್ ಮಾಡಿ ವಿಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಲ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ಸ್. ಪ್ರತಿದಿನ ಹೇಳ್ತೀನಪ್ಪ, ಅದ್ ಏನು ನೀವು ಕೇಳೋದಿಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಯಾರ ಕೇಳ್ಬೇಕು. ನೀವೇನು ನೆನ್ನೆ ಮೊನ್ನೆ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿರೋದು. ಪ್ರತಿದಿನ ಹೇಳ್ತೀನಿ, ಡೋಂಟ್ ಮೆನ್ಷನ್ ಫಾರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಇಂಟ್ರಿ ಆರ್ಡರ್, ಆಲ್ ಇಂಟ್ರಿ ಆರ್ಡರ್ಸ್ ವಿಲ್ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
My lords are mentioning for a date, my lords.
In
serial number 16, list 2, my lords, may I request for a date, my lords?
Date is given on Wednesday, I think.
Very well. My lords, this is another matter, my lords. This is
which number?
the group list 2. Serial number 16, my lords.
List number 2 now.
Please, my lords. My
Take
lords, it's a
whichever
short,
date you want.
my lords,
Take
it's a
whichever
short
date you
matter
want.
which your lordships.
Take whichever date you want, madam.
Very well, my lord.
Serial number 62, short portion is involved only.
ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ರಿ. ಯಾವತ್ ಬೇಕೋ ಅವ್ರು ನೋಡ್ತಾರೆ, ನೋಡ್ ಕೊಡ್ತಾರೆ.
Submission, my lord.
ಮಂಡೇ ಹಾಕ್ಬೇಡಿ, ಮಂಡೇ ಜಾಸ್ತಿ ಕೇಸ್ ಇದೆ.
So, court officer? So, 14th ಕೊಡ್ತೀರಾ list to serial number 16.
Sir, date export. Madam, if you want 14, madam.
Ha, yes, sir. List to serial number 16.
Oh, okay, madam. Okay, madam.
Okay, thank you, sir.
Sir, serial number 22. Sir, serial number 22, sir. Tuesday, sir.
Yeah, date was sir. Everything, sir. Serial number 55. Sir, any date, 25th or 26th? Sorry, sir. ಯಾವ date? 25th, sir. 56.
Sir, next day, sir.
27th.
ಅಲ್ಲಲ್ಲ ಸರ್ ನಾನು ನೆಕ್ಸ್ಟ್
ಬೋರ್ಡ್ ಫುಲ್ ಇದೆ, ಇಲ್ಲೇ ನೋಡಿ.
ಇಲ್ಲ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 19th ಗೆ
ನೀವು ಅವತ್ತು ಒಪ್ಪಿಗೆ ಹೇಳಿದ್ದು, ಇವಾಗ ಸಾಹೇಬ್ರಿಗೆ ನಾವು ಬೋರ್ಡ್ ನೋಟ್ ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ನಾವು ಬೋರ್ಡ್ ನೋಟ್ ಕೊಡೋದು.
ಅಲ್ಲಲ್ಲ
13th ಬರಲ್ಲ, ಹಿಂಗೆ ಆಗುತ್ತೆ. BC ಕನೆಕ್ಷನ್ ಇದೆ.
ಅಲ್ಲ 13th ಇಲ್ಲ 14th ಹಾಕಿ ಅಲ್ಲಿ 19th ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಅದಕ್ಕೋಸ್ಕರ ಆರ್ಗ್ಯುಮೆಂಟ್
15th ನೋಡಿ, 15th.
ಇಲ್ಲ ಹಂಗೆ
7 ಸರ್. ಚಂದ್ರಶೇಖರ್ BK ಸರ್, ಏನಾದ್ರು ಸಬ್ಮಿಷನ್ ಇದೆಯಾ ಸರ್? ಆಫ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಯಾವ ಮ್ಯಾಟ್ರು?
ಸೀರಿಯಲ್
ನಮ್ದು 69ನೇ ಮ್ಯಾಟ್ರು ಮೇಡಮ್.
69 ಯಾವತ್ತು ಬೇಕು ಸರ್?
ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಯಾವ ತರ ಹಾಕಿ, ಸೋಮವಾರ ಬಿಟ್ಟು.
ಸರಿ ಸರ್, 20ಕ್ಕಂತೆ ಸರ್, 20/11
ಆಗ್ಬೋದು.
ಓಕೆ ಸರ್.
21 ಆಗುತ್ತಾ? 21 21
ಸರ್ 21 ಆಗೋಗಿದೆ ಸರ್.
21 ಆಗೋಯ್ತು.
22 ಇವಾಗ ಆಗೋಯ್ತು ಸರ್.
ಹೌದಾ? 20 ಬಿಟ್ಟು ಒಂದು ಮುಂದಿನ ಡೇಟ್ ಯಾವ್ದಾದ್ರು ಕೊಟ್ರೆ ಉತ್ತಮ
ಸರ್. 22 ಡೇಟ್ ನಿಮ್ಗೆ ಬೇಕಾ ಸರ್?
ನೀವು ಕೊಟ್ರೆ ಕೊಡ್ಬೋದು, ನಾನೇನು ಇದಿಲ್ಲ.
ಮೈಕಲ್ಲಿ
ಆಗೋದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತೀನಿ.
20 ಹಾಕೈದ ಅಲ್ಲೇ ಹಾಕೈತಲ್ಲ, ಮಾತಾಡಿ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 22 ನೀವಾ ಸರ್?
ಅಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ 69 ನಾನು.
ಸರ್ 69 ಆಗೋಯ್ತು ಸರ್.
ಅದೇ ಹೇಳಿದ ಅಷ್ಟೇ.
20 28th ನವೆಂಬರ್
ಆಗ್ಬೋದು.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಪ್ರಕಾರ ಸರ್ 22 11 14 11 ಹಾಕೊಳ್ಳಿ. ಸರ್ 57 ಆಗುತ್ತೆ. 57 ಸೀರಿಯಲ್ ನಂಬರ್ 57.
ಸರ್ ಕೊಟ್ಟಾಗ ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 58. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ ಸರ್, ಫುಲ್ ಆಗಿದೆ ಬೋರ್ಡ್. ಫುಲ್ ಆಗಿದೆ
ಸರ್.
ಜಾಸ್ತಿ ಆಗುತ್ತೆ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 56 14th ಆಗ್ಬೋದಾ ಸರ್?
59 ಸ್ಪೀಕರ್ ಫುಲ್ ಬೋರ್ಡ್ ಫುಲ್ ಇದೆ ಸರ್. ನೆಕ್ಸ್ಟ್ ವೀಕೆಂಡ್ ಬೋರ್ಡ್ ಫುಲ್ ಇದೆ. 20 21 ಇಲ್ಲ ತಪ್ಪಿದ್ರೆ 22. ಅಂತೆ ಸರ್. ಆಯ್ತು 25 ಕೊಡ್ತೀನಿ.
65 ಯಾವತ್ತು ಹೋಗಿದೆ? 65 65 65
ಸೀರಿಯಲ್ ನಂಬರ್ 60 ಪಟಿಷನರ್. ಸರಿ ಸರ್. 61 ಯಾವ ಹನ್ನೊಂದು ಮೇಡಮ್? ಸಾಹೇಬ್ರು ಹೇಳೋದ್ರಲ್ಲ ಮೇಡಮ್, ಮಂಡೆಗೆ ಯಾವ್ದು ಕೊಡ್ಬೇಡಿ ಅಂತ. ರೀಚ್ ಆಗಲ್ಲ. 62 ಸರ್. ಇಲ್ಲ ಸರ್, ಈ ಮಂಗಳವಾರ ಬುಧವಾರ ಫುಲ್ ಇದೆ. ಇಲ್ಲೇ ಇದೆ ನೋಡಿ ನಮ್ ತರ. 15th ಯಾರು ಹೇಳಿದ್ದು ಸರ್? 63 57 ಆಗೋಯ್ತು ಸರ್. 26/11
64. 65.
65 the respondent का appear ಆಗ್ತಾ ಇದೆ. I am appearing for the respondent.
ಇಲ್ಲ ಸರ್ ಬೋರ್ಡ್ ಫುಲ್ ಇದೆ. 66.
65 ಯಾವತ್ತು?
ಟ್ಯೂಸ್ಡೇ ಇಲ್ಲ ಸರ್ ಫುಲ್ ಇದೆ.
ಅಲ್ಲ 65 ಯಾವತ್ತಾಯ್ತು?
ಏನ್ ಹೇಳೋದು? ಅದೇ ಹಿಂಗೆ ಅದಕ್ಕೆ ಡೇಟ್ ಕೊಡ್ ನೋಡ್ಬಿಟ್ಟು ಇದನ್ನ ನೋಡಿ ಕೊಡ್ತಾ ಇದೀನಿ ಅಂದ್ರೆ ಅವತ್ತು ಅಟ್ಲೀಸ್ಟ್ ರೀಚ್ ಆಗ್ಲಿ ಅಂತ.
65 ಯಾವತ್ತು ಹೋಯ್ತು? ಹಲೋ 65 ಯಾವತ್ತು ಹೋಯ್ತು?
ನನ್ನೇನಿಲ್ಲ ನೀವು ಕೇಳಿದ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಷ್ಟೇ.
65 ಯಾವತ್ತು ಹೋಯ್ತು?
ಹೇಳಿ ಸರ್ ಅವ್ರು ಮಾತಾಡಿ ಸರ್ ಹೇಳಿ
ಸರ್ ಕರೀತಾ ಇದ್ದಾರೆ.
65 ಯಾವತ್ತು ಹೋಯ್ತು?
65 ಬಂದಿದೆ ಇವಾಗ.
68.
ಸರ್ 67
ಹೇಳಿದ್ರಲ್ಲ ಸರ್ ಅವರು 20th ಅಂತ ಹೇಳಿದ್ರು. ನಾನು ಹೇಳದ್ಮೇಲೆ ಕೊಟ್ಬಿಡ್ತೀವಿ.
2 weeks ಅಲ್ಲಿ 67 20th 2 weeks
ಹಂಗ ಡೇಟ್ ಕೊಡ್ಬೇಕು.
ಯಾವ ಡೇಟ್ ಕೊಡ್ತೀವಿ?
ಅಲ್ಲ ಸಾರಿ 65 ಏನಾಯ್ತು?
69 ಹೇಳಿ ಸರ್. 70 ಹೇಳಿ.
65 ಯಾವತ್ತು ಹೋಯ್ತು? ಹಲೋ ಪ್ಲೀಸ್ ಟೆಲ್ ಮಿ. 65
ಸರ್ 65 12/11 ಟ್ಯೂಸ್ಡೇಗಂತೆ
ಆಗ್ಬೋದು.
68 28 11 ಅಲ್ಲ ಸರ್?